ವಿಶ್ವೇಶ್ ಸರ್, DP ಚೇಂಜ್ ಮಾಡಿ ಸರ್. ವಿಶ್ವೇಶ್ ಸರ್, ನೀವು DP ಚೇಂಜ್ ಮಾಡಿ ಸರ್. ಸರ್ ನಿಮ್ಮ ಜೂಮ್ದು DP ಚೇಂಜ್ ಮಾಡಿ ಸರ್. ವಿಶ್ವೇಶ್ ಸರ್, ಪ್ರೊಫೈಲ್ ನೀವು ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಸರ್, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
ಝೂಮ್ DP ಚೇಂಜ್ ಮಾಡ್ಬೇಕಾ ಸರ್?
ಹಾಂ, ಪ್ರೊಫೈಲ್ ಫೋಟೋ ಚೇಂಜ್ ಮಾಡಿ. ಈಗ ನೀವು ಹಾಕೊಂಡಿದ್ದೀರಾ ಇದೇ ಫೋಟೋ ಯಾರಿಗಾದ್ರೂ ಕೇಳಿ ಸರ್. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
ನಾ ಇದೇ ಫೋಟೋ ಹಾಕ್ತೀನಿ ಸರ್, ಬಿಡಿ.
ಇದೇ ಹಾಕಿ ಸರ್, ಅದು ಬೇರೆ ಚೇಂಜ್ ಇದೆ.
ಆಯ್ತು.
ಓಕೆ ಓಕೆ,
ಥ್ಯಾಂಕ್ ಯು.
ಎಲ್ಲ ಮಿಕ್ಸ್ ಆಗ್ಬಿಡ್ತೈತಿ, ಎಲ್ಲ ಮಿಕ್ಸ್ ಮಾಡ್ಬಿಡೋಣ್ರಿ ಅವತ್ತು. ಕಂಟಿನ್ಯೂ ಅದಾವ್ರಿಪ್ಪ.
ಅದನ್ನ ಸ್ವಿಚ್ ಆಫ್ ಮಾಡಿ.
One writ petition end up. One writ petition, my lord, end of the list. And district work officer has declined to grant permission to held my lord Urus. It is on 24th onwards, my lord. Yes. Madam, number. Madam, number.
Running a banking society, my lord. They have submitted the list of eligible voters, but my lord, the two of the my lord, old members who have my lord, retired from the society.
Tomorrow 2:30.
Tomorrow, ma'am. The number bidilla summa.
Yes, madam.
Adjournment, preliminary reading, serial number 16 to 19. Number 20 to 25.
Lord, serial number 20, I want to file an objection.
Serial number
20. I'm appearing for respondent, want to file an objection.
20 na?
20.
ಅದು ಇದಕ್ಕಲ್ಲ ಆರ್ಡರ್ಸ್ ಅಲ್ವಾ? For the respondent number.
Respondent
Three
number
and four.
3 and
6 time, list on. Please intimate the other side.
Please, I'll inform.
29. Number. Serial number 26 to 34. Number 36 to 40.
38, my lords. Notes for respondent.
38.
38, R1 to R4.
Ah.
It's a week's accommodation.
The Tahsildar to appear before the court ಅಂತಿದೆ.
Tahsildar has already filed a report. So he's,
Section of employment of Anganwadi.
The report, the honorable court had directed to submit a report as to the residence of the.
Wait, let us see what is the report. Next.
Number 41 to 44.
That's serial number 44, my lords. I am for the respondent. That's short accommodation, my lords. I informed the other side, my lords, petitioner counsel. 43. 44.
Learn counsel for the respondent one seeks time. Respond.
My lord, 43, my lord. 43, my lord.
Birthday.
Yes.
Number 43.
43.
43.
Yes, my lord.
43, yes.
That is objection I have to file that on behalf of my learned colleague Uday Honaguntikar.
The
1 week
marriage-
time, 1 week time, I believe. Objection has to be
Learn
filed.
counsel for the respondent. ಯಾರಿಗೆ ನೀವು
Respondent, Uday Honaguntikar.
ಉದಯ್
Yes, on behalf of him.
Learn counsel for the respondent one seeks time. List on.
29-1.
Yeah, the purpose is ಸರ್ವಾಗಲ್ಲ. It's
You know, 1 week
appointment on compassionate grounds.
that he has conveyed something, he is not available, my lord, but it is 1 week time.
No, but the purpose will not be served. You keep the petition for appointment on compassionate grounds pending for the last 3 years.
That I will
Purpose
convey,
will not serve.
I will convey this something, at least Saturday, my.
Saturday ಎಲ್ಲ ಕೊಡಕ್ಕಾಗಲ್ಲ. Yes,
Good.
learn counsel for the
1 week.
respondent one seeks time. List on.
29-1. Number 45 to 47. Number 48 to 49. Number 50 to 54. Number 55. Number 56 to 57. Number 58 to 60. Number 60 to 65.
My lord, 65, I have to file objection, 2 weeks time maybe,
And AGA seeks time. List on.
2 weeks after,
2 weeks.
yes,
Number 66 to 68. Number 69 to 73.
69, same Uday Honaguntikar.
69, learn counsel for the
2
respondent
week.
number 1 and 2 seeks time. List on.
52.
2 weeks, 69.
The 5.
Okay.
Number 74 to 76. Number 77 to 81.
Lord, serial number 78, my lord. I am for the
78.
respondents in this matter, my lord. Kindly have this matter next
Counsel
Monday.
for
my
the
lord.
respondent seeks time. List on.
29.
Much.
Number 82 to 85.
My lord, 83, 84, 85, it is 2 weeks time, please be given. Because I. 83, 84, 85.
83, 84.
My lord, these are matter connected with serial number 4, my lord.
Yes.
And these are matters are covered, my lord, because of interim order, my lord, the persons who are appointed by the KPC, my lord, appointment orders have not been issued. They are, my lord, the,
Should I adjourn it or should I not?
no, my lord, because it may be
Yes.
2 weeks.
serial number,
Because
86 to 88.
some I have to get the covered judgment copy I have to get, my lord.
He will give you a copy of the judgment.
yes, my lord, similar orders.
86 to 88. Correct.
Out of matter serial number 1, Nitesh Padia.
I appear for the petitioner.
Yes, pass over.
Amendment.
I'll take it up. I'll take it up for disposal. Yes. Chakshetty.
Serial number 2, Gigi Chakshetty.
It may be dismissal, man.
The learned counsel for the petitioner submits the writ petition. Learned counsel for the petitioner, Mr. I.R. Biradar. Yes. Submits that the petition may be dismissed. In view of the aforesaid submission, the petition is dismissed. Yes.
Serial number 3, Nitesh Padia.
Sir, offering for the petition.
Filed by the petitioner to delete prayer number 2. In view of the memo, relief at prayer number 2 is deleted. Counsel for the petitioner is directed to make appropriate entries in the writ petition indicating the deletion of prayer number 2. Yes.
Serial number 4.
Kindly interim order may be extended.
Interim order granted unless extended to the next date. Serial number 3 null.
Liaquat Farid Ulsaf.
4.
City. Serial number 4.
For the petition.
Liaquat Farid Ulsaf.
1 week time is granted. to-
My lord, serial number 4,
Ah.
4.4, my lord, is connected with serial number 83, 84, 85, just now mentioned, my lord.
What should we do? Should I take it up? If it is covered by decision.
Covered, my lord, because they sought for regularization and interim order has been granted. Where, my lord, this honorable court passed an order, my lord, to continue their service, my lord, till fresh appointment is,
Yes.
My lord, this is our people with that 83, 84, 85 and 4. Since 10 years, they have been serving on the content visa and all benefits of the government, permanent employees benefits they are taking. We are not in the objection of not to take them, but only my request is not to remove from the job because we have worked continuously without any interruption. We have worked 10 years.
No, that is okay, but then you're not entitled for regularization.
With the honorable this court also given the judgment.
Four matter university.
Huh?
4.4. And even in their appointment also, my lord, appointment order also, the condition is prescribed.
No, that is right. See, if you have come in a particular manner and if you are bound to go out in a particular manner, you have to go out. See, if you are a backdoor entry, you have to go outside the back door only.
Already 10 years we have worked, my lord.
It doesn't matter. See, the conditions of service are such that it was always understood to be temporary.
And without
Where's the
any-
question of-
without even the break of 1 day also we have worked. And
There
at
is
that time also no, this thing, even broken services are also is not there. And there is this honorable court also on the same post on the of other officers. This honorable court has given recently a judgment.
Would you please pass on a copy to the other side? Let them also go
I'm
through.
implemented application filed my lord, but I'm implemented application filed my lord, but not put up.
Impediment.
ಹೌದು ಇದರಲ್ಲಿ
What
procedural
impli-
ಒಂದಲ್ಲಿ.
Who are you?
Purpose respondent my lord.
Huh?
ನಾನು ಪೋಸ್ಟಿಂಗ್ ಅವ್ರು ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ. ನನಗೆ joining
Select,
order ಕೊಟ್ಟಿದ್ದಾರೆ.
selected
ನಾನು
candidate from the KPSC because of
Actually, which is, in which writ petition?
4.4.
4.4 my lord.
4 point?
401.
203401.
ಯಾವ್ದು IA number?
11 my lord.
1 of 25.
ಹೌದು. ನಾನು ಹಾಕಿದ್ರೆ ಪುಟಪೇ ಆಗಿಲ್ಲ ಅದು.
Any objection for this impleading application?
Yes, sir, we have made the party already, KPSC we have made the party, but this selected candidates is, for that I object. And let them post.
So
other
filed some
places.
application, you not even given the particulars of the person who was to be impleaded. Where have you mentioned who has to be impleaded, mister?
ಇಲ್ಲ ನಾವು 401 ಅಲ್ಲಿ. Petition mention selected candidate mention.
Where are the particulars of the person to be impleaded? You have to implead Satish Kumar D. Gadkar.
Mahesh.
Where is it mentioned?
I'm a filed ಮಾಡೋ affidavit.
ಅದರಲ್ಲಿ ಬರೆದು
What type of applications you file, mister?
ಬರಿಬೇಕದು ಅವರು ಯಾರಂತ ಅನ್ನೋದು ಬರಿಬೇಕು.
Who has to be impleaded? You're not even given the particulars of the person to be impleaded.
Afford my lord correction.
ಏನ್ dispose ಮಾಡ್ಬೋದಾ ಏನ್ ಹೇಳಿ? All of you decide will consider it.
I have no objection of posting me somewhere else or posting those persons in some, because it is OCN, but I work 10 years.
Then your lordship, interim order may be modified, my lord,
ಕೊಡ್ರಿ, serial number 4 ಕೊಡಿ. Serial number 4. Who appears for serial number 4?
My lord, I am appearing for
Yes, what is it?
20, ಇದರಲ್ಲಿ objection, I have already served the copy to the Ghate, my lord, he is appearing.
Okay, mister, what are the facts of the case?
My lord, fact of the case is that, my lord, the petitioners herein who have been appointed as
You have been appointed as what?
non-teaching staff, my lord.
Appointed as non-teaching staff.
Huh.
So they're not giving you posting.
No, not removed. They have issued a circular stating that now the service will be 179 days. You have been appointed in the year 2009. Till today, we are in continuous service, my lord. In similar circumstances, this honorable court has ordered, and that order was not complied. They have filed contempt petition. In contempt petition was dropped. That in that contempt petition, Supreme Court, Honorable Supreme Court has directed, as per Uma Devi, since they have worked more than 10 years, therefore they are entitled for the regularization. So we are also standing on similar footings. That order is produced at annexure in page 48.
Serial number 4 ನಲ್ಲಿ, I request my lord university,
Yes,
we have filed
yes,
a
Mr.
memo.
Liaquat,
Please. In page 48 is the order, my lord.
48.
48. Para number 4, my lord, the matter arises out of regularization of the employees. The Chief Commissioner of Income Tax in this report dated so and so found that in exercise concerned in pursuance of the judgment of this court in the case of Secretary of State and Umadevi, through 65 employees were found to be entitled for regularization, only 35 employees were regularized. This was done since only 35 vacancies were available. 16 persons out of the remaining 30 employees filed contempt petitions alleging that the respondent departments are not regularizing the services of the appellants, thereby committing contempt of court. It appears that before the Honorable High Court, an affidavit was filed stating therein that the services of the appellants could not be regularized since the posts were not available. On this statement, the contempt petition has been filed. The Constitution bench judgment of this court passes in Uma Devi. Though the court has held that backdoor entries should not be permitted, it has permitted a one-time measure to be conducted for regularization of services for these employees who had completed a service of more than 10 years. They have completed the services of more than 10 years. Indisputably, the appellants herein have completed services of more than 10 years. Even this court, in the case of Ravi Verma versus and others versus Union of India, decided on 13/3/2019, found that the act of regularization the services of some employees and not regularizing the services of the other is discriminatory and violative of article. These persons are also belonging
But where
to
is the continuation of this order? Paragraph number 9.
With kind permission.
Please wait.
Lord, that is
Where is the continuation of this order?
it is missing. Missing, my lord, I will say. I will produce it, my lord. My
But
lord.
why don't you see
By-
the file, Mr.
My lord, I seek apology for this, my lord. By oversight, I will.
What oversight?
Like, this is,
Without even seeing the document, you produced it.
Lord, I will produce it, my lord. I seek apology for this. My lord. So the gist of this order is, my lord. So we have completed.
No, but why this 179 days?
They have, now they want to convert it, my lord. Now they issued an order in 2024 stating that after the regularization of some of the persons, my lord, by Supreme Court, Honorable Supreme Court, they have come with this order, my lord, to deny the services to the petitioners. This itself shows that, my lord, our continuative services should be regularized.
This, the order at page 48 was at whose instance?
Lord, this instance of some employees who have been earlier ordered by this honorable court to be regularized.
Where is that order?
That order is ink page, my lord. Lordship will find it on ink page 31. Annexure B.
Raman Kumar and others.
Yes, my lord.
Where is this Raman Kumar? Raman Kumar, he's not a petitioner in WP number 34001 of 2019. Huh?
Annexure B of his petition may kindly be seen, that is covered. 31. Page
31.
number 31.
Madam, that is right, but where is Raman Kumar is not a petitioner in WP number 34001.
Pages, Lord. One more
Regularization.
judgment, the same Lord, Nagendra judgment is
And
So
I
you
can-
said page 48 is the order passed
by the Supreme.
by the Supreme Court based on the order passed by this court in WP number 34001 of 2019.
Yes,
It is there.
it is there, madam. Here,
It is there.
Elli the Ramana Kumar, who is not a petitioner,
They have not made them as party, but it is covered in another judgment also.
yeah, ನೀವು ಓದೋದಿಲ್ಲ ಅಲ್ಲಿಯ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
I don't know why you come to the court without preparation.
ಇಲ್ಲಿ ಕಾಣ್ತದೆ.
ನಾಗೇಂದ್ರಪ್ಪ.
Last page section.
So this order was passed against the dismissal of the contempt petition.
Yes, madam.
And they have complied the order also based on that contempt order. And based on that, my lord, another similar repetition is allowed by this coordinate bench, my lords. In WP number 202146.
Yes,
Based on those two judgment, coordinate bench has passed.
I have
upon
filed a
this.
memo.
I'll come to you, please wait. Yes. What else? Yes,
Lord, I have filed a memo. The connected matters are pending before the honorable principal bench. And there is a direction to consolidate all these matters, my lord, to the university. Accordingly, I have filed a memo.
ಇಲ್ಲಿ
19/12/2024.
which petition?
In all the petitions, my lord.
ಕೊಡಿ ಯಾವ್ದೋ memo.
The honorable principal bench passes the order in WP number 14330 of 22. 19/12, I have moved a memo, my lord, requesting this honorable court to
ಇಲ್ಲಿದೆ memo. ತಗೊಳ್ರಿ ಎಲ್ರು ಯಾವ ಕೇಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದಿರ? In which case have you filed the memo, sir?
Yes, my lord. Yes, that is noted also. Yes.
4.1 ಅಲ್ಲಿ
Rihanna
ಕೊಟ್ಟಿದ್ದಾರೆ,
Begum,
memo
4.
dated 1912,
202184 of 24
4.1 ಅಲ್ಲಿ.
and 201052 of 24. Elderly, my memo is listed. my lord.
Then we'll await the consideration before the principal
Yes.
bench.
I am submit the order copy also.
Yes,
There is a direction to the university.
there's some matters which
therefore
are
we have
pending
moved the
before the
members.
principal bench.
And this coordinate bench has also passed the order, my lord, on the similar ground.
As the principal bench directed that all matters should be
Please,
transferred.
my lord. Second para of this order may kindly be read, my lord. Unnumbered second para.
That memo may kindly be given to me.
Xerox ಮಾಡ್ಕೊಡ್ತೀನಿ.
Because all they fall within the jurisdiction of this Kalaburagi High Court, my lord. All are working in Bidar.
Correct, but where is the court said that it has to be transferred to the principal bench?
They have to be consolidated before the single judge. anta.
Consolidated, okay, you give all the numbers so that we can dispose of in one shot.
Yes, my lord. The Bangalore number, which is directed, my lord, 14330 of the
Whereas the court said that this has to be transferred, you look at the memo that you.
consolidated, my lord. Kalaburagi bench matter kuda, they may be consolidated and taken on the common hearing before the single judge anta ide.
Same.
But it's same.
Because
That-
before the single judge, I am the single judge.
That's what I am submitting, my
But
lord.
look at the memo that you have filed. It is requested this honorable court to made over the aforesaid writ petition to the honorable principal bench.
Yes, just to consolidate, my lord, as per this order.
ಇನ್ಯಾವುದು ಬೇರೆ petitions ಇದೆಯಾ?
Yes, my lord, there are other petitions are also there.
Huh?
There are other petitions, my lord.
Why don't you
I will
a
give the
list?
numbers.
Give the list.
I will give the numbers.
Or learn counsel for the petitioner, so learn counsel for the respondent number 2 and 3 in WP number 201052 of 2024 submits that hardship, ಇಲ್ಲಿ order ಕೊಟ್ರಲ್ಲ ಈಗ.
4.1 may be delinked, my lord. That is.
Bench of this court. Submits that a coordinate bench of this court in terms of the order dated 22/11/2024 has directed consolidation of all cases relating to regularization of service in the respondent number 2 and 3.
Yes,
So that all the cases could be disposed of uniformly. The learned counsel for the respondents 2 and 3 submits that there are several other petitions which are pending. Full stop. The learned counsel for the respondents 2 and 3 is therefore directed to furnish the furnish the particulars of the writ petitions which are pending
Please.
consideration before this bench.
please, please.
What do you, ಯಾವ ಕೊಡ್ತೀರಾ?
There are total 5 matters, my lord, total, no more.
Give the number, sir,
Yes, number,
Date, my lord.
other than those which are posted today.
I will give the number here only.
List
I
these
have.
petitions along with WP numbers. ಬೇರೆ ಕೊಡಿ.
Please. 20184 of 89,
20184.
89 of 2024.
ಅಲ್ರಿ ಇದೆಲ್ಲ ಬಂದಿದೆಯಲ್ರಿ ಇಲ್ಲಿ?
Then all these 5 cases I have moved the memo.
Mr. Gate, other than those cases which are listed today,
Yes,
are there any other cases which
no,
are?
no, no, these are the only cases. Today what I have placed.
Consolidate ಆಗಿದೆಯಲ್ರಿ?
ಅಲ್ಲಲ್ಲ, Bangalore matter,
ಅಯ್ಯಯ್ಯೋ, ನಂದು.
ಓ, ಏನಿದೆ?
Relating to same university, Bengaluru ಕೂಡ matters are.
ಬೆಂಗಳೂರಿನಲ್ಲಿ ಕೂಡ matters ಇದೆ. ಅದಕ್ಕೆ there are total 126 persons who have filed these writ petitions for regarding regularization. So their lordship has just to avoid the any conflicting views. So let all the matters may be taken together anta, that is the observation.
But why should these?
ಇಲ್ಲಿ ಈ bench ನಲ್ಲಿ 5 matters ಇದೆ, we have given the memo.
ಆಯ್ತು. Yes,
Surekha,
list on
this
bench.
coordinate bench, my lords, after passing that order only,
ಆಯ್ತು, what has happened before the principal bench?
that is
That
still
is
pending.
pending.
But whereas
1443
this coordinate bench
shall
already
given.
taken decision based on those.
That matter is pending.
That is okay, when he says that there are some matters before the principal bench. So now this coordinate bench of this court has directed that all matters have to be consolidated. I don't know whether these matters will have to be transferred to the,
It cannot be,
bench.
they are all working in Bidar, my lord. They fall within the jurisdiction of Kalaburagi High
It
Court.
is state matters, state university matter ಇದೆ ಅದು.
then.
Yes.
Yeah,
ಇದರ
ಹೊಡ್ದಾಕ
ಪ್ರಶ್ನೆ ಇಲ್ಲ,
numbers ಹೊಡ್ದಾಕ.
state matter.
In that view of the matter, list these petitions after disposal of the,
It will take time, my lords. Let
disposal
them-
of the large number of petitions which are pending before the principal bench.
14330 of 22 ma'am.
Yes. Next.
My lordship may kindly fix
For
the
five.
date and so that otherwise indefinitely if we
Madam,
go for without
Principal
disposal.
bench, there are more matters. Here we have only 5 matters. He says that there are 126 petitions.
Yes,
Read petitions, but there are more than 30 employees, my lords.
Doesn't matter. 126 petitions are pending before the principal bench. So let them take a call.
That's fine, my lord, but coordinate bench of this honorable court, my lord, already has taken a view, my lords. They can follow it and it
But
could be.
also you
disposed
can
of.
mention to those employees to compel the principal bench to accept
Because
the
last
view.
time, my lords, this honorable court, my lord, it has passed order taking note of all the matters which are disposed of before the Supreme
Why
Court.
don't you bring it to the notice of the principal court that a coordinate bench of this bench,
The only problem is we don't appear there, my lord. They are all Mysore and Bangalore
all-
matters.
it's all on VC. Don't say you can't appear.
ಗೊತ್ತಾಗಲ್ಲ ನಮ್ಗೆ.
So any of you can either pass it on to your colleagues there in Bangalore so that the petitions could be disposed of. Just list down on date could.
ಇನ್ನೊಂದು 4.1 may be disconnected. my lords.
Dealing.
That is different.
4.4.
Deals with something different.
Yes,
Different.
Office is directed to dealing 4.4
4.1 also.
and 4.1.
That is also
4.1 and
covered.
4.4.
4.4 is connected with serial number 83, 84, 85.
4.4. And list along with serial number
83, 84, 85.
83, 84 and 85. Serial number ಅಂತಾನೆ ಬರಿಬೇಡಿ. Numbers ಹಾಕಿ.
Serial number 4 ನಲ್ಲಿ office objection may be overruled, my lord, because I have already served the copies with the Ghate.
Mr. Ghate already appears.
Yep, sir.
Copy ಕೊಟ್ಟಿದ್ದೀರಿ?
ಕೊಟ್ರಿ.
The office objection in serial number 4 is overruled. Since the current counsel for the response 2 to 4 has already entered appearance.
Interim order, may please.
Interim order wherever in force shall stand extended till the
Date
next.
may be fixed for serial 83, 84 ಗೆ. Date may be fixed.
ಯಾವ್ದು?
Serial 83, 84, 85.
ಯಾವ್ದು ಒಂದು ಡೇಟ್ ಕೊಡು.
Next Wednesday.
Next, 2 weeks, because I have 2 weeks time.
Yes.
My lords, 4.1 also, the KM Ghati appears, that is in regard to NPS and OPS, my lord, that is also covered by the judgment of this honorable court, my lords.
All
And
right.
my learned friend is also aware.
Yes, Mr. Ghate.
4.1.
ಘಾಟಿ ಅವರೇ, ಸಾಹೇಬ್ರ.
ಅವ್ರು already.
Yes, 4.1, what do you want?
It is also covered, my lords. If he wants to go through and he had appeared in this.
ಕೊಡಿ ಅವ್ರ ಕಾಪಿ ಕೊಡಿ. Yes, next.
4.3 ನಲ್ಲಿ same office objection may be overruled.
Serial number 6.
May I pass on the
3
date?
ನಲ್ಲೂ overrule ಮಾಡಮ್ಮ. Huh? Yes, next.
Serial number
Date
5.
may can you fix or?
His date is already fixed, yes.
5-2.
My lord, I represent petitioner, my lord.
Number 5, Uppi Neerappa.
So I'm
My lord.
respondent 7, my lords.
5 and 6.
Not 5 and 6 on the last occasion I had undertaken to pay the dues of petitioner and also respondent number 7 on this day.
Lords, as per instructions, my lords,
Yes, serial number 5, who appears for the petitioner?
I appear for petitioner, my lord.
Yes, why is it listed today?
these applications, they do not survive, my lords, because the interim order granted by this honorable court has been modified subsequently. So, my lords, I for vacating interim order of stay, my lords, may not arise.
What about this?
That apart, my lord, he had undertaken to pay the dues. Now 10.74 crores is the dues, my lord. Outstanding.
On the last,
How does it
on
The
the
last
last-
occasion.
on the last date of hearing,
Whether IA 2 of 24 survives for consideration?
ಇಲ್ಲ.
No, no, my lord.
Yes, Barkole, IA 2
One
of 24.
and
Who has filed this IA 2 of 24?
I2 by respondent number 5 and 6, 1 of 24 by the state.
Barkole, IA 2 of 24 is filed by the learned counsel for the respondents 5 and 6 to vacate the order of stay granted by this court. The learned counsel for the respondents 5 and 6 submits that since the interim order granted by this court was subsequently modified, there is no need to vacate the order of stay. In that view of the matter, IA 2 of 24 is rejected. What about other things? Yes.
I1 of 24 also same.
Similarly, IA 1 of 24 is also rejected.
Yes.
What are these affidavits
Affidavits, my lords, in compliance of the order passed by this honorable court,
dated?
on, my lords,
My lord, actually, the respondents have filed that affidavit and thereafter they had undertaken to pay the dues, my lord. Now the question is to pay the dues. On this day, they had undertaken to pay entire dues, my lord.
ಇದರಲ್ಲಿ ಒಂದು small.
No, I don't know.
There is still a balance of
Why don't you
10.74.
people give me proper facts? You're arguing from the middle. What happened? I do not know about the case. You should brief me about the case.
May I beg to brief, my lord.
Yeah,
This
You're arguing
petition,
from the middle as if I know the facts beforehand.
may I make a submission with your lordship permission?
Yes.
My lord, this petition was filed by the petitioner bank, my lord,
Hmm.
challenging the order issued by respondent number 1 and 2, my lord, to pay off the entire dues of the sale proceeds of sugar, which was pledged to the petitioner bank, my lord, and the dues to be paid to the farmers only. And thereafter, this honorable court was pleased to stop the payment to the farmers and pay the question of paying to only to the petitioner was taken up, my lord. After that, this honorable court was further pleased to allow the respondent number 5 and 6 who are the factory, sugar factory, my lord. They were allowed to pay to the farmers, and the balance amount, whatever dues, was allowed to be paid to the bankers, my lord. In between, my lord, the respondent number 7 also got implicated. He is also one of the banker, my lord. And now the stage, my lord, is that the respondent number 5 and 6 sugar factory, my lord, they had undertaken on the last occasion to pay the 5 and 6, 7 bank and also petitioner bank. Now the respondent number 7 is also a lead bank, my lord, and petitioner is also another bank. Our outstanding dues, our account shows, my lord, and actually it was due on 30th September 2024, my lord. That loan was to be paid on or before that. Now there is no dues to payable to the farmers, my lord. Only bankers' dues is there, and my learned colleague had undertaken to appear for 5 and 6 to pay the entire dues on or before 20 this date, my lord. Whereas we received, still there is an outstanding balance 10.74 CR, my lord.
Yes.
And it is going to be a NPA, my lord. So undertaking that is given by the respondent 5 and 6 may kindly be enforced, and I beg your lordship to direct the
Where's the undertaking?
last occasion he had undertaken orally, my lord.
28/8/2024, my lord. Affidavit is extracted in order.
Yes. Yes, please.
May I read the order sheet, my lord, on 8/1,
Please wait, I'm reading the order sheet.
please.
Yes, after this order, what was the order?
8/1/2025 may kindly be produced, my lord.
8/1/25.
Yes, madam. Learned counsel for the respondent 5 and 6 submits that some time may be granted so that entire outstanding to the petitioner as well as respondent number 7 could be closed. In that two matter list on 22/1/2025 today.
From 8/1/2024, lords, this respondent 5 and 6, they have deposited nearly 5 crores to the petitioner and respondent number 7 bank. Balance remaining is 10 crores and odd in respect of petitioner and 10 crores to the respondent number 7 bank. We have lots sugar stock more than 1 lakh ton. And we have written lots of applications seeking permission. Since the monthly quota is not released, the sugar factory is unable to sell them in the market.
Yes.
So, lots, as per the undertaking, lots, as per the affidavit, as per the affidavit submitted by respondent number 5 and 6, whatever amount that has been received from the sale of sugar has been deposited to the petitioner and respondent number 7 bank, and they have been lots taking those amount equally. So lots, I am informed that lots permission would be given, and lots whatever amount that is received will clear up the door.
But is it a fact that they have paid up some 5 crores?
Allah,
Yes, it's a fact, my lord.
Yes.
After 8/1/25.
Yes.
After
Lord.
8/1/25, have
Yes.
you paid 5 crores?
Yes.
Yes, they have paid, my lord. They have paid. They have paid 5 crores and now the outstanding is 10.74 is the due, my lord. 10.74.
ಇಲ್ಲ ಅದು sugar sale permission ಬಂದ್ಮೇಲೆ
There's some permission is given for export of sugar also.
yes, the Millards director of sugar Millards New Delhi, it has to Millards issue monthly quota. There is a fixed quota for sale of sugar Millards.
Yes.
That has not been given to the Millards this respondent number 5 and 6. Immediately Millards this after receipt of this permission Millards whatever
Please
amount
put a
will
timeline
in
on
fact
whatever-
Millards will be saving interest on the loan amount if the amount is released.
Right, but then if you can't be sitting over the claim of
ಇಲ್ಲ
the
ನಾವು
petitioner.
ಏನು ಇಮಿಡಿಯೇಟ್ಲಿ ಹಂಗೆ ದುಡ್ಡು ಬಂದಿದೆ ಆ ತರ ನಾವು ಅವ್ರಿಗೆ ಡಿಪಾಸಿಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ವಿ. ದೇರ್ ಇಸ್ ನೋ.
Yes, how much time do you need?
May I make a submission?
Yes, how much time do you need?
Yes, Millards, one small submission, Millards. This honorable court on previous occasion, Millards, had directed the respondent number 1 government to Millards consider my application for release of sugar so as to clear the dues. If Millards similar Millards direction is issued to the learned GA.
May I submit, my lord?
Yes, please.
Your lordship may kindly peruse the order dated 28/8/2024, my lord.
Yes, that I have seen.
At para number 7, already directions was issued by this honorable court, my lord, to the
Para
respondent
number
number 1 and 2 to grant permission to sell the sugar at one stop. 7th last para, my lord.
ಅದನ್ನ ಬಂದಿದ್ದ ದುಡ್ಡನ್ನ ನಾವು
Learned
ಡಿಪಾಸಿಟ್
senior
ಮಾಡಿ
counsel for, may I read, my lord?
Yes, that is in respect of 1,58,000
yes
tons.
that is sold and
Now he says that something else is there in the
ಅಲ್ಲ
stock.
ನವೆಂಬರ್ದಿಂದ ಕ್ರಷಿಂಗ್ ಸೀಸನ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ ಅಗೇನ್ ಲಾಟ್ಸ್ ದೇರ್ ಇಸ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಶುಗರ್.
The learned counsel for the respondents in continuation of the submission made by the learned counsel for the respondents 5 and 6, he submits 5 and 6 on 8/1/2025, he submits that the respondents 5 and 6 are in possession of more than 1 lakh ton of sugar, and that they have made requests before the state government,
ಸ್ಟೇಟ್ ಆಸ್ ವೆಲ್ ಆಸ್ ಡೈರೆಕ್ಟರ್ ಆಫ್ ಶುಗರ್
before the state government as well as the director of sugar for permission to
ಸೆಲ್ ದ
sell
ಸೆಟ್
the quantity of sugar. He submits that soon after the said permission is given, the respondents 5 and 6 shall endeavor to sell the sugar and pay off the dues to the petitioner as well as the respondent number 7. Full stop. He also submits that post 8/1/2025, the respondents 5 and 6 have paid nearly 5 crores to the petitioner and the respondent number 7. And balance payable to the petitioner is about 10 crores and odd.
10.74 CR million.
A sum of rupees 10 crores and odd is payable to the respondent number 7. He submits, full stop. He therefore prays that a direction be issued to the state government and the Directorate of Sugar to consider the request of the respondents 5 and 6 expeditiously, full stop. In view of the aforesaid request of the learned counsel for the respondents 5 and 6, the respondent, the state government as well as the Directorate of Sugar is directed to consider the request of the respondents 5 and 6 as expeditiously as possible, at any rate within a period of
1 week.
month.
ಅವಾಗ್ನು 1 ವಾರ ಕೊಟ್ಟಿದ್ರು. ನಾವು 1 ವಾರ ಅಲ್ಲಲ್ಲ ಪರ್ಮಿಷನ್ ದೇರ್ ಆಫ್ಟರ್ ನೋಟ್ಸ್
in 15 days, the date of receipt of a copy of this order.
Please.
Stop, list down, after 15 days. Yes, next.
ಎಷ್ಟು ಸಮ
11 to
12
This 11th February,
12
KLR matter is on 11th, yes.
Much obliged.
Number 6, Arun Kumar Ambarguntappa.
Who's the R5? R5R.
It is my lord, private respondent.
List after service of notice to respondent number 5.
Next is also same.
Same.
7 also same order.
Number 8, Mahesh Patil.
Memo for producing documents filed with the- The memo shall be considered, memo along with the document shall be considered the time of final disposition.
My lord, one submission, my lord.
Ah.
And the matter, my lord, had come up last week, my lord, for a preliminary hearing, my lord. Here, my lord, they have affected my lord, recovery of 15 lakhs. My lord, lordship, my lord, had asked me, my lord, whether, my lord, I had informed, my lord, my my lord, employer, that is the central government, my lord, with regard to, my lord, my employment in the present. That I have produced, my lord, the documents, my lord, kindly.
Put it
lordship. Additional document, my lord. Page 2. My lord, this is the certificate of re-employment, my lord, which, my lord, issued by the, my lord, the present employer, that is the state government, my lord, to the, my lord, the central government. My lord, with regard to, my lord, appointment here. And thereafter, my lord,
Central government.
Secure the instruction and I filed
my
objection.
lord, next page, my lord, kindly, my lord.
No, wait a second. Not this. 2025 petition you are hurrying.
Andre, my lord, I'm,
Okay, secure
in the
instruction.
meanwhile, my lord, they have affected, my lord, every month, my lord, 15 lakhs.
To repay the money in case if it, your date.
But all others in similar matters, my lord.
Date for yavat. When will you get instructions? List on,
Additional document could.
list on, date put
29.
29. There are additional documents anta kudi.
Please.
Why don't you serve a copy to him?
Number 9, Reddy Basaraj.
The Kareddy Basuraj Siddhalingam.
The memo is filed on behalf of the respondent number 1.
What happened? What happened? Memo is filed.
filed memo.
Is filed, may I?
Filed by JDR number 1, stating that they will
Purple. No, you go and file an application for impleading if you want. You go and file an application for impleading if you want in the execution petition.
before that I will make some. But kindly look at the order sheet.
Yes.
But,
Last is to the
But even (13, 11, 24).
Not way back on, in n- even in September 24 also, many of the JDRs were not served.
No, why are you bothered about them?
No, why me?
No, Barkul.
My lord,
No,
one
sorry.
submission, my lords may kindly,
Ah.
here another aspect also, my lord. And now, at this stage, they have filed this application in this court here. If it were to be there in the filing EP code, that is.
So we'll direct him to go and file an appropriate application there. We'll
That
say that in view of the memo that they have filed,
Please,
you have no locus standi to question the proceedings before the executing court. You have no locus standi.
another aspect, my lord. My lords are in a supervisory jurisdiction, my lord.
Huh?
My lords are in a supervisory jurisdiction. My lord, the impugned order is against the established principles of laws.
I'll consider all those things, Barkul. The
Sir, Rule 34 may kindly.
proposed JDRs, no, that's okay. The proposed JDRs in execution petition 4/2024, pending consideration before the senior civil judge and JMFC, Mudde Bihal, are before this court, challenging the order dated
18/1/25.
18/1/25, issuing commissioner warrant to execute a sale deed.
As the objections is not filed by us.
Full stop. Pardon?
As the objections are not filed by us on that ground.
A suit in OS number 117/2001 was filed for specific performance of an agreement of sale in favor of the predecessor of the respondents 2 to 9. Full stop. A compromise was entered into
In appeal, that was reversed.
for this court in RSA 7247 of 2012, in terms of which the vendor had agreed to convey the property to the predecessor of the respondents 2 to 10, 2 to 9. Full stop. Later, the predecessor of the respondents 2 to 9 died, and the respondents 2 to 9.
The predecessor himself had assigned the decree, Manoj, in favor of the, yes.
Later died. Later, the predecessor of the response 2 to 9 assigned the decree in favor of the respondent number 1 in terms of a deed dated. What is the date?
Date, my lord,
Yes, Mr. Harshavardhan.
21/4/22.
21/4/22. Full stop. The respondent number 1 thus initiated execution proceedings in EP number 4/2024. Full stop. In the meanwhile, the respondents 10 to 31,
Please.
20. Respondents 10 to 31, who are the judgment debtors, executed a power of attorney in favor of the petitioner number 1 herein. in respect of the very same property that was the subject matter of the agreement of sale. And the decree passed in RSA so and so. Full stop. The petitioner number 1, based on the said power of attorney, executed a deed of absolute sale in favor of the petitioner number 2 and
petitioner.
Himself.
petitioner 2 ಇನ್ನೊಬ್ರು ಯಾರು ಅಂದ್ರಲ್ಲ.
Himself.
One favor ಆಯ್ತು ಮೊದಲು.
Based on the power of attorney, the petition number 1 executed a sale deed in his own favor and then conveyed it to the petition number 2
And one Sangappa.
and one Sangappa. Full stop. Next part. The respondent number 1 filed an application to implead
ಇಲ್ಲ ಎಲ್ಲ
the
ಕೂಡಿ ಹಾಕ್ಯಾರ.
petitioners. Huh?
Respondents 1 to 9 ಕೂಡಿ ಹಾಕ್ಯಾರ. 1 ಒಬ್ಬತ್ನೇ ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿರೋದು ಅವ್ರೊಬ್ಬರೇ ತಾನೆ.
ಇಲ್ಲ 1 to 9 ಕೂಡಿ ಹಾಕಿದ್ದಾರೆ.
The petition, the respondent number 1 to 10,
ಅಲ್ಲ 9.
1 to 9 filed an application to implead the petitioners herein as well as Sangappa
And one Sangappa.
and Sangappa as judgment debtors 24, 25 and 26.
Please.
Full stop. The notice of the application was served on the judgment debtor number 24. And the petition was listed for his appearance on 11/12/2024.
ಅಲ್ಲ
Full stop.
18ಕ್ಕೆ ಸರ್.
Sir, 11/12/24 ಬನ್ನಿ.
Please. 11, 12.
Full stop.
11, 12, 24. ಹಾ ಅದರಲ್ಲಿ ಇಲ್ಲ ಸಾಹೇಬ್ರೆ.
Sir, ಓದಿ sir. For appearance of proposed JD held sufficient ಅಂತ ಇದೆ ನೋಡಿ. JDR number 24 held sufficient as per postal report. ಊರಲ್ಲಿ ಇಲ್ಲದ ಕಾರಣ. For appearance of proposed JDR number 24 listed for appearance of the proposed JDR number 24 on 11/12/24. Full stop.
25 and 26 ಗೆ
On an application was also filed for interim injunction.
Pardon. ಅದು 11/12/24 ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ನಲ್ಲಿ ಬರೆದಿದ್ದು JDR 24 ಅನ್ಸರ್ವ್ಡ್ ಊರಲ್ಲಿ ಇಲ್ಲದ ಕಾರಣ ಅಂತ.
ಆಯ್ತು.
ಅದಕ್ಕೆ ಯಾಕಂದ್ರೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಆಗಿ 18ಕ್ಕೆ ನಾನು
ಆಯ್ತು. For appearance of proposed JDR ಅಂತ ಮಾಡಿದ್ರು ಮತ್ತೆ. It is listed for appearance of JDR number 24 on IA number 13/3.
IA number 3 ಅಂತ ಇದಂತ ಅದು ತಪ್ಪು ಬರ್ತದೆ.
For interim injunction against the proposed JDRs 25 and 26. Full stop. The executing court in terms of the order dated 18/12/2024 granted an order of injunction against the proposed JDR number 25 and 26 and restrained them from alienating the suit property. Full stop. The execution petition was then adjourned to 18/1/2025. Full stop. The execution petition was then advanced to 8/1/2025 and an application and order 26 rule 10 of CPC was filed. Full stop. The case was then adjourned to 18/1/2025. Full stop. On the said day, the proposed JDR number 25 and 26 entered appearance through counsel. Full stop. The notice to the proposed JDR number 24, which was ordered by substituted service through paper publication, was also accepted. Full stop. Based on the request of the respondent number 1/decree holder, IA number 7 filed by him and order 26 rule 10 was considered and the same was allowed, and an advocate was appointed as a commissioner to execute a sale deed in favor of the decree holder. Full stop. Being agreed with the same, the JDR number 25 and 26 are before this court.
24 and 20.
24 and 25 are before this court. Next part, the learned counsel for the petitioner submitted that the petitioners were impleaded by the decree holder in the execution petition, and the case was listed on 18/1/2025. Full stop.
Sought to be implemented.
Full stop. He submits that even before the petitioners could file objections to the execution petition, as well as to the application filed by the decree holder and order 26 rule 10 of CPC.
151 CPC.
Orders 26 rule 10 alva.
Correct. Commission.
26 rule 10 application IA number 7.
Even before the petitioners could file objections to the application to implead them in the execution petition, and also objections to the execution petition and to the application filed for under order 26 rule 10 of CPC, the executing court allowed the application filed under order 26 rule 10 and appointed a commissioner. Full stop. He further contended that the executing court did not comply the procedure set out under order 21 rule 34 of CPC, and a draft of the sale deed was also not furnished. Therefore, he contends that the entire procedure adopted by the executing court is improper, and hence the same is liable to be undone by setting aside the order dated 18/1/2025 and to grant an opportunity to the petitioners to contest the application to implead them in the proceedings as well as the execution petition. Full stop. Per contra, the learned,
Rule 16 follow madilla.
full stop. He also contends that the executing court has not complied with Rule 16 of the Karnataka Civil Rules of Practice.
Rule 16 of order 21.
Order 21,
Assignment of a decree iddaga.
Order 21, Rule 16 of CPC. Insofar as it relates to assignment of the decree by the predecessor of the respondents 2 to 9 in favor of the respondent number 1. Full stop. Per contra, the learned senior counsel appearing for the decree holder / respondent number 1 submits that the JDR numbers 24 and 25 were improperly sought to be impleaded as they were pendenti lite purchasers and hence were not entitled to oppose.
Under the compromise decree, possession was already delivered to the decree holder.
Full stop.
As
He
per the
also
compromise.
contends that as per the compromise decree in RSA 7247 of 2012, the possession of the suit property was already delivered to the predecessor in title of the respondents 2 to 9. Therefore, he contends that the petitioners were not really necessary in the execution petition. Full stop. When this court queried as to how the executing court could proceed further, even before the petitioners could be brought on record, and even before the petitioners could be granted an opportunity to contest the execution petition, the learned senior counsel contended that the petitioners are neither necessary nor proper parties to the execution proceeding, and that the application was filed to implead them by mistake, under a mistaken notion of law. Full stop. He also submitted that the respondent number 1 would take immediate steps to withdraw the application filed to implead the petitioners herein as judgment debtors 24 and 25 before the executing court. Full stop. Next para. In continuation of the aforesaid submission, a memo is filed today, which reads as follows. Copy Mabut.
Yesterday it was.
Filed yesterday.
Yesterday.
Filed yesterday, which reads as follows. Copy Mabut. Next para. Since the respondent number 1 is not pressing the application filed to implead the petitioners herein as judgment debtors in the execution petition, the petitioners would not have any locus standi to challenge the proceedings of the execution petition. Full stop. The contentions urged by the learned counsel for the petitioners are contentions that are available to the judgment debtors before the execution petition. Therefore, the petitioners cannot shoot from the shoulder of the judgment debtors / respondents 10 to 31. Full stop. In view of the memo filed by the learned counsel for the respondent number 1, and in view of the categoric statement that the application filed by the decree holder / respondent number 1 before the executing court to implead the petitioners herein would be withdrawn, no indulgence can be shown to the petitioners herein to set aside the order passed by the executing court. Hence, the petition stands disposed of on the above terms. However, if the petitioners are interested to oppose the execution petition, they may do so in accordance with law. Yes. Great. All contentions are kept.
At least
The executing.
an application withdraw. ಈಗ ಏನಾಗುತ್ತೆ ಸರ್, ಅವ್ರು JDRs ನಮ್ಗೆ ಮಾರಿವಂತ ಸುಮ್ ಕುಂತು ಅವ್ರು ಕೆಲವು ಸರ್
you have fished in troubled water. What can be done?
ಇರ್ಲಿ, ಈಗ ನಮ್ದು ಸ್ಟೆಪ್ಸ್
ಬೆಂಕಿಯಲ್ಲಿ ಕೈ ಇಟ್ಟಾಗ ಬಿಸಿ ಆಗುತ್ತೆ, ಸುಡುತ್ತೆ. ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಆಯ್ತು ಸರ್,
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ಹೇಳಿ?
ಆಯ್ತು.
You have taken the risk of buying a property which is under litigation, against which a decree is already drawn, which is a subject matter of execution. You are bound to face the music.
ಅಲ್ಲ, ಅದನ್ನ ಒಂದು ಮೆಥಡಾಲಜಿಕಲ್ ಫೇಸ್ ಮಾಡ್ಬೇಕಂತ ನಾನು.
ಏನ್ ಮೆಥಡಾಲಜಿ?
ಆಸ್ ಪರ್ ಲಾ ಏನ್ ನನಗೆ ಪ್ರೊವೈಡ್ ಮಾಡ್ಯದ, ಏನಾಗ್ಯದ, JDRs ನನಗೆ ಕೈ ಕೊಟ್ರು. ಈಗ ಈ ಆರ್ಡರ್ ಲಿಂದ ನನಗೆ ಅದಕ್ಕೆ ಏನು ಅಪೋಸ್ ಮಾಡಕ್ ಬರಲ್ಲ.
There can be no method in madness. But ಅಲ್ಲೋಗಿ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ.
ಆದ್ಮೇಲೆ
Please to work out your remedy in the execution.
ಪ್ಲೀಸ್ ಅಲ್ಲ, ಅಟ್ ಲೀಸ್ಟ್ ಸಮ್ ಬ್ರೀದಿಂಗ್ ಟೈಮ್ ಅಂತ ನಮ್ಗೆ ಈಗ ಅಲ್ಲಿ
ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಪ್ಲೀಸ್
Hema Kulkarni. Name of petitioner to be clarified. File ಕೊಡ್ರಿ.
Cancellation of affiliation.
Who is this petition number 6?
Petition number 6.
There's some office objection that name of petition number 6 has to be clarified.
Yes.
Veerabhadreshwara Educational
ಅದು
Trust.
ವೀರಭದ್ರಕೇಶ್ವರ ಅಂತ ಆಗಿದೆ. ಜಿ ಅಂತ ಮಿಸ್ಟೈಪ್ ಆಗಿದೆ ಅದು. ವೀರಭದ್ರೇಶ್ವರ ಬದಲಿ ಜಿ ಅಂತ ಟೈಪ್ ಆಗಿದೆ. ಹೆಚ್ ಬದಲಿ ಜಿ ಅಂತ ಬಂದಿದೆ.
ವೀರಭದ್ರೇಶ್ವರ ಅಂತಿದೆ.
ಹೌದು, ಆರ್ ಬದಲಿ ಅದು ಜಿ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಟೈಪ್ ಆಗಿದೆ.
ಏನ್ರಿ ಜಿ ಅಂತ?
ಅದಕ್ಕೋಸ್ಕರ ಹಾಕಿದೆ.
ಏನದು ಆರ್ ಬದಲು ಜಿ ಏನದು?
ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ
The
ಅದು
office objection is name of petition number 6 has to be clarified. Please go through the file.
petition 6
Learn counsel for the petitioner
Siddharth.
seeks time to
Minutes.
say the office objections.
Kindly pass over minutes.
Password.
Hearing interrupted application, serial number 11, Sachin Mahajan.
Sachin Mahajan.
Minutes.
Then somebody has not filed Vakala. R6, R8, R50.
Pardon?
Where is your briefing counsel? Somebody has not filed Vakalat for R6, R8 and R50.
Bandila. They have not turned up. They have not turned up. What my,
Well, then what should be done without? Can we dispose of this petition in their absence?
please, I leave it to your lord.
Yes. Process.
Lord, my lord,
Pay process to issue notice to these people. R6, R8 and R50.
notice has been served, my lord, they have,
ಸರ್ವಾಗಿದ್ಯಾ? ಸರ್ವಾಗಿದೆ ನೋಡ್ರಿ.
please serve, my lord.
R6 ಆಗಿದೆ. R3.
ಆರು ಶೀಟ್ ಕೊಡಿ.
Invitation.
They undertaken on 10/9/2024. ಕೊಡ್ರಿ ಅವ್ರು. Now you say that you don't have instructions. Please go through the order sheet. Accept notice for those responding.
Accept.
Huh? The Nitish Padiyal is directed to file the memo of appearance for the respondent 6, 8 and 50. Yes.
Lord, order passed by the reference court.
List down on ವಾರ ಕೊಡಿ. List down on date ಕೊಡಿ. You don't see the cause list, is it? You people don't see the cause list? Why do we issue a cause list?
Correct.
Correct, ಸರಿ, ನೀವು ಅವ್ರ ಸಾಣ ಹಿಡಿಬೇಕು ನೀವು ಅವ್ರಿಗೆ. You should sharpen those people, youngsters.
Please, I will.
Then why should we issue a cause list?
ಇಲ್ಲ correct. Your lordship.
Yes, list on date ಕೊಡಿ.
29.
LCR ಬಂದದೇನ್ರಿ?
ಬಂದಿದ್ಯಾ?
TCR.
LCR ಬೇಕಾ?
ಇದ್ರೆ
Relevant documents have been, my lord, produced.
Yeah.
Relevant documents have been produced by me along with the petition.
So if you say LCR is required, I'll call it. If you don't want, I'll proceed.
Raichur, it is not far away.
Call for LCR, yes.
29th, my lord.
What about 11.1? ಅದರಲ್ಲೂ LCR ಇದೆಯಾ?
ಇಲ್ಲ ಅದರಲ್ಲಿ it is connected, my lord. It is mandamus. It is in respect of
Correct.
termination, my lord. That is in respect of regularization of service of the employees.
Yes. 12. Sham Harindra.
Lord, 12, I appear for the petitioner, my lord.
This is Karnataka Tax on Entry of Goods Act demand. Your lordships have already decided this issue.
I will follow the same judgment and close it.
Please, my lord, only one request. Your lordships may not make it a concession, my lord. It may be an order of the court because
no.
a different
Not
party. Please.
The petitioner has challenged an order bearing number so and so dated 33/2021, passed with the respondent number 2, bearing demand number so and so and CS order number so and so. Where the petitioner has also challenged a notice of demand of tax dated 33/2021, issued by the respondent number 2. Full stop. Next para. The petitioner contends that it is a company incorporated in the Companies Act and is engaged in the business of developing, building and managing renewable energy projects. Full stop. The petitioner is a subsidiary of Hero Wind Energy Private Limited, which is owning and operating wind power projects in India and other parts of the world. Stop. In the year 2016, the petitioner sought to set up a wind energy plant in the state of Karnataka and accordingly made a proposal to the state government. The proposal was accepted and a government order bearing number EN 343 NCE 2016 dated 16/12/2016 was issued allotting 26 megawatt wind power project to the petitioner located at Babaleshwar and Moolwad villages of Vijaypur Taluk and district. Full stop. The petitioner entered into a power purchase agreement with the jurisdictional electric distribution company. Full stop. The petitioner contends that Siemens Gamesa Renewable Power Private Limited bracket henceforth referred to as Gamesa bracket close offered to assist the petitioner in the installation of the wind energy project with an operational capacity of 50 megawatt at Khakandaki village of Babaleshwar Taluk for production and supply of electricity to distribution companies. In that regard, petitioner entered into an agreement with Gamesa in relation to the supply of wind turbine generators and commissioning of the project. Full stop. The investment of the petitioner in the project was approximately a sum of rupees 220 crores. Full stop. Pursuant to the aforesaid supply contract, Gamesa GAMESA procured the components from various places within and outside Karnataka and used them for installation and commissioning of the project, which comprised of 13 wind turbine generators. The installation was completed and the project was commissioned on 30th of March 2017. Full stop. The petitioner contends that the state government with a view to incentivize entities to establish and operate windmills in Karnataka, had issued a notification bearing number FD 37 CET 2000-1 under section 11A of KTEG Act dated 31/3/2000, exempting the liability to pay entry tax by any dealer on all kinds of windmills and parts and accessories brought into the local area. Full stop. The petitioner contends that this exemption is also clear from the clarification issued by the Commissioner of Commercial Taxes, Karnataka, for the year 2006-2007, which specifically state that the 2000 notification is applicable to all power projects, to all renewable energy projects. It is therefore contended that the petitioner is entitled to the exemption under the notification dated 31/3/2000 referred supra. It is contended that the state government issued another notification bearing number FD 10 CET 2010 dated 18/12/2010, which exempted the payment of tax on the entry of goods into a local area by an entrepreneur for use as inputs, component parts and consumables in the renewable energy project for a period of 5 years from the commencement of the project. Full stop. It also contemplated that an entrepreneur availing the exemption has to procure an exemption certificate from the Department of Energy, Government of Karnataka. Full stop. The petitioner contends that it was under the bona fide belief that it was covered under the notification dated 31/3/2000 and not the notification dated 18/12/2010. Full stop. It contends that it was shocked to receive a letter bearing number ACCT bracket audit bracket close -3/VJP /2020-21/B-283 dated 12/1/2021, calling upon the petitioner to submit various documents for completion of assessment under the KTEG Act for the year 2016-17. Full stop. The petitioner submitted all its documents on 4/2/2021. Full stop. Later, it received a notice of assessment dated 23/2/2021 from the respondent number 2, proposing to levy entry tax on the goods sourced at the site of the project of the petitioner between 2016-17, which amounted to a sum of rupees 3,40,49,742. It also proposed to levy interest on such due amount. Full stop. The petitioner replied to the proposition notice and contended that it was entitled to the benefit of exemption under the notification dated 31/3/2000 and hence requested the respondent number 2 to close the assessment. Following this, the respondent number 2 passed the impugned order and cast the impugned demand, called upon the petitioner to pay a sum of rupees 6,37,279, being the entry tax and interest thereon within 21 days from the date of service of the demand. Being agreed by the said notice and demand, being agreed with the said order and the notice of demand. The petitioner is before this court. Next para. The learned counsel for the petitioner contended that the notification dated 31/3/2000 exempted the entry tax on all kinds of windmills, parts and accessories thereof brought into any local area for consumption, use or sale. Full stop. He contends that the impugned assessment order is passed based on the notification dated 18/12/2010, which is a general notification providing for exemption on entry of plant and machineries and capital goods brought for the purpose of establishing captive power generation plant into the local area by an entrepreneur for use in setting up a renewable energy project. He contends that the notification dated 31/3/2000, being a specific notification applicable to windmills and parts, would prevail over a general notification dealing with goods involved in a renewable energy project. Full stop. While drawing a distinction in the various types of renewable energy project, he contends that, the notification dated 31/3/2000 is not applicable to a windmill project or solar project or biomass project. Therefore, he contends that the windmill turbine generators fall within the ambit of the word windmills, parts and accessories thereof, and hence the petitioner was exempt from payment of entry tax. In support of his contentions, he relied upon the judgment of the Honorable Apex Court in Santosh Maize and Industries Limited, State of Tamil Nadu, where the court was considering a statute containing both a general and specific provision and held that the latter must prevail over the former. Next, number 2. 2, 3, 4 ಇಲ್ಲಿ ನೋಡಿ ಕಾಪಿ ಮಾಡ್ತೀವಿ. Full stop. ಏನು objection ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದೆ ಮೇಲೆ.
Per contra, the respondent number 2 has filed a statement of objections contending that according to section 3(2) of the KTEG Act 1979, madam 16 copy of 16 full copy of full stop. I consider the submissions made by the learned counsel for the petitioner and the learned AGA for the respondents. I have also verified the records placed before me. Next para. The issue raised in this writ petition regarding the applicability of the notification dated 31/3/2000 and the non-applicability of the notification dated 18/12/2010 was considered at length by this court in WP number 226317 of 2020. And this court held in terms of the judgment dated 24/9/2024 that the notification that the petitioner therein was not entitled to the benefit of the notification dated 31/3/2000, and that the demand made by the respondent number 2 was just and proper. Full stop. Therefore, this writ petition also deserves to be disposed of on similar lines as is done in WP number 226317 of 2020. Stop. Since it is held by this court that the petitioner was entitled to petitioner was liable to pay the entry tax as per the notification dated 18/12/2020, and having regard to the renewable energy project of the state government and the purpose of granting exemption from payment of entry tax, the petitioner is granted 3 months' time from the date of receipt of a copy of this order to comply with the prescribed procedure to claim the exemption. If the petitioner fails to avail the opportunity, The respondents are at liberty to proceed to recover the tax and the interest payable by the petitioner in accordance with law. Yes.
Obliged, my lord.
Number 13, Nitish Padia.
Mr. Nitesh Padial.
I have filed, my lord, IA for intervention. I have filed IA for intervention.
Who are you?
My lord, I am, my lord, my lord, I am a candidate, my lord, for the selection to the post of junior engineer.
You
my
are
lord,
the
which is called
candidate
by
who
the-
selected,
Yes, my lord.
selected candidate.
Yes, my lord, interview, my lord, and only it has been withheld, my lord, only because of the
Any
interim order
objection?
in force.
I have filed objections, my lord. I am ready for final arguments insofar as writ
You are
petitions.
ready for final arguments.
Please.
Do you have any objection for it?
I have objections, my lord.
Please
Your
argue
lordship
on
may-
that first.
Your lordship may kindly peruse interim order dated 20th January 2023.
The IA one is returned for clarification, Renu. Please look at the cause list, Mr. Mahesh Patil.
2020
Cause list ilva?
January
I have the cause list with
2023.
you.
Okay.
Your lordship order
Order dated?
20th January 2023, my lord.
Very good.
ಪಾಸ್ ಮಾಡ್ತದೆ ರೆಡಿ ಅಂತ ಹೇಳಿ ಯಾವಲ್ಲ ರೆಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ರೆಡಿ ಅಂತ ಹೇಳಿ
Yes, please.
ನಾನು ಬರ್ತೇನೆ
Yes. ಹೇಳಿ.
Your lordship, the operative portion, the second respondent university is permitted to proceed with the notification at Annexure C by receiving the application from the eligible persons who are eligible to apply for the post notified in Annexure C. That is challenged, my lord. The second respondent university is also permitted to proceed further to scrutinize the applications and to conduct the examinations, if any, in terms of notification. However, it is made clear that there shall not be any order of appointment in respect of the post in which the petitioners are working till further orders from this court. It is made clear that the petitioners who are eligible to apply for the post notified in Annexure C are permitted to apply for the post without prejudice to their claim in the petition. The respondent university is at liberty to file an application for vacating. It is not coming in the way of appointment of the impleading applicant, my lord. We are, and the order, interim order is very clear, my lord. And the university has also not issued any endorsement to the intervener that because of the interim order, we are not
Any appointment
proceeding
order?
further.
Yes, along with my,
You have not been appointed.
my lord, here.
No, appointment order issue ಆಗಿಲ್ವಲ್ಲ?
Illa, sir.
My lord, only because, my lord, there is an interim order in force. My lord, I attended
But
interview.
the court has said that no appointment orders will be issued.
Yes, my lord.
Therefore, how can you come on record?
Because, my lord, now, my lord, they are the contract employees. And notification, fresh notification is called, my lord, I have applied, my lord, for the post of junior engineer. There was, my lord, I reached till, my lord, interview, and thereafter, my lord, appointment orders were yet to be issued.
Consider you can,
And, my lord, they have not challenged, my lord, the very notification. They have only sought for mandamus. But insofar as, my lord, the interim prayer, lordship may kindly see, my lord, the prayer and the interim prayer.
Sir, first come on record. Why are you arguing?
Yes, please, please.
I don't know when lawyers
I
will
will-
learn. I don't know, these are basic things. I don't know why lawyers don't learn this. You are arguing on merits even before you're impleaded.
Lordship will not ask for some, and I will clarify, with regard to, my lord, that, I will,
Yes. What is the, yes, what is the release short for?
Annexure C, my lord. Washing of Annexure C
Random is directed and regular.
and
service-
regularize
No, actually,
the persons
pay the regular service.
stated in Annexure A, my lord.
Yes.
And that order will not be coming in, and he is speaking to Speaking for the university, my lord, university is there, it has filed objections and we are ready for arguments and it can be.
This Burkhold, here 1 of 24 is filed by an applicant who had filed who had filed an application pursuant to a recruitment notification issued by the respondent number
True, my lord.
full stop. He contends that in view of the order passed by this court on so and so, the respondent number 2 has not issued the order of appointment, and that the interim order dated so and so is coming in the way of the respondent number 2 issuing orders of appointment to him. Therefore, he intends to come on record in this writ petition and contest the claim of the petitioner. Next para. This court, in terms of the order dated 9/1/2023.
20th.
20th January
20th January 2023 had permitted the respondent number 2 to proceed with the recruitment process as per the notification at Annex C by receiving the applications from the eligible persons. However, this court had directed that there shall be orders of appointment shall be issued.
In the place of the petitions.
Orders of appointment would be issued, disturbing the petitioners who are working, full stop. Therefore, comma, no order of appointment is issued by the respondent number 2 till date, full stop. The applicant in IA 1 of 24 would not be clothed with any right to come on record in this petition unless he has been appointed, full stop. Under the circumstances, comma, IA 1 of 24 does not survive for consideration, hence the same is rejected.
My lords,
Oblige.
in the place of petitioners, he has applied for junior engineer and none of them are eligible. They have already filed applications. It was directed by the court that who are eligible, they can
Are
file
they
the
working as
applications.
junior engineers?
No, my lords, none of them. And this will not, this should not come in the way.
No, are they working
No.
as junior engineers? What are they working
In
as?
personal notification, they were also permitted to apply. They have applied.
Madam,
And none of them
I'm
were
asking
eligible.
a simple question. What were they working as?
Some computer operators.
Computer operators.
Operators.
Mr.
Serial
CA
number 15 ಅಲ್ಲಿ ಇದೆ sir, Annex A ಅಲ್ಲಿ.
Hmm.
He is junior engineer. He has applied for, he is working as junior engineer.
Annexure ಏನಲ್ಲಿ junior engineers ಎಲ್ಲಿದ್ದಾರೆ?
ಇದಾರೆ sir, ಒಬ್ಬರು ಇದ್ದಾನೆ.
ಎಲ್ಲಿದ್ದಾರೆ?
Serial number 15 my lord.
ಅದ್ಬಿಟ್ಟು how many posts were there? How many posts were
ಅದು
there?
ಒಂದೇ ಇದೆ sir. Junior engineer ಒಂದೇ ಇದೆ.
The recruitment notification ಅಲ್ಲಿ ಎಷ್ಟು
ಸರಿ.
post?
Electrical ಒಂದೇ ಇದೆ sir. Ink page 35. ಸಿವಿಲ್ ಅಲ್ಲಿ ಒಂದು, ಎಲೆಕ್ಟ್ರಿಕಲ್ ಅಲ್ಲಿ ಒಂದು, ಎರಡಿದಾವೆ ಸರ್.
Yes, Mr. Mahesh Patil.
My lord, I have
ಎರಡೇನಾ?
applied-
How many posts are there?
my lord, I have applied, my lord, lordship, may kindly see my, my lord, the
Number
four of my, my lord, application.
Notification ಇದೆ ಎರಡೇ ಪೋಸ್ಟ್.
ಒಂದು ಎಲೆಕ್ಟ್ರಿಕಲ್ ಒಂದು ಸಿವಿಲ್.
One civil.
ನೀವು ಯಾರಿಗೆ?
ಇವ್ರು ಹಾಕಿರೋದು ಎಲೆಕ್ಟ್ರಿಕಲ್, ಸಿವಿಲ್ ಇರೋದು. ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಇರೋದು ಸಿವಿಲ್.
Number 15 is civil.
ಸಿವಿಲ್ ಹನುಮಂತ.
ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಅಂತ ಮಾತ್ರ ಇದೆ.
ಸಿವಿಲ್ ಇಂಜಿನಿಯರಿಂಗ್.
So how can, why should it not be brought on record?
I leave it to your lordship.
Then why did you not tell this?
He has not been specific in his application, my lord.
Madam, no.
No, I regret, my lord, because there is no proper application filed and,
You're a senior counsel, you're a designated senior
no,
counsel.
my lord, I fairly
We
concede.
we expect you to.
True, my lord. He doesn't say anything that he has applied and
ಆಯ್ತಾ? This order court passed an order dated so and so 21/2023 ಅಂತೇನು ಮಾಡಿದ್ರಲ್ಲ.
And university has not issued any endorsement, my lord, that it is because of the pendency.
ಆಮೇಲೆ
Application ಯಾವ ಪೋಸ್ಟಿಗೆ ಮಾಡ್ಯಾನಂತ.
ನೆಕ್ಸ್ಟ್ ವಾರ
One
ನಿಮಿಷ ತಾಳಿ.
Civil engineer ಇದೆ sir ಅವ್ರು.
ನಾನೇ ನೋಟ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ.
Yes, please.
The application, the affidavit filed accompanying the application shows that the petitioner, so that the applicant had applied against the post, against the post of junior engineer civil. Full stop. Petitioner number,
15, my lord.
the petitioner number 15 is also employed as junior engineer civil. Full stop. Therefore, by virtue of the order dated 21/2023, the applicant in IA 1 of 24 was rightly not issued with an order of appointment. Therefore, unless the order of appointment is issued to the applicant in IA 1 of 24, he is not entitled to come on record in this petition. Consequently, IA 1 of 24 is rejected. Yes.
Please.
Ready on merits?
Date may be fixed. Because.
I am ready, my lord.
No, but lawyers should gear up, sir. Sorry to say this.
No, my
Lawyers
lord.
should gear up. No,
No,
many lawyers, no,
I'm-
I'm sorry to say this. Many lawyers don't come with the cause list. They don't come with the cause list. This is given free of cost.
How?
This cause list is given by the court free of cost. And lawyers do not bother to carry the cause list. Very unfortunate. It's not only Mahesh Patil, Tumba Jana.
How?
They don't carry the cause list. I don't understand. How will you know what it is listed for?
It is a checkered problem, my lord, because your lordship, if your lordship permit, sometimes the list will be released belatedly, my lord. Your lordship kindly, your lordship can, for an entire 15 years, sir. Only in Gulbarga High Court, belatedly, the list
Sir,
will
it's
be released.
it's all uploaded. It's all uploaded.
Sir. Your lordship may kindly glance entire 15 years, my lord. It is only belatedly it will be released. Only 3-4 ಮೂರೇ ಕೋರ್ಟ್ ಇದ್ರು ಸರ್ 8:30 9 10 ಗಂಟೆಗೆ ಬರ್ತಿದ್ವಿ ಸರ್. That is how we are also being affected. All the advocates.
That's what
I am not making any
cause list will be there.
aspersions, my lord. I am not making
No.
any aspersions.
Cause list will be uploaded by the end of the day. You have to take a printout. If not 1, 2, 3, 4, and depending upon the number of juniors you have to take a printout.
If I am wrong, my lord, I will correct myself. But as per my instructions and my experience, your lordship may kindly have a glance.
No,
it is
many-
only Gulbarga bench is belatedly being released.
No.
Now, it is open, my lord. It is
No.
open. I am not making any.
Had obtained the cause list, my lord. Only this matter, my lord, is not, my lord, missing.
I'm saying, ಇವಾಗ ಅನ್ನ ಬೆಂದಿದ್ಯೋ ಇಲ್ಲೋ ಅಂತ ತಪ್ಪಲೆಗೆ ಕೈ ಹಾಕಲ್ಲ. ಅನ್ನ ಬೆಂದಿದ್ಯೋ ಇಲ್ಲ ಅಂತ ತಪ್ಪಲೆಗೆ ಕೈ ಹಾಕಲ್ಲ. ಒಂದು ಕಾಳು ತೆಗಿತಾರೆ. So therefore, please, lawyers should gear up, yeah. Kalaburagi bench should be equally competent. It's a request to all lawyers. There are some small things that you have to correct. Please
ಹೌದು.
correct.
There-
Small
there-
things.
There are follies, my lord, I am not disputing.
And nobody wants to correct. They think they are correct and what they're doing is correct.
No, no,
Despite
it is
being
not like
told-
that. Checkered problems, sir. Adar salai.
Checkered ಏನilla.
And many a times office objections.
There's
office
nothing that
objection-
you can't correct. There's nothing that you can't correct. Only thing is you have to make up your mind to
ಹೌದು,
correct.
ಹೌದು.
At least file ಓದ್ಕೊಂಬನ್ರಿ ಅಂದ್ರೆ ಓದ್ಕೊಂಬರಲ್ಲ. Forget. Youngsters, so I request them, they come for an adjournment. I ask them, have you read the file? They say no. But only when you read the file, you will know the case, how to draft a case, how to draft a writ petition, what are the grounds that can be raised.
There is dearth, my lord. There is dearth.
ಏನ್ ಡರ್ತ್ ನೀವು ಸುಮ್ಮನೆ ಡರ್ತ್ ಅಂತಿದ್ರೆ ಯು ಆರ್ ನಾಟ್ wielding the cane.
There is dearth.
There is dearth ಅಂದ್ರೆ ಉಪಯೋಗ ಏನು? Just about 15-20 people excelling in Gulbarga bench will not suffice.
ಹೌದು.
I can only count about 15 to 20 lawyers in Gulbarga who are capable, who come to the court fully prepared. The rest of them, what should we do? When will you gear up? When will the rest gear up is what I am asking. When will you? This is already yesterday. This is the 12th year,
15th year.
15th year.
16th year.
16th year after the establishment of the bench in Gulbarga, and we are still saying there is a dearth.
ಇಲ್ಲ, my lord, there may not be ಬೆಂಗಳೂರಲ್ಲಿ ಶಟ್ ಡೌನ್ ಇರಲ್ಲ ಸರ್, ಇಲ್ಲಿ ಗುಲ್ಬರ್ಗದಲ್ಲಿ.
I don't expect you to be Bangalore. You can't be like lawyers in Bangalore. At least you should
ಹೌದು.
show some change ಅಲ್ವಾ. ನಾನು 19 ಬಂದಾಗ ಹೆಂಗಿತ್ತು 2024 ಹಂಗೆ ಇದೆ.
ನಮ್ಮ young friends, many of them are from Kannada medium, sir. Many of them will not be in a position.
ಕನ್ನಡದಲ್ಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಫೈಲ್ ಓದ್ಬೇಕಲ್ಲ. You can argue in Kannada, but you should read the file.
ಹೌದು.
ಫೈಲ್ ಓದ್ಬೇಕಲ್ಲ first of all.
It is a checkered problem, my lord. I fairly consider and I will speak with our
Not a
office bearers.
checkered
and-
problem.
Please.
ನೋಡಿ ಒಂದ್ ಸಣ್ಣ ಅಯ್ಯೆ ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ ಅವ್ರಿಗೂ ಗೊತ್ತಿಲ್ಲ. ಯು ಆರ್ ಓನ್ಲಿ ಗ್ರೋಪಿಂಗ್ ಇನ್ ದ ಡಾರ್ಕ್. ಏನ್ ಮಾಡ್ಬೇಕು.
Hello, sir. In this petition, he has not mentioned as to which post he has.
Yes, mentioned, you are not seen. He has mentioned it in the affidavit.
It's a vague, my lord.
It is mentioned in the affidavit. Please go through the affidavit. He has mentioned in the affidavit.
Please, I regret.
Your lordship, kindly entry order may
It's
be
a
extended.
request to all lawyers. It is not as if ನಾನೇನ್ ದೊಡ್ಡ ಇವನು ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. But at least sitting here, I can find out what are the anomalies, what are the shortfalls. At least ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ರಿ ಅಂತ ಯಾರು. ಫೈಲ್ ಓದ್ಕೊಂಬನ್ನಿ, ಇನ್ನೇನು ಬೇಕಾಗಿಲ್ಲ. ಫೈಲ್ ಓದ್ಕೊಂಬನ್ನಿ. ದಟ್ ಇಸ್ ಆಲ್ ಐ ರಿಕ್ವೆಸ್ಟ್.
ಒಂದೊಂದ್ಸರಿ ಏನಾಗ್ತದೆ ಗೊತ್ತು, 60-50 ಕೇಸಸ್ in a single day, it will be overlapping and.
Then you please hand over all the files to lawyers who do not have the files. If you bite more than what you can chew, you can't complain. ಎಲ್ಲಾ ಕೇಸ್ಗಳು ನನಗೆ ಬೇಕು ಅಂತ ನೀವು ಮಾಡಿದ್ರೆ you can't help it.
ಅವ್ರು ಯಾರು ತಗೋತಾರೆ ಸರ್, ಎಲ್ಲ ಬಡವರಲ್ಲ, ಎಲ್ಲ ಅವ್ರಿಗೆ ಫೀಸ್ ಕೊಡೋದು ಗತಿ ಇಲ್ಲ ಅವ್ರಿಗೆ, ಅಂತವ್ರು ನನ್ನ ಹತ್ರ.
Correct. Then you should say I can't do it. Let them go to somebody.
Single day, 25 to 30 matters. Your lordship.
That is.
No.
Yes, next. Karil,
Your lordship, kindly interim order may be extended, your lordship, in serial number 30.
order granted, it is extended to the next date.
Plus.
Date code.
14. Mahesh Patil.
I am appearing, my lord.
Mahantesh Patil.
My lord, I am appearing for the respondent, my lord. I have filed my objections.
Lord, sir. They have served objections and vacating a.
Pardon?
They have served objections and vacating a. I need weeks accommodation, not I will come.
There is an, my lord, interim order.
ಏನ್ ಕೇಸ್ ಅಂತ ಹೇಳಿ.
Lords, it's a case wherein the respondent, my lords, the private respond number 2, who has an employee of, my lords, the college run by the present petitioner, NET Pharmacy College. He was working as a lecturer. He remained absent for, my lords, in the month of August 2023.
August
2023, my lords.
For how many days?
30 to 45 days he was remained unauthorized absent. Then my lords, he come up with an explanation that he was suffering from a low eye vision and therefore he was under treatment, my lords. Then he made a request for my lords rejoining. Then thereafter, my lords, the authorities, the petitioner has replied to the request made by him through the email, stating that, my lord, since he is suffering from low vision, as he submitted in the information itself, my lords, in the reply, he was suffering from 60% of, more than 60% of low vision. Then, my lords, he made a complaint to the commissioner under the Physical Disabilities Act 2016. That authority has passed an order, my lords, relying on the earlier 2000 rules and other proceedings. Challenging that, my lords, I am before.
You have taken him back into service?
No, not taken. That order itself is not under challenge. That is why I, my lords.
No, but have you accepted the reason given by him? Have you accepted the reason given by him for absenting from work?
No, but it's not accepted because the reason that what has happened is even we are not aware that my lords, he is suffering from low vision.
Then you must have
Only
subjected
in
him.
the year 2023, when he come up with a reply after unauthorized absence, in the reply he stated that I am suffering from the low vision.
Do you accept it or do not accept it?
Accepted means the unauthorized absence.
Do you accept the fact that
suffering
he is
from-
suffering from low vision?
That is why we stated that, my lord, since from last year.
No, first of all, let us go one step by the other. If you have accepted it, then you have to reinstate him back into service. If you do not accept it, then you can throw him out. Have you done either of the two?
I have to get instruction. There is no clear about all these things. What your lordship saying, my understanding is that, my lords, your lordship saying that the physical disability, what he is suffering and the reasons mentioned, that is whether we have accepted that reason or not.
Whether you accepted the reason for abstaining from work.
We stated that non-revealing the physical disability because he is a lecturer. That itself amounts to an misconduct.
No, that is okay. Now he has abstained from work. He has abstained from work. Ideally, he must have applied for leave. Thereafter, this is the ideal situation.
How?
He must have applied for leave. Only after the leave was sanctioned, he could have abstained from work. No, he has not obtained the leave.
And remained unauthorized.
On his own, he has abstained from work. No, he gives a reply and says, "Nan kan kaanta illa, adike nan kelsakke barakkaglilla. Dayaviಟ್ಟು ಕ್ಷಮಿಸಿ. Please take me back to work."
That is where what the management says, my lords. My instructions are that there were several complaints from the student itself they have made earlier. We are not aware about this deficiency. He was suffering from low vision, 60%. Therefore, they could not take it. Kindly have it on next week. I will come up with.
Or you give him some other work, if not
some
light work, depending upon his.
Very showcase notice, my lord, is that, my lord, that I am suffering from low visibility. It is not, my lord, of unauthorized option. They are very showcase notice. And I have replied, my lord, and my lord, that I am capable of working and to take back, and they have denied me attendance.
Showcase notice, Angit.
Yes, please, bro. Page 20.
Showcase notice was continuation of earlier.
Page 20, my lord. Page 20. As per your email, you are suffering from the disability. That is bilateral retina pigment. So the said disability not disclosed to the management in spite of complaint.
20.
Received, page 20, my lord, Annexure D. As per your email, you are suffering from the disability, that is bilateral retinous pigmentosa. The said disability not disclosed to the management in spite of complaint received from the student with respect to the lower performance in teaching since 2 to 3 years. The said not disclosing the disability which was affected your teaching amounts to misconduct. Wherever you have, moreover, you are unauthorized absence from 1/8/2023 to till date without proper sanctioning of leave, and it is amounts to misconduct on your part. Therefore, you are called upon to give an explanation to the aforesaid misconduct. My lord, here, my lord, they have not denied me attendance.
What do they want to do? Whether they'll take him back to work by accepting the disability or the reason for abstaining from work. If they'll take you back to duty, then the question of assigning light work under the Disabilities Act will be considered
Yes,
later.
That's all I'm seeking.
They'll get it
Yavaga.
on 10 days.
The land counsel for the petition seeks time, list on. Yes.
Please.
Number 15, Manvendra Reddy. Not appear for the petition, but I have received the statement of objection yesterday, my lords. 10 days accommodation, lots to file a rejoinder.
I'm for respondent, private respondent, I'm ready.
ಏನ್ ಮಾಡಿ ಟೈಮ್ ಬೇಕಂತ ಕೊಡೋದಾ ಬೇಡ?
ಕೊಡಿ.
Land counsel for the petition seeks
29,
time to file
29.
the rejoinder to the statement of objections, list on.
29, my lords. In
Great.
first week, my lords. First week, my lords.
No,
Yeah, take whichever date you want.
Why two? Fine, please, oblige.
Yes.
Preliminary hearing, November 16, PG Chicken Argunda. PG Chicken Argunda.
PG Chicken Aragund.
My lord, in this case, appear for the petition, your lordships.
Yes.
In this case, not the petitioner sought for grants upon additional increment for having passed the Kannada language examination, your lordship.
Government.
My lord, writ petition is allowed, writ appeal is pending, my lord. It is on 22/7/21 partly heard and pending. The state has preferred appeal,
On what?
challenging the order of this writ petition, my lord.
ಎಲ್ಲಿದೆ?
They have given copy, man. In fact, no. I filed the judgment along with the memo, your lordship.
ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಇದಕ್ಕೇನು ಸಂಬಂಧ?
Increments, they are. In terms of the judgment passed by this honorable court, this also not may kindly be not disposed of, your lordship. Subject to results of the writ appeal, your lordship.
So this writ petition can be disposed of on the same lines, subject to the outcome of the writ appeal.
Yes, ma'am.
Purple. The petitioners have challenged the wires of VIRES of the Karnataka Education Amendment Act 2015, which was published in the Karnataka Gazette on 9/1/2015. On the ground that it encroaches upon the powers of the court to grant powers of the, on the ground that it encroaches upon the powers of the court to review the orders passed thereunder, and consequently to direct the respondents to grant the benefit of an additional increment for having passed the Kannada language examination. They also sought for a writ in the nature of mandamus, directing the respondents to extend the benefit of the Karnataka Civil Services Service and Kannada language examination rules 1974, read with circular dated 3/11/2000 and 12/9/2001. Next para. When this petition was listed for preliminary hearing, it was brought to the notice of this court that similar writ petitions filed before this court in WP number 105439/2014, WP number 108382-417/2014 were favorably considered by a coordinate bench of this court, void order dated 24/7/2020. Full stop. It is therefore prayed that this writ petition may also be disposed of on the same lines as is done in the aforesaid writ petitions. Next para. The learned AGA contended that the order passed in WP number 105439/2014 and WP number 108382-417/2014 is challenged in writ appeal.
1,03,000 of 21.
Full stop. He therefore contends that this writ petition may be taken up for consideration after the disposal of the writ appeal.
Yes.
Since similar questions of fact and law were considered by this court in WP number 105439 of 2014 and WP number 108382-417/2014, this petition also deserves to be disposed of on the same lines as is done in the aforesaid writ petitions. Subject, however, to the outcome of the writ appeal number so and so. In view of the aforesaid, this writ petition is allowed on the same lines as in WP number 1054 of 39/2014 and WP number 108382-417/2014. And the petitioners are granted the same reliefs which are granted in the aforesaid writ petitions. This is, however, subject to the outcome of writ appeal number so and so.
Oblige.
Ratna Shivagama?
Ratna Shivagama, yes, please. Yes, madam.
Yes, madam. See, in challenging the order passed by the first respondent, then consequently order passed by the second respondent, on the ground that the authorities have considered his entire service without deducting the period of which he was absent for the period of. He
For
was
how long?
dismissed from 1985
Ah,
and he was reinstated in the year 1992. That's,
but why should that period be deducted?
it was not deducted, my lord. The labor, he has approached against the order passed by disciplinary authority, he has approached the labor court. The labor court has passed the order directing the corporation reinstated without back wages and continuity of services. When there is a specific observation regarding his continuity of service, he is not entitled for that period. If that period is deducted, my lord, his qualified service is, that is entitled for only 19 years, 4 months.
Continuity of service ಕೊಟ್ಟಿಲ್ವಾ?
Kotila.
ಎಲ್ಲಿದೆ ಅದು order?
Order kotla, but he has mentioned in the service I
This
collected.
order passed by the labor court.
Just now they collected the information and I collected the service register also.
The learned
That is
counsel for
mentioned
the
in the
petitioner
service register.
submits, learned counsel for the petitioner submits that the respondent number 3 was dismissed from service, which was challenged before the labor court.
Per court.
The labor court reinstated the respondent number 3 back into service. But however, it was without continuity of service and without back wages. Full stop. Therefore, she contends that the qualifying service of the respondent number 3 for payment of gratuity was 19 years,
19 years, 4 months.
4 months. But on the contrary, the respondent number 1.
No, 2.
Respondent
One
number 2
and
na 1 na?
One has
One is
passed,
the
the
appellate
same is
authority.
confirmed by 2.
One, respondent number 1, sorry, respondent number 1 has passed the impugned order treating the qualifying service as 30 years and 1 month, huh?
Yes, my lord.
Yes.
Full stop. In view of the aforesaid submission, issue emergent notice, sorry, AG is directed to accept notice for respondent 1 and 2. Issue emergent notice to respondent number 3.
And he has received 2 checks, my lord. In spite of that, they have not deducted the second check. They have mentioned the check number also. The labor court carried in over
At the
160.
rate of 19 years, have you deposited the money?
Yes, my lord, so I paid the entire amount. That 2 lakhs,
But stay in ಬೇಕಾಗಿಲ್ವಲ್ಲ?
stay back, otherwise the interest double ಆಗುತ್ತೆ, 10% interest.
Next. So
2
emergent
lakh
notice,
30,000 entire payment ಇದೆ.
issue emergent notice to respondent number 3.
Interim order.
Interim order of what?
Otherwise the interest will be money.
ಅಲ್ಲ interim order deposit ಮಾಡಿದೀನಿ ಅಂತಿದ್ರಲ್ಲ.
ಅಲ್ಲ ಮಾಡಿದ್ವಿ, ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ ಅವ್ರಿಗೆ ರಿಸೀವ್ ಮಾಡ್ಕೊಳಕ್ಕೆ ಹೇಳಿದೆ. Dispersal, we have to pay the interest at 10%.
Since the petitioner has already deposited the amount as per the impugned order, the same shall not be released to the respondent number 3
Please.
until further orders from
Please.
this court.
Number 18, Danappa Pani Bate.
Danappa Pani Bate.
The petitioner was retired as a professor on 31st 1/2020. Pension was settled, but not regularized the suspension period. It is from,
What happened to the inquiry?
inquiry, it is out of 6 allegations, the one allegation was proved by the department inquiry, but not, that also not passed the orders by the disciplinary authority.
No orders of.
No orders, sir. That is no orders.
Please, I, my lord, the my lordship attention, but page 14 of the writ petition, my lord. But second para, Lord, I just go to second para, 2017-18 ರಲ್ಲಿ ತಮ್ಮ ಮತ್ತು ಪ್ರೊಫೆಸರ್ ರಮೇಶ್ ರಾಠೋಡ್ ಅವರ ಕೇಸು ಮತ್ತು ಪ್ರತಿ ಕೇಸುಗಳ ವಿಶ್ವವಿದ್ಯಾಲಯ ಜರುಗಿಸಿದ ಏಕನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರ ವಿಚಾರಣೆಯಲ್ಲಿ 5 ಆರೋಪಗಳಿಗೆ ತಾನು ಸರಿಯಾಗಿ ಉತ್ತರಿಸಿದ್ದು, ಆರೋಪ 3 ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರು ಸಮಾನಾಂತರವಾಗಿ ಪೊಲೀಸ್ DSP SS ಹುಲ್ಲೂರ್ ಅವರ ಆ ವೇಳೆಯಲ್ಲಿ ವಿಚಾರಣೆ ಗೊಂಡಿರದಿದ್ದರಿಂದ ಹಿಂದೆ ಬಿಟ್ಟಿರುತ್ತಾರೆ. ಆರೋಪ 3 ವಿಚಾರಣೆಯು ಪೊಲೀಸ್ ವರದಿಯನ್ನು ಆಧರಿಸಿ ಬಿ ಫೈನಲ್ 1 ವರ್ಷದ ಹಿಂದೆ ಕೋರ್ಟಿನಿಂದ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಅದರ ಪ್ರತಿಯನ್ನು 1 ವರ್ಷದ ಹಿಂದೆ ಸಲ್ಲಿಸಿರುತ್ತೇನೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಬಿ ಫೈನಲ್ ಅನ್ನು ಆಧರಿಸಿ ತನ್ನ ಮೇಲೆ ಹಿಂದೆ ಉಳಿಸಿರುವ ಆರೋಪ 3ರ ಇತ್ಯರ್ಥವನ್ನು ದಯಾಳುಗಳಾದ ತಾವು ಆಧಾರ ರಹಿತವೆಂದು ಪರಿಗಣಿಸಬೇಕೆಂದು ವಿನಮ್ರವಾಗಿ ವಿನಂತಿಸಿರುತ್ತಾರೆ. ಸದರಿ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕಡತದಲ್ಲಿ ಮಂಡಿಸಲಾಗಿ ಮಾನ್ಯ ಕುಲಪತಿಗಳು ಸಿಂಡಿಕೇಟ್ ನಿರ್ಣಯ ಸಂಖ್ಯೆ 8/8/2019 ತೀರ್ಮಾನದನ್ವಯ ಹೆಚ್ಚಿನ ವಿಚಾರಣೆಗಾಗಿ ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರ ನೇಮಕದ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಕಡತದಲ್ಲಿ ಮಂಡಿಸಲು ನಿರ್ದೇಶನ ಮತ್ತು ಆದೇಶವನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಅದರಂತೆ ಮಾನ್ಯ ಕುಲಪತಿಗಳ ನಿರ್ದೇಶನದ ಮೇರೆಗೆ ಈ ಕಚೇರಿಯ ಟಿಪ್ಪಣಿ ದಿನಾಂಕ 30/12/2019 ಮೂಲಕ ಕಾನೂನು ಘಟಕಕ್ಕೆ ಟಿಪ್ಪಣಿ ಬರೆಯಲಾಗಿತ್ತು. ಡಾಕ್ಟರ್ VR ಬಡಿಗೇರ್ ಪ್ರಾಧ್ಯಾಪಕರು ಇಂಗ್ಲಿಷ್ ಅಧ್ಯಯನ ವಿಭಾಗ ಇವರ ಆರೋಪಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹೆಚ್ಚಿನ ವಿವರಣೆಯನ್ನು ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರನ್ನು ನೇಮಕಾತಿ ಮಾಡಿ ವಿಚಾರಣೆಯನ್ನು ನಡೆಸುವ ಪ್ರಯುಕ್ತ ನಿವೃತ್ತ ನ್ಯಾಯಾಧೀಶರ ಹೆಸರು, ವಿಳಾಸ, ಇನ್ನಿತರ ಮಾಹಿತಿ ತುರ್ತಾಗಿ ಕಚೇರಿ ಸಲ್ಲಿಸಲು ಕೋರಲಾಯಿತು. ಆದರೆ ಕಾನೂನು ಘಟಕದಿಂದ ಯಾವುದೇ ಮಾಹಿತಿ ಬಂದಿರುವುದಿಲ್ಲ. And my lord, kindly come to my lord page 15, the last para. ಶ್ರೀ so and so my lord, ತಮ್ಮ ಪತ್ರ ದಿನಾಂಕ 30/4/2020 ಮೂಲಕ ಸದರಿ ಪ್ರಾಧ್ಯಾಪಕರ ಇಲಾಖಾ ವಿಚಾರಣೆಯಲ್ಲಿ 6 ಚಾರ್ಜಸ್ಗಳಲ್ಲಿ 1 ಚಾರ್ಜ್ ಸಾಬೀತಾಗಿತ್ತು, ಉಳಿದ 5 ಚಾರ್ಜಸ್ ಸಾಬೀತಾಗಿಲ್ಲ ಎಂದು ತಿಳಿಸಿದ್ದಾರೆ. ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಸದರಿ ಪ್ರಾಧ್ಯಾಪಕರ has violated regulation 5(2) of the regulation governing program as he tried to take a candidate exceeding quota as per the other charges. They are not directly convicted with the Dr. Badigere for lack of complete evidence. ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ವಿಚಾರಣಾ ವರದಿಯನ್ನು ದಿನಾಂಕ 27/3/2018 ವಿಶ್ವವಿದ್ಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ್ದರು. ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪ್ರಾಧಿಕಾರ ಸದರಿ ಪ್ರಾಧ್ಯಾಪಕರು ಸಲ್ಲಿಸಿದ ವಿವರಣೆಯ ಮೇಲೆ ಯಾವುದೇ ಕ್ರಮವನ್ನು ಕೈಗೊಂಡಿರುವುದಿಲ್ಲ. It is only a minor misconduct which can be exonerated by disciplinary authority, and his pension and other service benefits may be fixed. Regarding pendency of SC/ST atrocity criminal case in which police has already filed a B report, final report to the court, so that cannot be an impediment for settlement of pension ಎಂದು ಕಾನೂನು ಅಭಿಪ್ರಾಯ ನೀಡಿರುತ್ತಾರೆ. And kindly come to me lord, page 20, annexure D, para 1 ಡಾಕ್ಟರ್ so and so ಇವರ ವಿರುದ್ಧ ಇಂಗ್ಲಿಷ್ ಅಧ್ಯಯನ ವಿಭಾಗದ ಪ್ರಾಧ್ಯಾಪಕರ ಡಾಕ್ಟರ್ ರಮೇಶ್ ರಾಠೋಡ್ ಅವರ ದಿನಾಂಕ 15/7/2017 ತಮ್ಮ ವಿವರಣಾ ಪತ್ರದಲ್ಲಿ VR ಬಡಿಗೇರ್ ಅವರಿಗೆ ನಿಗದಿಗೊಳಿಸಿದ PhD ಕೋಟಾ ಭರ್ತಿಯಾಗಿದ್ದರೂ ಹೆಚ್ಚಿನ ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು PhD ಪ್ರವೇಶ ಪಡೆಯಲು ಪ್ರಯತ್ನಿಸುತ್ತಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಇದಕ್ಕೆ ತಮ್ಮ ವಿರೋಧ ವ್ಯಕ್ತಪಡಿಸಿರುವ ಕಾರಣ ಕೆಲವು ವಿದ್ಯಾರ್ಥಿಗಳು ಅವರ ಮೇಲೆ ಹಲ್ಲೆ ಮಾಡಿದ್ದಾರೆ ಎಂದು ಆರೋಪಿಸಿದ್ದರು. ಮುಂದುವರೆದು ಬಡಿಗೇರ್ ಅವರ ಮಗನಾದ ಕುಮಾರ್ ಸಂತೋಷ್ ಕುಮಾರ್ ಇವರ MA ಇಂಗ್ಲಿಷ್ ಪ್ರಥಮ ಸೆಮಿಸ್ಟರ್ 2016-17 ಪರೀಕ್ಷೆಗಳನ್ನು ಕುಮಾರಿ ಅಶ್ವಿನಿ ಗಡ್ಡದ್ ಇವರಿಂದ ಬರೆಸಿರುವುದಾಗಿ ತಿಳಿಸಿದ್ದರು. ಈ ಬಗ್ಗೆ ಡಾಕ್ಟರ್ VR ಬಡಿಗೇರ್ ಅವರ ಮೇಲೆ ವಿಚಾರಣೆ ನಡೆಸಲು ಆರೋಪ ಪಟ್ಟಿ ನೀಡಲಾಗಿತ್ತು. ಸದರಿಯವರ ವಿರುದ್ಧ ಮಾಡಲಾದ ಆರೋಪಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆ ಮಾಡಲು ಶ್ರೀ so and so ಇವರನ್ನು ವಿಚಾರಣಾಧಿಕಾರಿಗಳೆಂದು ನೇಮಕ ಮಾಡಲಾಗಿತ್ತು. ವಿಚಾರಣಾಧಿಕಾರಿಗಳು ಡಾಕ್ಟರ್ VR ಬಡಿಗೇರ್ ಅವರ ಮೇಲಿರುವ ಆರೋಪಗಳ ಕುರಿತು ವಿಚಾರಣೆ ನಡೆಸಿ ಆಪಾದನೆ 2 ಸಾಬೀತಾಗಿರುವುದೆಂದು ವರದಿ ನೀಡಿದ್ದಾರೆ.
ಏನ್ ಮಾಡಿದ್ರಿ ರಿಪೋರ್ಟ್ ಮೇಲೆ?
Lord,
Have you taken any disciplinary action against him?
Lord, that is how 2019, as my lord, I just my lord brought to the notice of my lord,
page 14. It is, my lord, pending consideration, ಘಟಕದಿಂದ ಯಾವುದೇ ಮಾಹಿತಿ ಬಂದಿರುವುದಿಲ್ಲ.
ಮತ್ತೆ ನೀವು
That is one part, my lord. And the, my lord,
But if you have not
annexure
taken any disciplinary action against him, how can you deny him the benefits?
benefits, my lord, certainly we, my lord, can't hold back.
But
The thing is, my lord, see, whatever the, my lord, charges, my lord, my lord, proved. And for that, my lord, whatever the minor punishment, my lord, it has to be.
you're not imposed.
Now,
ಯಾವಾಗ ರಿಪೋರ್ಟ್ ಆಗಿದ್ದು? When was the report submitted by the?
my lord, 2018,
We are in 2024,
24,
25.
after retirement, that is 2020, he got retired, my lord. Now, my lord, we are in
After
so many years, yes. And my lord, last I,
so you're not taken any steps.
Yes.
Passing your.
my lord, I just draw last, my lord, last page 23, Lord, the syndicate, my lord, regarding this issue. ಸದರಿ ಪ್ಯಾರಾ 2 ಸದರಿ ಸಿಬ್ಬಂದಿಯ ವಿರುದ್ಧ ಮಾಡಲಾದ ಆಪಾದನೆ 2 ಸಾಬೀತಾಗಿರುವ ಪ್ರಯುಕ್ತ ಅವರಿಗೆ ಈ ಕೆಳಗಿನ ಶಿಕ್ಷೆಗೆ ಒಳಪಡಿಸಲಾಗಿದೆ. ಸದರಿಯವರನ್ನು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಮುಂದಿನ ವಿಚಾರಣೆಯನ್ನು ಕಾಯ್ದಿರಿಸಿ ಮರುನಿಯುಕ್ತಗೊಳಿಸುವುದು ಮುಂದುವರೆದು 1 ಸೆಮಿಸ್ಟರ್ಗೆ ಸೀಮಿತಗೊಳಿಸಿ ಬೀದರ್ ಸ್ನಾತಕೋತ್ತರ ಕೇಂದ್ರಕ್ಕೆ ವರ್ಗಾವಣೆ ಮಾಡುವುದು. ಸದರಿಯವರಿಗೆ ವಿಭಾಗದ ಮುಖ್ಯಸ್ಥರ ಸ್ಥಾನವನ್ನೊಳಗೊಂಡು ಯಾವುದೇ ಆಡಳಿತಾತ್ಮಕ ಜವಾಬ್ದಾರಿಗಳನ್ನು ನೀಡದಿರುವುದು. 3 ಸದರಿಯವರ 1 ವಾರ್ಷಿಕ ವೇತನ ಬಡ್ತಿಯನ್ನು ಕಡಿತಗೊಳಿಸುವುದು. 4 ಸದರಿಯವರ ಮಾರ್ಗದರ್ಶನದಲ್ಲಿ ಪ್ರಸ್ತುತ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಂಶೋಧನಾ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಮಾತ್ರ ಮಾರ್ಗದರ್ಶನ ನೀಡುವುದು. So kindly come to my lord operative portion, next page. ಆದೇಶ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಲ್ಲೇಖ 6ರಲ್ಲಿಯ ಸಿಂಡಿಕೇಟ್ ಸಭೆಯ ತೀರ್ಮಾನದಂತೆ ಮತ್ತು ಮಾನ್ಯ ಕುಲಪತಿಗಳ ಅನುಮೋದನೆ ಮೇರೆಗೆ ಸೊ ಅಂಡ್ ಸೊ ಇಂಗ್ಲಿಷ್ ಅಧ್ಯಯನ ವಿಭಾಗ ಇವರಿಗೆ ಕರ್ನಾಟಕ ನಾಗರಿಕ ಸೇವಾ ನಿಯಮ 99/299/5 ಕರ್ನಾಟಕ ಸೇವಾ ನಿಯಮ 118 ಅನ್ವಯ ಈಗಾಗಲೇ 223/73ಗಳಿಗೆ ರಜೆಗಳನ್ನು ಮರುಗಡೆ ಮಾಡಲು ವೇತನ ಲಾಭಕ್ಕಾಗಿ ಮಂಜೂರಿಸಿ ಬಿಡುಗಡೆಗೊಳಿಸಿರುವುದರಿಂದ ಇನ್ನುಳಿದ 50% ಜೀವನಾಂಶ ಭತ್ಯೆ ನೀಡುವ ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ.
ಎಲ್ಲ where have you passed? Where have you passed an order?
The Lord, this is the Lord.
Will you get instructions or should I direct them to?
Lord, I in fact, my lord, interacted with the registrar also, my lord. What has been told, my lord, these are the, my lord, key points highlighted, and my lord, only one charge, my lord, as of now, my lord. If it is not, yes,
Only one charge, the inquiry officer says it is proved.
Please, if it
What
is,
have you done on
yes,
that?
my lord, and that is how, my lord, I have requested him, my lord,
What do
if
you
it
want?
is taken day after tomorrow, we will come back with.
Learned counsel for the respondent number 1 and 2 seeks time to secure instructions.
Please,
List on date.
29.
Arun Kumar.
29.
Much, please.
Number 19, Arun Kumar Amargondappa.
It's the petition related to regularization of the service.
When were you appointed?
In the year 1990, Your Lordship.
This government, yaar. Gaurish Kashampur.
I'm appearing on behalf of Gaurish Kashampur. Your Lordship. There was a direction to the government advocate to. There was a direction to the, in the last date of hearing, Your Lordship, there was a direction to the government advocate to get the instructions, Your Lordship, for the regularization of the work petitioners.
Yes, Mr.
In this case, they have sought the mandamus. So wherein the CMC has recommended for regularization, still it is pending for consideration before the government.
All these are sanctioned posts.
Yes. So therefore, whether that has to be decided by the authority. My lord. So my submission, my lord, not get the instruction, my lord. So however, it's in mandamus. Let them decide on the recommendation made by the CMC, my lord. On that observation, my lord, it may dispose. Since the proposal is pending before the government.
The petitioner.
What submission, Your Lordship?
I'm allowing the petition.
Yes, Your Lordship. 2 petitioners have
reach their retired,
Superannuation.
yes, retirement, Your Lordship.
I think you're entitled for whatever benefits,
Yes.
in case if you are considered for regularization. Annexure K5 proposal is pending.
The petitioners have sought for a writ in the nature of mandamus to direct the response 1 and 2 to consider the recommendation dated 9/6/2023 forwarded by the respondent number 3. And consequently, to direct the response 1 and 2 to consider the cases of the petitioners for regularization. They have also sought for a writ in the nature of mandamus to direct the respondents to regularize the services of the petitioners on they completing 10 years of service. Next. The petitioners contend that the respondent number 4 in its proceedings held on 20/10/1990 took a decision to appoint the petitioners and others on daily wage basis against sanctioned vacant posts after verifying their eligibility. Full stop. The petitioner number 1 was appointed as a bill collector, while petitioner number 2 was appointed as a second division assistant and petitioner number 3 as a bill collector on 21/10/1990. They contend that they have been working ever since then to the satisfaction of the respondent number 4. Full stop. The respondent number 4, taking into account these services rendered by the petitioners, granted equal pay for equal work in terms of an order dated 2/12/1999. Full stop. Following the judgment of the apex court in Uma Devi, the respondent number 2 called for details of daily wage employees who are entitled to be regularized. Full stop. Accordingly, the respondent number 4 prepared a list of daily wage employees who are eligible to be regularized and forwarded the same to the respondent number 3 on 21/1/2016. On receipt of the same, the respondent number 3 forwarded it to the respondent number 2. After entering his remarks regarding the eligibility of the petitioners. Full stop. However, the respondent number 2 has not taken any action which compelled the petitioners to file representations on 22/2/19 and 5/1/2022. Full stop. The respondent number 4 thereafter, in terms of its communication dated 10/2/2022, recommended the regularization of the petitioners, which following which the respondent number 3 again sent the proposal to the respondent number 2. Full stop. The respondent number 2 sought additional information and opinion of the respondents 3 and 4. Which was furnished on 3/12/2022. The respondent number 2 requested the respondent number 1 to regularize the services of the petitioners as they fulfilled all the 4 conditions prescribed in Uma Devi. Full stop. Despite all these efforts, the respondent number 1 is sitting over the case of the petitioners.
2.
Respondent
2. They have given the proposal to the respondent number 2, annexure K5.
So, respondent number 1
again sought additional information with reference to a government order dated 13/11/2006. Full stop. The respondent number 2 then communicated the same to the respondent number 3, who in turn directed the respondent number 4 to furnish the additional information sought for. The respondent number 4 thereafter prepared a letter containing the details of the condition of the service conditions of the petitioners and forwarded it to the respondent number 2, who then forwarded it to the respondent number forward to the respondent number 3, who then forwarded it to the respondent number 2. The petitioners contend that despite all these communications and letter correspondence, the respondents 1 and 2 have not taken any action to regularize the services of the petitioners. In the meanwhile, the petitioners 2 and 3,
1 and 2.
1 and 2 direction to seek for a writ in the nature of mandamus for a direction to the respondents to do the aforesaid. Next para. The learned AGA submitted that the requests of the petitioners would be considered in the light of the recommendations made by the respondents 1, 2 and respondent 2 and 3, and also in the light of the judgment of the apex court in the case of Uma Devi, as well as the subsequent judgments relating to regularization of service of daily wage employees. So in view of the aforesaid submission of the learned AGA, this writ petition is disposed of, directing the respondents to consider the recommendations dated 9/6/2023 forwarded by the respondent number 3, based on the representations of the petitioners dated 22/1/2019 and 5/1/2022. And if they are entitled to, regularize their services in accordance with law. Full stop. Since the petitioners 1 and 2 have retired from service, in the event of regularization of the services of the petitioners 1 and 2 shall be entitled to all consequential benefits.
Urgence number 21, Paramagowda, K part. The notices has been issued on the mentioned in application addresses, Your Honor. That have complied the order of this honorable court by depositing 15,000 rupees before the trial court, my lordship. It's an endorsement is here.
What do you want? You want to withdraw it?
No, my lordship. No, I'm the. There's.
You know your facts. Why don't you tell me the facts?
Fact is that, my lordship.
You're talking of some 15,000 deposit. What is that 15,000? Why they were asked to deposit?
While admitting the case, the court has ordered to deposit 15,000 rupees, my lordship. And same has been complied. It is in the order. It has been mentioned. I have not complied that.
Notice issue agilwa?
Yes. Notice has been issued on the address which is mentioned in the application, my lordship. I will search for a fresh address. If I found, I furnish it. A week time may be granted. And the interim order may be extended.
Issue emergent notice to the respondent. Madam, it is stated by the learned counsel for the petitioner that the order dated 19/12/2024 is complied.
Yes.
And the sum of rupees 15,000 is already deposited.
Deposit.
Which is withdrawn.
No, it's not
Deposited
withdrawn.
Before the labor court.
Before labor court.
Full stop. In that view of the matter, issue emergent notice to the respondent.
An interim order is granted. It may be
Interim order granted early is extended till the next date. Yaval complete a ಹೇಳ್ರಿ. Complete a facts ಹೇಳಿ.
Yes. Okay. But 22, Ratna Shivakumar.
The disciplinary authority has passed the order produced at Annexure A on 6/7/2008. And the charge that he was unauthorized absent for a period of 1 year, near about 1 year, my lord. Then the respondent herein has approached the labor court in the year 2021 after lapse of 12 years, my lord.
Take out notice, but 17B wages you pay.
The 17 bill, 12 years ಆದ್ಮೇಲೆ when though issued the call letters, my lord, we produce your RCMA kindly see
Order
the
of reinstatement.
order passed by the labor court, my lord, reasons in page 29 ದಲ್ಲಿ. Without dispensing a single word about the delay, RCMA kindly see they have not produced any document
There's an
evidence.
order of reinstatement. We'll stay the reinstatement, but pay 17B wages.
17 ಬಿ ಆತಲ್ಲ ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಒಂದ್ಸಲ ತಾವು ನೋಡಿದ್ರೆ 12 years ಆದ್ಮೇಲೆ
Correct,
RCMA
but
kindly see
ಏನು
in page 29.
But is entitled. Now there's an order of reinstatement. If he reports to
That reinstatement is not correct, my lord. After lapse of 12 years, without even single evidence, you are saying
Consider
page
all
29. ತಾವು ಒಂದ್ಸಲ reasons in page 29 ಒಂದ್ಸಲ ನೋಡಿ. Issue number 1 and 2. Issue number 2, the claimant examined. PW1, he has filed his examination chief affidavit and wherein he has been reiterated the claim statement and no documentary evidence on his behalf. Then, my lord, we produce all the documents, my lord, the para number 24, and furnish the call letters also. All these documents, my lord, when he has not turned to join the duty, when despite of our call letters, produce those letters, my lord. Even single document he has not produced regarding his absence, why he is taken, whether he has.
Where are the
admitted.
call letters that you have marked?
Call letters, my lord, exhibit P, exhibit R3 to 5, that exhibit para 24 dalli ಹಾಕಿದೆ. On behalf of respondent corporation, RW1 to 3 have been examined and got marked R1 to R44. R1 to 2 are the intimation addressed by so-and-so depot manager, Atni to division manager, Vijayapura, reporting that the claimant is remained absent for his duty since so-and-so. R3 to 5 are the call letters given by senior division controller, NEKRTC, Vijayapura division, Vijayapura to claimant calling upon him to join for his duty. 6 is the copy of articles of charge. 7 is the request and return claimant to the senior divisional controller, Vijayapura, so-and-so. R8 is a letter of permission issued by the respondent corporation to the claimant permitting him to join it to his duty. After that,
Right, but
2006 also you had issued
That's
letter to
right. He has given some medical report.
Yes, they are not, he has not adduced every evidence, my lord,
Please,
just.
What have you done? Have you checked the correctness of that medical report? It is with you. Do you dispute the receipt of the medical report? A medical report, now, either you should accept the medical report or you should reject it.
When that labor court held that is the inquiry is not fair and proper, they let him, he has to adduce the evidence before the labor court. He has not adduced any single
Please come to the
document.
Page 33, Bunny.
Sorry, sorry, para?
Page 33, ink page 33.
Yes, my lords.
Exhibit R43 is a medical certificate issued by Gotial.
Yes.
Has not been disputed by the respondent corporation. So you are in possession of R33. ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಿ.
43 just ಒಂದು receipt ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ, they have not, we have
ಆಯ್ತು,
disputed
ನೀವು
that.
ಗೋಟಿಯಾಲ್ ಹತ್ರ ಹೋಗಿ ಕೇಳಿದ್ರಾ?
ಅಲ್ಲ, we have cross-examined, he has not.
Correct, but have you verified with Mr. Gotial whether he has issued a medical certificate? ಏನಾದ್ರೂ ಮಾಡ್ಬೇಕಲ್ಲ. Either you accept, ಇವಾಗ suppose if he is ill, ಏನೋ ಕಾಯಿಲೆ ಇತ್ತು.
ಕಾಯಿಲೆ.
How can he come to work?
If it is after recovery, as per his contention, we have issued call letters after 2006 also. Exhibit R8, my lord, that is in the year 2006.
Yes.
He has stated that he will recover in 2006 and 2006 alone issued letter, R8. Last time you kindly see R8. I have taken the Xerox copies of those letters.
ಏನು ಎಕ್ಸಿಬಿಟ್ R43 ಅಲ್ಲಿ
R8 ಅಲ್ಲಿ ಅವ್ರು ಟು ರಿಕವರಿ 5/6/15/6 2006 ಗೆ ಮತ್ತೊಂದು ಕಾಲ್ ಲೆಟರ್ ಇಶ್ಯೂ ಮಾಡಿದೆ. ಸೊ ಅಂಡ್ ಸೊ ಚಾಲಕನು ಸೊ ಅಂಡ್ ಸೊ ನಲ್ಲಿ ಮನವಿ ಕೆಲಸಕ್ಕೆ ಮರಳಿ ಹಾಜರು ಅಂತ ನೀಡಬೇಕೆಂದು ತಿಳಿಸಿಕೊಂಡ್ರು. ಅವರ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು
ಕೊಟ್ಟಿದ್ದೀರಾ ಮೇಡಮ್? ಕಾಲ್ ಲೆಟರ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅವ್ನು ಹುಷಾರಿಲ್ದ್ರೆ ಹೆಂಗ್ ಬರ್ತಾನೆ?
ಅಲ್ಲ, ಹುಷಾರಾದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೆ ಅವನಿಗೆ, ಹುಷಾರಾದ್ಮೇಲೆ. ಇವಾಗ ಲಾಸ್ಟ್ ಮೈ ಪರ್ಮಿಟ್ ಟು ರೀಡ್ ದಟ್ ಲೆಟರ್ ಆನ್ 15/6/2006. ಸೊ ಅಂಡ್ ಸೊ ನಾನು ರಿಕಾರ್ಡ್ ಇದ್ದೆ ಓದ್ತೇನೆ, ಅದು ಕೊಡ್ತೇನೆ ನಾನು ಒರಿಜಿನಲ್. R8 ಸೊ ಅಂಡ್ ಸೊ ಹುದ್ದೆ ಚಾಲಕ ಸೊ ಅಂಡ್ ಸೊ ಸಲ್ಲಿಸಿದ ಮನವಿಯಲ್ಲಿ ಕೆಲಸಕ್ಕೆ ಮರಳಿ ಹಾಜರಾಗಲು ಅನುಮತಿ ನೀಡಬೇಕೆಂದು ವಿನಂತಿಸಿಕೊಂಡರು. ಅವರ ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಕೂಲಂಕಷ ಪರಿಶೀಲಿಸಲಾಯಿತು. ಸದರಿಯವರು ಅನಧಿಕೃತ ಗೈರು ಹಾಜರ ಕುರಿತು ನಿರ್ಧಾರ ತೆಗೆದುಕೊಳ್ಳುವುದನ್ನು ಬಾಕಿ ಇರಿಸಿ ಸದರಿಯವರ ಕರ್ತವ್ಯಕ್ಕೆ ಮರಳಿ ಹಾಜರಾಗಲು ಈ ಮೂಲಕ ಅನುಮತಿಯನ್ನು ನಿರ್ಧರಿಸಲಾಗಿದೆ. ಕಾರಣ ಸದರಿಯವರು ಕೂಡಲೇ ಘಟಕ ಸ್ಥಾಪಿಸುವ ಮರಳಿ ಕರ್ತವ್ಯಕ್ಕೆ ಹಾಜರಾಗಲು ಮೂಲಕ ಆದೇಶಿಸಿಲ್ಲ. ಡಿಸ್ಪೈಟ್ ದಿಸ್ ಕಾಲ್ ಲೆಟರ್, ಹಿ ಹ್ಯಾಸ್ ನಾಟ್ ರಿಪೋರ್ಟೆಡ್ ಡ್ಯೂಟಿ.
ಬರ್ಕೊಳ್ಳಿ, issue emergent notice. Interim stay of the impugned order passed by the labor court, subject to the petitioner paying up 17B wages to the respondent.
So 12 years ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. 12 years they had explained
madam.
anything about the delay ಬಗ್ಗೆ ಏನೋ ಒಂದು ಹೇಳಿಲ್ಲ. And labor court has not used for single word about the delay.
23.
Yes, next.
It is stale proceedings, my lord. Therefore,
Stay ಮಾಡಿದೆ.
ಅಲ್ಲ stay ಆಗಿದೆ. Stale proceedings ಇದು 12 years ಆದ್ಮೇಲೆ he has approached the labor
Consider
court. Otherwise, I would have.
17B wages again, he has to file an affidavit and all those things. Let him do it. Yes, Manure Ashok Kumar, please, man. The petitioners challenge the impugned order, Annexure E, my lord, which is passed by the second respondent Revised order of appointing on different- 13/12/2020. Pardon? That is Annexure E, my lord, impugned order. Annexure E. My lord, the second respondent issued the notification for selections of 18 posts of the supervisor of library of Gram Panchayat in Bidar district and different Gram Panchayats, my lord. On that is as per Annexure A on 16/8/2000, my lord. As per that, the petitioner made the applications as per Annexure B on 12/8/2023 for the Astur Gram Panchayat in Bidar Taluka, my lord. Yes. As per that, on 14/6/2014, as per Annexure C, the second respondent issued the provisional list. The name of the petitioner was figured in serial number 15, my lord. That is on page number 17, my lord, in provisional list. Ladvanti. That is a provisional list which is Annexure C, my lord. For Bidar Astur Gram Panchayat. And serial number 17. 15, my lord. That is with Vita. Yes, please. And further, my lord, as per Annexure D, final list was issued on 8/11/2024. The name of the petitioner is also figured in 6. He is selected in final list also. And in serial number 6, the name of the petitioner was figured, my lord. After that, the second respondent, after given the 15 days time for any objection, after that, on 13/12/2024, the Annexure E is issued by the second respondent. That is the one revised order, my lord. Yeah. Revised order, then they modify the order of the election of the petitioner, and the same was in the place of petitioner, the fifth respondent was appointed, my lord. After final list and his name was But figured. our marks ಜಾಸ್ತಿ ತಗೊಂಡಿದ್ದಾರೆ. That is the, my lord. This is the provision which is apply for the one, that is Karnataka Grama Swarajya and Panchayat Raj Service of Supervision of Grama Panchayat Libraries and Information Center Rules 2022. There is no such there is no such provisions under this rules, my lord, which is applicable for Correct, sir. The best candidate should be recruited. that is, my lord. The best candidate is the candidate who has taken 239 marks.
Final list ನಲ್ಲಿ ಅವರನ್ನ selection ಮಾಡೋದು question ಆಯ್ತಲ್ಲ. And after that 1 month, my lord, the final list was already issued by the second respondent. Thereafter, my lord, 1 month, there is no any objections by the fifth respondent. And how there is such provisions under this rules is applicable for the selection, my lord. There is no such provisions under this revised.
ತಪ್ಪು ಮಾಡೋದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕಾ ಸರ್?
My lord,
ಆಯ್ತು, ತಪ್ಪು ಮಾಡಿರೋದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕಾ ಅಂತ ಕೇಳ್ತೀನಿ.
ಅಲ್ಲ, ತಪ್ಪು ಮಾಡಿ ಸ್ವಾಮಿ. ಅವರನ್ನೇ ಫೈನಲ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ there is something in behind that is some president of the Gram Panchayat was related to the fifth respondent. Something is
Sir, how does it matter?
My lord,
You have secured 225 marks.
that is as per they said in revised order, my lord. Is that call for the record whether they are got if they have got this
Emergent
marks.
Issue emergent notice. Sorry.
R1 government.
ನೀವು ಯಾರಿಗಿಲ್ವಾ?
R1 ಮನೆ. Respond number 1.
ಕಮಿಷನರ್ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ ಕಮಿಷನ್ ನಿಮಗೆ ಬರುತ್ತಾ?
Yes, commissioners.
AG is that to accept notice for respondent number 1. ಬೀದರ್ ತಾಲೂಕ್ ಪಂಚಾಯತ್ ಯಾರು? ಗೌರೀಶ್ ಕಾಶಂಪುರ?
Yes, Gaurish.
Gaurish Kashampur for 234, issue emergent notice to respondent number 5. Any appointment issued to the respondent number 5 shall be subject to the result of this writ petition.
Please, my lord. There is interim order, but at least,
Any-
please,
Subject to the result.
please, ma'am, of that.
Number 24, Kumar Malik Patil.
Kumar Mali Patil.
Kumar Malik Patil.
Yeah, challenge the article of charges.
Vast idu. ಬರ್ಕೊಳ್ಳಿ. Kumar Mali Patil. There is no representation for the petitioner. List on.
29. Number 25, Ramachandra K.
My lord, we have challenged annexure D and F, my lord.
Annexure D and F.
Annexure D and F, my lord.
Ah,
For quashing, the impugned orders issued by the respondent number 1 to 5 to take charge in the order issued by the respondents to respondent number 6, take charge in the place of respondent number 7, my lord, without considering the seniority list issued by them earlier as per annexure C, my lord. And also we are seeking directions to consider my representation as per annexure E, my lord. My lord, petitioner was appointed as a assistant at Krishi Vignana Kendra Raichur in the year 2009. Further, he was promoted in the year 2016 as a senior assistant at Kalaburagi. The respondents issued seniority list on 31st/5/2024, my lord. As per seniority list, the petitioner's name appeared in the senior assistant column, my lord. And the respondent number 6 name was shown in the superintendent column, my lord. Kindly peruse page number 13, my lord, the annexure C. As per seniority list, petitioner is entitled to the said post in the place of respondent number 7, my lord. Without considering the earlier seniority list issued by themselves, they ordered as per annexure D and F to take charge in the place of respondent number 7, which is violates the fundamental rights of the petitioner. Therefore, we have challenged the said orders, my lord, here for quashing. Annexure C, kindly, the page number 13, my lord.
yes, please. You are a senior assistant.
Yes. My name appeared in the Riya Sahayakaru, senior assistant column, my lord, serial number 4.
Correct.
The respondent number 6 name appeared in the superintendent column, my lord, serial number 1 in page number 13, my lord.
That's a higher post.
But
Superintendent is higher post.
But the grievance of the petitioner is as per seniority list issued by respondents, he is entitled to the said post, my lord.
Said post andre.
The senior assistant in the,
Please read annexure D.
please. ಮಾನ್ಯ ಕುಲಪತಿಗಳು ಕೃಷಿ ವಿಶ್ವವಿದ್ಯಾಲಯ ರಾಯಚೂರು ಇವರ ನಿರ್ದೇಶನದ ಈ ಕೆಳಗೆ ಸಿಬ್ಬಂದಿಯವರನ್ನು ಕೃಷಿ ಹಿತದೃಷ್ಟಿಯಿಂದ ಅವರ ಹೆಸರಿನ ಮುಂದೆ ಕಾಣಿಸಿದ ಕಚೇರಿ ತಕ್ಷಣದಿಂದಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಆಂತರಿಕ ಕಾರ್ಯವ್ಯವಸ್ಥೆಗಾಗಿ ವರ್ಗಾವಣೆ ಮಾಡಿ ಆದೇಶಿಸಿದೆ.
ಬಿರಾದರ್ ಅಧೀಕ್ಷಕರು
ಎಸ್ ಮೇಡಮ್.
ನಿಯೋಜನೆ ಮಾಡಲಾದ ಸ್ಥಳ ಅಧೀಕ್ಷಕರು ಸಾಮಾನ್ಯ ಕಲಬುರಗಿ. Either how are you agreed by this order?
My lord, as per seniority list, my lord, I am the eligible person for that senior assistant
ಇಲ್ಲಿ
post.
ಕಲಬುರಗಿನಲ್ಲ.
Yes.
What is there to show that?
Sorry, madam.
Whether is this a promotional post? Superintendent, is it a promotional post?
No, my lord. The annexure C is the seniority list issued by the respondents. In the said seniority list, my name appeared in the column of senior assistant, my lord.
ಅದ್ರ ಮೇಲೆ ನಿಮ್ಮ ಮೇಲೆ ಬಸವರಾಜು, ಮಲ್ಲೇಶು.
No, serial number 4 is mine, Anumesh.
There are three people above you.
Yes.
ನಿಮ್ಮ ಮೇಲೆ 3 ಜನ ಇದ್ದಾರೆ.
Yes.
So how can you claim seniority?
But the respondent number 6 name appeared in the Adhikshakaru column, my lord, the superintendent.
Correct, brother. This annexure D is only a temporary arrangement. ಕಾರ್ಯ ವ್ಯವಸ್ಥೆಗಾಗಿ ನಿಯೋಜನೆ ಮಾಡುವ ಕುರಿತು.
Later,
ನಿಯೋಜನೆ.
Annex F also they have issued, my lord.
ಹಾ,
Page number 16.
ಹಾ.
ಶ್ರೀ ಜಗದೀಶ್ ರೆಡ್ಡಿ ಹಿರಿಯ ಸಹಾಯಕರು ಲೆಕ್ಕ ವಿಭಾಗ ವಲಯ ಕೃಷಿ ಸಂಶೋಧನಾ ಕೇಂದ್ರ ಕಲಬುರಗಿ ಇವರಿಗೆ ನಿಯೋಜಿಸಿದ ಲೆಕ್ಕ ವಿಭಾಗದ ಸಂಪೂರ್ಣ ಎಂಟೈರ್ ಚಾರ್ಜ್ ಮೇಲೆ ಸಂಪೂರ್ಣ ಪ್ರಭಾರವನ್ನು ಶ್ರೀ SK ಬಿರಾದರ್ ಅಧೀಕ್ಷಕರು ಸಾಮಾನ್ಯರವರಿಗೆ ತಕ್ಷಣದಿಂದಲೇ ವಹಿಸಿಕೊಡಲು ಆದೇಶಿಸಲಾಗಿದೆ.
ಹೌದ್ರಿ. ಜಗದೀಶ್ ರೆಡ್ಡಿ ವಾಸ್ ಆಲ್ಸೋ ಎ ಡೆಪ್ಯೂಟೇಷನಿಸ್ಟ್. ಜಗದೀಶ್ ರೆಡ್ಡಿನೂ ಡೆಪ್ಯೂಟೇಷನ್ ಇದ್ರು. ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು 4th in the seniority.
Yes.
You are 4th in the seniority. Next ಪ್ರಮೋಷನ್ ಬರಬೇಕು ಅಂದ್ರೆ ನಿಮ್ಮೇಲೆ 3 ಜನ ಇದ್ದಾರೆ. How can you claim the post of superintendent?
I am claiming the post of senior assistant, my lord.
Senior assistant, but ಇವಾಗ annexure D ನಲ್ಲಿ ಮಾಡಿರೋದು ಯಾವುದು? annexure D ನಲ್ಲಿ ಮಾಡಿರೋದು ಯಾವುದು? ಅಧೀಕ್ಷಕರು is superintendent.
Here in Annex F, my lord.
First
senior-
annexure D ಓದಿದ್ರಾ?
Yes.
annexure D ನಲ್ಲಿ ಏನಂತಿದೆ?
Yes.
ಅಧೀಕ್ಷಕರು.
Yes.
ಅಂದ್ರೆ ಬಿರಾದರ್ ಅವರು ಅಧೀಕ್ಷಕರಾಗಿ ಕಲಬುರ್ಗಿ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆ 2013 ಇಲ್ಲಿಗೆ ಡೆಪ್ಯೂಟೇಷನ್ ಕಳಿಸಿದ್ದಾರೆ. ನಿಮ್ಮನ್ನ ಕಳಿಸ್ಬೇಕಿತ್ತು ಅಲ್ಲಿಗೆ ಅಂತ ಹೇಳ್ತೀವಿ. ಪ್ರಮೋಷನ್ ಪೋಸ್ಟ್ ನೀವು ಎಂಟೈಟಲ್ಡ್ ಅಂತ ಹೇಳ್ತಿದ್ದೀರಿ.
Yes.
ನಿಮ್ ಮೇಲೆ 3 ಜನ ಇದ್ದಾರೆ. ಅವರು ಎಂಟೈಟಲ್ ಫಾರ್ ಪ್ರಮೋಷನ್.
But his name not at all mentioned in the senior assistant column, my lord, whose name appeared in the superintendent column as per Annex C, my lord.
What is your case ಹೇಳಿ? You want a promotion to the post of superintending?
No. Senior assistant post.
ನೀವು senior assistant post ಅಲ್ಲಿ ಇದ್ದೀರಿ ಆಗ್ಲೇ. ಇದ್ದೀರಲ್ವಾ?
No. Assistant, he is working as a assistant senior, my lord.
ಸೀನಿಯರ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂತ annexure 13 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, page 13 ಅಲ್ಲಿ. ಹನುಮೇಶ್, serial number 4. He is a senior assistant.
No, my lord. This is the seniority list issued by the respondents, my lord. The petitioner's name appeared in the said list in column of senior assistant, but he not at all taken that charge as a senior assistant, my lord. Petitioner. That is the grievance of the petitioner, my lord.
Yes.
ಅವ್ರ ಹೆಸರು ಮೆನ್ಷನ್ ಆಗಿದೆ ಇದರಲ್ಲಿ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಮೆನ್ಷನ್ ಆಗಿದೆ, ಬಟ್ ಆ ಪೋಸ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅವರಿಗೆ. ಇವ್ರಿಗೆ ಕೊಡೋ ಬದಲು ಸೊ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. As per order dated 9/1/25, my lord, the entire charge.
Please read annexure E.
ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದ ನಾನು ಕಳೆದ 6 ತಿಂಗಳ ಹಿಂದೆ ವರ್ಗಾವಣೆಯಾಗಿ ಬಂದಾಗಿನಿಂದಲೂ ಉದ್ದೇಶಪೂರ್ವಕ ನನಗಿಂತ ಕಿರಿಯ ಸಿಬ್ಬಂದಿಗೆ ಉನ್ನತವಾದ ಹುದ್ದೆಯನ್ನು ನೀಡಿ ನನ್ನ ಮೇಲೆ ದಬ್ಬಾಳಿಕೆ ಮಾಡುತ್ತಿದ್ದು ಇಲ್ಲಿಯವರೆಗೆ ಸಹಿಸಿಕೊಂಡಿದ್ದೆ. ನನ್ನ ಲೆಕ್ಕ ಶಾಖೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿ ಆರೋಗ್ಯ ದೃಷ್ಟಿಯಿಂದ ಸದರಿ ಶಾಖೆಯ ಕಾರ್ಯಭಾರವನ್ನು ನಿರಾಕರಿಸಿದರು. ನನ್ನ ಮೇಲಾಧಿಕಾರಿಗಳು ಅರ್ಹತೆ ಹೊಂದಿದ ನನ್ನನ್ನು ಪರಿಗಣಿಸದೆ ಉನ್ನತ ಹುದ್ದೆಯ ಸಿಬ್ಬಂದಿ ಅಧೀಕ್ಷಕರು ಸಾಮಾನ್ಯರನ್ನು ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಕರೆತಂದು ಅವರಿಗೆ ಸದರಿ ಲೆಕ್ಕ ಶಾಖೆಯನ್ನು ನೀಡುವ ಪ್ರಯತ್ನವನ್ನು ಮಾಡುತ್ತಿದ್ದಾರೆ. ಆದರೆ ಅವರು ಸದರಿ ಹುದ್ದೆಗೆ ಅರ್ಹರಿಲ್ಲ.
ಏನಂತ ಅರ್ಥ ಆಯ್ತು ಹೇಳಿ ನಿಮ್ಗೆ? What did you understand from annexure E?
ಅಧೀಕ್ಷಕರನ್ನು ಕರೆತಂದು ಅಕೌಂಟ್ ಸೆಕ್ಷನ್ ನಲ್ಲಿ ಸೀನಿಯರ್ ಅಸಿಸ್ಟೆಂಟ್ ಅಂತ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ.
annexure E ನಲ್ಲಿ ಏನ್ ಹೇಳಿದೆ ಅಂದ್ರೆ, ನಾನು ಸೀನಿಯರ್ ಅಸಿಸ್ಟೆಂಟ್ ಆಗಿದ್ದೀನಿ, ನನಗೆ ಸೂಪರಿಂಟೆಂಡೆಂಟು ಪೋಸ್ಟ್ ನನಗೆ ಕೊಡಬೇಕು, ನನಗೆ ಕೊಡೋದ್ ಬದಲು ಬೇರೆಯವ್ರನ್ನ ತಂದು ಕೂರಿಸ್ತಿದ್ದಾರೆ ಅಂತ. ಇನ್ನೊಂದ್ಸತಿ ನಿಧಾನಕ್ಕೆ ಓದಿ. ಮೇಲ್ ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದ ನಾನು ಕಳೆದ 6 ತಿಂಗಳ ಹಿಂದೆ ವರ್ಗಾವಣೆಯಾಗಿ ಬಂದಾಗಿನಿಂದಲೂ ಉದ್ದೇಶಪೂರ್ವಕವಾಗಿ ನನಗಿಂತ ಕಿರಿಯ ಸಿಬ್ಬಂದಿಗೆ ಉನ್ನತವಾದ ಹುದ್ದೆಗಳನ್ನು ನೀಡಿ ನನ್ನ ಮೇಲೆ ದಬ್ಬಾಳಿಕೆ ಮಾಡುತ್ತಿದ್ದು ಇಲ್ಲಿಯವರೆಗೆ ಸಹಿಸಿಕೊಂಡಿದ್ದೆ. ಫುಲ್ ಸ್ಟಾಪ್. ಸದ್ಯ ಲೆಕ್ಕ ಶಾಖೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿಯ ಆರೋಗ್ಯ ದೃಷ್ಟಿಯಿಂದ ಸದರಿ ಶಾಖೆಯ ಕಾರ್ಯಭಾರವನ್ನು ನಿರಾಕರಿಸಿದರು. ನನ್ನ ಮೇಲಾಧಿಕಾರಿಗಳು ಅರ್ಹತೆ ಹೊಂದಿದ್ದ ನನ್ನನ್ನು ಪರಿಗಣಿಸದೆ ಉನ್ನತ ಹುದ್ದೆಯ ಸಿಬ್ಬಂದಿ ಅಧೀಕ್ಷಕರು ರನ್ನು ವರ್ಗಾವಣೆ ಮಾಡಿಕೊಂಡು ಕರೆತಂದು ಅವರಿಗೆ ಸದರಿ ಲೆಕ್ಕ ಶಾಖೆಯನ್ನು ನೀಡುವ ಪ್ರಯತ್ನವನ್ನು ಮಾಡುತ್ತಿದ್ದಾರೆ. ಆದರೆ ಅವರು ಸದರಿ ಹುದ್ದೆಗೆ ಅರ್ಹರಲ್ಲ. ಅಂದ್ರೆ ಅರ್ಥ ಏನು? ನಿಮಗೆ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಪೋಸ್ಟ್ ನಿಮಗೆ ಕೊಡಬೇಕಾಗಿತ್ತು, ಅದನ್ನ ಕೊಡದೆ ಬೇರೆಯವ್ರನ್ನ ತಂದು ಇಲ್ಲಿ ಕೂರಿಸ್ತಿದ್ದಾರೆ ಅಂತ ಕೇಳ್ತಿರೋದು. How are you entitled to when 3 people are above you? ನಿಮ್ಮ ಮೇಲೆ 3 ಜನ ಇದ್ದಾರೆ. ನೋಡ್ಕೊಂಬನ್ನಿ ಪಾಸ್ವರ್ಡ್. Number 26, Amir Ahmad, Amja.
My lord, it is the case of appointment of Anganwadi worker, my lord.
Yes.
As per annexure, call for the post of Anganwadi helper, sir. As per annexure B, the petitioner was submitted the all relevant documents and applications, my lord.
Sir, if you want to practice in the High Court, you may have to change your way of drafting the writ petition. This is the second time I am seeing this. This is the second time. Last time petition ಏನು ಹೇಳಿಲ್ಲ. When I asked you where are the facts, you said in the prayer ಹೇಳಿದ್ದೀನಿ ಅಂತ. And this is the second time you are doing this. Please change the way you draft your writ petition. It's a request.
Okay. Sir.
It's a request.
Sir.
Yes. ಹೇಳ್ರಿ.
Sir, ಹೆಲ್ಪರ್ ಪೋಸ್ಟಿಗೆ ಕಾಲ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು ಸರ್, ಅದರಂತೆ ಪೆಟಿಷನರ್ ಅವರು ಅಪ್ಲಿಕೇಶನ್.
ನಿಮಗೆ ಇಂಗ್ಲಿಷಲ್ಲಿ ಮಾಡಕ್ ಬರ್ದಿದ್ರೆ ದಯವಿಟ್ಟು ಕನ್ನಡದಲ್ಲೇ ಮಾಡಿ.
ಸರಿ.
ಇಂಗ್ಲಿಷಲ್ಲಿ ಮಾಡಕ್ ಆಗದೆ ಇದ್ರೆ ಕನ್ನಡದಲ್ಲಿ ಮಾಡಿ.
ಸರಿ ಸರ್.
We'll accept even that. But don't try to do something and spoil the whole thing. We don't even understand what is your case. We can't even, ನಿಮ್ ಕೇಸ್ ಏನು ಅಂತಾನೆ ಅರ್ಥ ಆಗಲ್ಲ. ಹೇಳ್ರಿ
ಸರ್, ಅಂಗನವಾಡಿ ಸಹಾಯಕರ ಹುದ್ದೆಗೆ ಕಾಲ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೇವೆ ಸರ್. ಆಸ್ ಪರ್ annexure A notification ನಂಬರ್ ಕಿಶನ್ ನಾಯಕ್ ತಾಂಡಾ ಅಂಗನವಾಡಿ ಸೆಂಟರ್ ಸರ್.
ಎಸ್.
ಆಮೇಲೆ ಅರ್ಜಿದಾರರು ಪೆಟಿಷನರ್ ಅಪ್ಲೈಡ್ ಫಾರ್ ದ ಸೇಮ್ ಪೋಸ್ಟ್ ಮೇಲೆ ಆಸ್ ಪರ್ annexure B ಮೇಲೆ ಅಲಾಂಗ್ ವಿತ್ ರಿಲೆವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಬಟ್ annexure C they are remarked as a respondent. ಸರ್ಕಾರದ ಮಾರ್ಗಸೂಚಿಯಂತೆ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ಹುದ್ದೆ ನೀಡಲಾಗಿದೆ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಸರ್. ಅರ್ಹ ಅರ್ಜಿ ಬಾರದೇ ಇರುವುದರಿಂದ ಮರು ಪ್ರಕಟಣೆ ಹೊರಡಿಸಲಾಗುವುದು ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಸರ್. ನಿಮ್ಮ ಪೇಜ್ ನಂಬರ್ 22 ಮೇಲೆ.
ಪೇಜ್ ನಂಬರ್
22 ಮೇಲೆ ಅರ್ಹ ಅರ್ಜಿ ಬಾರದೇ ಇರುವುದರಿಂದ ಮರು ಪ್ರಕಟಣೆ ಹೊರಡಿಸಲಾಗುವುದು ಅಂತಂದ್ರೆ
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀವಿ ಸರ್. ಎಲ್ಲ ರಿಲೆವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಪೆಟಿಷನರ್ ವಾಸ್ ರೆಸಿಡೆಂಟ್ ಆಫ್ ಸೇಮ್ ವಿಲೇಜ್ ಮೈ ಲಾರ್ಡ್. ಆಮೇಲೆ ಎಲ್ಲ ಕ್ರೈಟೇರಿಯಾ ಫುಲ್ಫಿಲ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಆದ್ರೆ ಯಾವ ರೀಸನ್ಗಾಗಿ ಈ ರೀತಿ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ಗೊತ್ತಾಗಿಲ್ಲ ಸರ್.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ annexure B
ಬಿ ಸರ್, ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೇವೆ ಸರ್. annexure D ಪ್ರಕಾರ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೇವೆ. ಈ ರೀತಿ ನಾವು ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೆವು, ಆದರೂ ನಮ್ದು ಪರಿಗಣಿಸಿಲ್ಲ ಅಂತ.
ಗೌರ್ಮೆಂಟ್
ಪ್ಲೀಸ್
I'll go through.
AJ
the-
is drafted
at
except
least-
notice for response 1 to 5. Till objections are filed in this writ petition, comma, the respondent number 4 and 5 are directed not to
Publish,
huh?
new publication, call for it. So,
Directed not to invite any fresh application
Please.
for the post of
Anganwadi helper.
Anganwadi helper at Kishan Nayak Tanda, Anganwadi Center.
Number 27, Ganesh Nayak.
For the petitioner, please, your lordship.
ಸತಿ ನೋಡಿ ಅಮೀರ್ ರಂಜಾ ಅವ್ರೆ ಕುತ್ಕೊಂಡು ನೋಡಿ ಸ್ವಲ್ಪ ಏನೋ ಒಂದು ಕತೆ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ ಹೆಂಗ್ ಹೇಳ್ತಾರೆ. ಒಂದು ಊರಲ್ಲಿ ಒಬ್ಬ ರಾಜ ಇದ್ದ, ರಾಜಂಗ್ 3 ಜನ ಹೆಂಡ್ತಿದಿರಿದ್ರು, ಅವ್ರಿಗೆ 5 ಜನ ಮಕ್ಕಳಿದ್ರು, ಮಗ ಒಬ್ಬ BA ಒಬ್ಬ MBBS, ಹಿಂಗ್ ತಾನೇ ಹೇಳೋದು. ಕತೆ ಹೇಳೋದು ಹಂಗಿರ್ಬೇಕು. ದೇ ಶುಡ್ ಬಿ ಸೀರಿಯಾಟಮ್. ನೀವು ಡೇಟ್ ವೈಸ್ ಜೋಡಿಸ್ಕೊಳ್ಳಿ ಅಂತ ಅದಕ್ಕೆ ಹೇಳೋದು. ಪ್ಲೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನ ಡೇಟ್ ವೈಸ್ ಜೋಡಿಸ್ಕೊಳ್ಳಿ. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರಕಾರ ಯು ಕ್ಯಾನ್ ಗೋ ಆನ್ ಡಿಸ್ಕ್ರೈಬಿಂಗ್ ಇಟ್ ಇನ್ ದ ರಿಟ್ ಪಿಟಿಷನ್. ದೆನ್ ಓನ್ಲಿ ಯು ವಿಲ್ ಗೆಟ್ ಎ ಕ್ಲಿಯರ್ ಫ್ಲೋ. ಒಂದು ಫ್ಲೋ ಇರಬೇಕು.
Serial number 27, my lord, appear for the petitioner, my lord.
Yes.
My lord, in this matter, the compass of facts is very short. The petitioners are drivers under the Arogya Kavacha scheme, 108 ambulance scheme, my lord.
Yes.
There are 711 ambulances running throughout the state of Karnataka.
Yes.
The petitioner's grievance is that their minimum wages and wages have not been paid on time.
No, but there is
After
some
the filing
direction.
of the writ petition,
No,
2
I
months
passed some
paid.
direction. No, please wait.
Yes,
I
my
passed
lord.
some direction in Bangalore, principal court, principal bench.
My lord, the petitioners are from Bijapur and Bidar, my lord.
Now, the same rule will apply to everybody. The same rule will apply to everybody. Some
Yes, my lord.
20,000 rupees. 25,000 ಸಾವಿರ ಏನೋ ಕೊಡ್ಬೇಕು ಅಂತ ಮಾಡಿದ್ದೀನಲ್ಲ.
Very well, my lord.
Please go through that order.
Yes, my lord.
AG has directed accept notice for respondent number 1.
Only one respondent, my lord.
Please check that order.
Yes, my lord. Oblige, my lord.
Next.
29, Basav Kiran.
28.
Please.
28. Arun Kumar. Basu Kiranalla.
28.
Arun Kumar Amargundu.
Is this petition some other day, madam? Yes, next. Land council for the petition seeks time. List on.
29.
Is Basu Kiran.
Please, madam.
Government.
My lord, I inquired, financial bid is not yet open, my lord.
What about financial bid is not opened?
Not open, my lord.
Then
16/1 it is date, my lord, tentative date they have given. I inquired, they are not open finance.
why don't you accept his bid then?
Direction may be,
Physical bid tagoli.
yes,
Will permit him to submit a physical bid. You consider it and make appropriate.
direction may be issued. I will
Good.
intimate.
The petitioner has challenged the petitioner sought for writ in the nature of certiorari to quash point number 6 of the point number 6 of the technical bid relating to turnover and contends that Similar condition in annexure G, other department. and contends that the necessary experience for supply of food items shall be equal to the tender amount. And that the tenderer shall submit a separate experience certificate for the year 2019-20 to 2023-24 for the past 5 years. He submits that the respondents have granted only 10 days time,
Please, my lord, on
Granted 10 days time to furnish the credentials, which is inadequate and is designed to accommodate a few tenderers. Full stop. He submits that similar conditions
At annexure F, my lord, the tender issued by the ST Welfare Department.
at tender conditions, he submits that a similar tender issued by the
Scheduled Tribe Department.
department.
At page 65, my lord, serial number 16.
ಅದೇನು ಸ್ಟೇ ಆಗಿದೆಯಾ ಏನದು?
My lord,
Whether it is stayed,
this order, my lord.
page
I-
65, is it stayed or what? Why are you referring to page 65?
Only to show that the condition has been relaxed in other tenders, but not in this.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು?
30%.
Comma, the clause,
Clause,
the the turnover is reduced to 30%. Therefore, he contends that
for any 1 year, my lord,
30% for any 1 year.
in foods.
Full stop. In view of the aforesaid, he submits that he was not in a position to submit his bid. Thus, he has sought for an interim prayer to direct the respondents 2 and 3 to relax point number 6. And grant additional time of 2 weeks for submission of the documents and allow him to participate in the tender process. Next para. Since the petitioner claims that he is qualified to participate in the bid and that he was not in a position to
Secure order.
secure the documents to meet the eligibility criteria, it deserves to be granted to the petitioner to participate in the bid. Full stop. Hence, by way of an interim order, the petitioner is permitted to participate in the bid by submitting the requirements within a period of 2 weeks,
Please,
10
madam.
days.
10 days is in.
Within a period of, ಯಾವತ್ತು issue ಮಾಡಿದ್ದು notification? When was the notification issued?
It was on 30/12, my lord.
So it's already more than a month. By now you must have got it.
There was a delay because of,
Correct, but notification is 30/12.
yes, my lord.
So you must have got all the documents by now.
I'll submit within a week, my lord.
Within week, within
Is
3 days.
Because
Within
my
3
lord,
days from today.
I'm also currently supplying to the same
Full
department.
stop.
Yes,
If the petitioner is permitted to submit a physical, the tender in the physical form, and the respondents 2 and 3 are directed to accept it and verify the technical bid as well as the financial bid in accordance with law. Yes.
much obliged. I may be permitted,
However, subject to the result of this writ petition.
Your lordship, I may be permitted to issue memo for hand delivery.
Yes, please. Yes, Ravindra Reddy.
Number 13, Ravindra Reddy.
Ah, But petitioner was working as a second division clerk in the respondent office. Lord. hmm.
He was appointed in the year 2009. Since 2009, my lord, he was working, and during COVID period, my lord, circular was issued by the society that office will be closed and the staff was not.
Take out notice, issue emergent notice.
Rupa Sagar is
Yara idara?
appearing for society.
Rupa Sagar Patil is directed to
yes.
accept notice for the respondents.
Yes, only respondent.
Respondent, yes. Lakshmi ji.
Number 31, Lakshmi ji.
Please.
My lord, petitioners are working in the school of the sixth society, my lord, sixth education society. Since from 1980, petition number 1 is working from 1995. Aid is granted from the government, my lord. In the year 2023, 9/2023, they declared that the two teachers are the excess teachers, my lord. Since from they have not released the salary to the petitioners and they have not deputed the petitioners to other needed school, my lord. The government.
I will take
AG is
instruction.
directed to accept notice for respondent. Mahantesh Patil.
Number 32, Mantesh Patil.
The petitioners are plaintiff in the suit for declaration and for injunction and cancellation of the registered sale deed.
Yes.
An application was filed for cross-examination of DW1.
Yesterday opportunity put.
ಒಂದೇ ಸಲ ಅದು ಫರ್ದರ್ ಕ್ರಾಸ್ ಅಂತ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ರೆಫರ್ ಆಗಿ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ.
Notice in addition, the learned counsel for the petitioners is directed to serve the learned counsel who represented the respondent before the trial court. Till the next date of hearing, further proceedings before the trial court is stayed.
Our next matter, my lords, have challenged the same suit, the rejection of IA for framing additional issues. It may be notice may be issued since.
Rejection of?
Lords, IA for framing additional issues.
ಯಾವ stage file ಮಾಡಿದ್ರಿ?
ಅದು
At what stage you filed this application?
Lords, I filed after examination of evidence.
What kind of issues, mister? There's a sale deed, there's a consideration. Where's the question of defendant proves that the consideration passed to the plaintiffs under the sale deeds? You say that consideration did not pass. Negative ಹೆಂಗ್ ಹೇಳ್ತೀರಿ?
Allah, they specifically stated that my awareness is that there was no consideration was passed.
So you have
They
to prove,
come up with the defense that they
so you have
that
to
is
prove
denied.
that no consideration passed under the sale deed. Don't prove the possession of land should deliver to him under the sale deed.
Possession of the suit lands delivered to him under the sale.
You are the one who has executed the sale deed.
As per their say.
Mother?
We are denying that, not we have specifically pleaded in.
Wait, where's the question of these issues? Whether the defendant proves that the possession of the suit lands were delivered, whether the defendant proves consideration was paid, ಹೆಂಗ್ ಬರುತ್ತೆ issues?
They come up with a specific plea that on the date of the execution of the registered sale deed, there was a delivery of possession and no consideration was passed.
Barkul. The plaintiffs in OS number 19 bar
Respect of the same suit, earlier your lordships have issued the
2019 on the file of the senior civil judge and JMFC Devdurga. I have filed this petition challenging an order dated so-and-so by which their application under Order 14 Rule 5 of CPC was rejected. Next para. The suit in OS number 19 bar 2019 was filed for
page 28.
declaration that the plaintiffs are the owners of the suit real properties and to restrain the defendant from interfering with their possession. They also sought for a direction to deliver possession of the suit property to the plaintiffs. ನೋಡಿ ಎಲ್ಲ ನೀವೇ ಕೇಳ್ತೀರಾ. And to direct the defendant to pay mean profits. And also to cancel the sale deed dated 17/3/2017 and
ಎರಡು sale deed
cancel the
17/3/2017.
two sale deeds dated 17/3/2017 and to delete the name of the defendant from the revenue records. Next para. The plaintiff claimed that
Para 8 and 11 of the
plaintiff
plaint.
claimed that they are the owners of the suit shell properties. Plaintiffs claim that they are the owners of the suit shell properties and that the defendant took them to the office of the sub-registrar on 17/3/2017 under the pretext of executing mortgage deeds, and that the plaintiffs, believing his words, executed a document which later turned out to be a sale deed. Full stop. The plaintiffs therefore sought for the aforementioned reliefs. Full stop. The suit was contested by the defendant, who denied the contentions of the plaintiffs and claimed that the plaintiffs had conveyed the suit property for valid consideration and had also delivered possession of the suit property. Full stop. Based on these contentions, the trial court framed the following issues, page 31. Full stop. When the suit was set down for cross-examination of defendant,
Huh? 29, 10, 24.
So don't for
Completion of
cross-exam-
cross.
First stage ಹಾಕಿದ್ದು
20, 29, 11, 24.
when the suit was set down for
Arguments.
when the suit was set down for reply arguments of the defendants, an application was filed by the plaintiffs under Order 14 Rule 5, suggesting the following issues. Copy mode. Page number. Or different arguments time ಹಾಕಿದ್ದೀರಾ?
Not start. If, under Order 14, there is a provision not even after judgment, even the matter is posted for judgment, the court can.
Okay, Mr. Hold it. Page 33, following issues. This application was contested by the defendant on the ground that the same was filed at a belated stage and that there was no justification for the issues that was suggested. Full stop. The trial court rejected the application in terms of the impugned order on the ground that the application was filed at a belated stage of the proceedings.
Illa para 7.
So, and also that the proposed issues did not arise for consideration, as the issue regarding passing of consideration on the sale deed is already framed as issue number 4, and the handing over of possession of the suit property was also framed under issue number 2. Being agreed with the said order, the plaintiffs are before this court. Next, for the learned counsel for the plaintiffs contends that the plaintiffs have denied the receipt of consideration from the defendant as well as handing over possession of the suit property to the defendant. Therefore, these two issues arise for consideration and were not framed by the trial court. Next para. The perusal of the plaintiff as well as the written statement shows that the plaintiffs claimed that they had executed the agreement under the bona fide impression that what was executed was a mortgage deed and not a sale deed in favor of the defendant. Therefore, they were bound to prove the said fact. And also the fact that they did not receive any consideration under the sale deed. The question of placing a negative burden on the defendant to prove that possession was not handed over, possession was handed over under the sale deed, and that consideration was paid under the sale deed. More particularly, when there was an averment in the sale deed regarding delivery of possession and also paying the consideration. This apart, in the relief sought for in the suit, the plaintiffs had sought for recovery of possession of the suit property from the defendant. Therefore, the issue suggested by the plaintiffs really did not arise for consideration, as issue number 2 and 4 framed by the trial court sufficiently covered the issues suggested by the plaintiffs. Hence, the trial court is justified in not entertaining the application filed by the plaintiffs warranting interference in this writ petition. Hence, the petition lacks merit and is dismissed.
Findings, the trial court should not influence, my lords, any find.
It is needless to mention that the trial court shall not be influenced by any observations made herein above while disposing the suit on merits.
ಸರ್ ಎಷ್ಟನೇ ಮ್ಯಾಟ್ರಲ್ಲಿ ಸ್ಟಾಪ್ ಆಯ್ತು ಸರ್ ಅದು ಡಿಸ್ಪ್ಲೇ ಬೋರ್ಡ್ ವರ್ಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಸಾರಿ.
ಡಿಸ್ಪ್ಲೇ ಇದೆಯಲ್ಲ ಸರ್?
ಇಲ್ಲ ನಮ್ಗೆ ಇಂಟರ್ನೆಟ್ ಅಲ್ಲಿ ನಾನು ಬೆಂಗಳೂರು ಬೆಂಚಿಂದ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀನಿ, ಇದರಲ್ಲಿ ನಮಗೆ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಅದಕ್ಕೆ.
33 ವರೆಗೆ ಆಯ್ತು ಸರ್ ಈಗ.
33 ಸರಿ, ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಸರ್ ಕೋರ್ಟ್ ವಿಡಿಯೋ ಆಫ್ ಆಗಿದೆ ಸರ್.
institution has not submitted satisfactory compliance with the following. That is, 1, faculties are not appointed as per norms, 7 faculties are deficient as per norms. And in the approval status, they say approved, my lords. So though they have given for the same norm, my lord, for the second year also the same norm, first year also same norm, but they have forbidden me from taking admission for first year. May I First year. take my lordship notice too? For the first year, you stopped. They have stopped. Second year, I have asked to continue. And I have compared 7 deficient, what they have said. My Where have you lordship, complained? please, minutes. At page number 69, What is the date of this order? 9/12. 9th December. 9th December. Where have you complained? Immediately next page, 80. Annexure E. Ah. Submission of compliance on 9/12 itself. Faculties are not appointed as per norms for the deficient. And specific compliance, faculty details are submitted with the details as per Annexure 1 format of PCI, along with all documents and certificates. D-Pharma course under section 12 is already started in 2024. There are 15 faculties appointed and 7 faculty consent have given. Annexure 1, I have annexed all the details of 22. So they say 15 Let are them verify Barkul. ಯಾವಾಗಿಂದ ಶುರು ಆಗುತ್ತೆ? In fact, my lord, shuru agadali 24-25 academic course is already over. The one thing which is coming in the way is they have issued, the RGHS has issued calendar of events. In the calendar of events, my lords, the last date for admission is 30th/11/24, my lords. They have communicated me on 9/12, my lords, the But deficiencies. that date is already over. Yes, and 9/12, they have communicated me itself on 9/12, my lords. My lordship, I Okay. kindly see. You know, that year is over, academic year is over. Academic year is not over, my lords, with, Last date is November. yes, my lords. November ಆದ್ರೆ ಆಗೋಯ್ತಲ್ಲ. ಆಗಿದೆ, ಆದ್ರೆ ಅವ್ರನ್ನ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿರೋದು 9th ಡಿಸೆಂಬರ್ಗೆ. Correct. Whatever is over is over. They can, my lords. How can you now admit students for the year 2020? Already counseling was in September, my lords. Already 8 students are given in the counseling, my lords. They are with me only. Only because despite I have complied, my lords, that was I was about to show, despite I have complied in time, my lords, they have not permitted me for the first year course. Mr. Sudhir Singh Bijapur, Not Sudhir Singh, my lord, SS Haveri, SS. SS Haveri, PCI, SS Haveri is there to accept notice for PCI,
Respond number 1,
R1.
AJ for respond number 2, RGHS,
Busare,
Mr. Busare for R3. List on when do you want it?
Monday, Tuesday.
Monday, Tuesday, ಎಲ್ಲ ಆಗುತ್ತೆ ma'am.
1 minute, I'll take only 1 minute of my lordship. Page number 62. The procedure is that, my lord, I had to submit a SIF standard inspection report. And in that format, I have already submitted. And they conduct inspection, my lord. The Pharmacy Council of India will send 2 inspectors for inspection, my lords. My lordship could find at page number 62. After conducting physical inspection by the professor sent by PCI, my lords, what they have said, the remarks given, the declaration at the end, my lord, they have given declaration along with their signature and photo. We hereby declare that we have successfully completed inspection at Shetty Institute of Pharmaceutical Sciences, Shabad Road, so-and-so, Karnataka date. There are no remark, no deficiency, my lords.
They only successfully completed the inspection. But
ಹಾಗಲ್ಲ.
December ಅಲ್ಲಿ ಹೇಳ್ತಾರಲ್ಲ.
ಇಲ್ಲ, ಅದು ಹಂಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ ಈ ಪಕ್ಕದಲ್ಲೇ ಅವರು ಡೆಫಿಷಿಯನ್ಸಿ ಅಂತ ಬರೀತಾರೆ. ಎಂಟೈರ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ರಿಪೋರ್ಟ್ ಇಫ್ ಇಟ್ ಇಸ್ ಸೀನ್, ಮೈ ಲಾರ್ಡ್ಸ್, ದೇ ಸೇ ಅವೈಲೇಬಲ್ ಅಂತ.
List on ಯಾವತ್ತು? When do you want it? When do you want it?
If my lordship could stay that grant order which was communicated me on 9/12, my lords.
Please, when do you want it? ಅದು verify ಮಾಡ್ಸೋಣ. If you have complied, then we'll grant the permission itself.
Please, at the earliest,
List on 10 days ಬಿಟ್ಕೊಡಿ.
please, grateful.
30th, 10 days ಯಾವತ್ತು? 10 days ಆದ್ಮೇಲೆ ಕೊಡಿ. ಹ್ಮ್. 6th
Great.
February. Yes.
Meanwhile, my lord, I would have insisted for the.
Stay ಕೊಟ್ಟು ಏನ್ ಮಾಡ್ತೀವಿ? You can't admit.
ಇಲ್ಲ, I can't admit. ಬಂತು ಅಂತ at least students academic year ಮಾಡಿದ್ಮೇಲೆ ನನಗೆ admission ಬರಲ್ಲ.
6 days ಅಲ್ಲಿ ಏನಾಗಲ್ಲ.
Great.
Yes.
Serial number 10 also, my lord, similar, which was passed over.
Seal number?
10. Pass over.
You can dispose of the writ petition in case if they're satisfied with the staff. If it is ಬಂದ್ ಮಾಡಿದಾರೆ ಅಂದ್ರೆ we can allow the petition itself.
Please, my lords.
Seal number 10 ನಾ?
ಅದನ್ನು ಸೇಮ್ ಅಂತ ಮಾಡಿದ್ವಿ. Please, council submit, office objections,
Office
number
objections,
21
let
and
me learn.
22 is overruled.
Page number 23. What they say,
I think Mr.
wrong spelling is
so-and-so
uploaded.
is accepted, directed to accept notice for so-and-so, same. List this petition along with serial number.
This is quite, this is D pharma, my lord, where calendar of events are not fixed. There, my lord, they have mentioned the
Same
cut-off date.
facts ಅಲ್ವಾ?
Fact same ಇದೆ, ಇದರಲ್ಲಿ ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಮಾಡಿಲ್ಲ. ಅಂದ್ರೆ ಅಡ್ಮಿಷನ್ ಮಾಡಬಹುದು ನಾನು, ಅದರಲ್ಲಿ ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಆಗಿದೆ. One thing.
On same date ಕೊಡಿ. 6/2.
This is D pharma. Tomorrow, if they conduct EC meeting, my lord, if they issue calendar of events, ನಂಗೆ admissions ಬರಲ್ಲ. ಅದರಲ್ಲಿ already EC meeting
ಮಾಡಿ
ಆಗಿದೆ.
ಮೇಡಮ್, ಹಾಗೆ ಮೂವ್ ಮಾಡಿ. Yes, next.
ಇಲ್ಲ.
You can
Let-
move it after that, after the calendar of meeting ಏನೋ ಮಾಡಿ ಇದು ಮಾಡಿ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಸ್ಲೈಟ್ ಡಿಫರೆನ್ಸ್ ಇದೆ ತಗೊಂಡು.
ಇದೆ.
My lordship, may kindly turn to impugned reject letters at page number 507. 507.
507.
507. Annexure of my lords. My lordship would find this is reject letter wherein they have said these are the deficiencies. These are the stereotype type common deficiency despite I have complied everything, my lords. One, faculty and principal details like qualification, joining report, experience certificate, central council number, etc. not available. Faculty having B Pharma qualification does not available. 3 years of experience. Compliance documents are not properly named and deficiencies are not complied as per letter. Laboratory details like infrastructure, QR code, geo, so-and-so, SOP are not available. In view of the above, it was decided to reject. My lordship, may kindly turn to 508. Same copy-paste deficiency, despite they were not the deficiency quoted by them in the earlier edition letter minutes. And my lordship, may kindly turn to 509 minutes. That is also same thing. That is faculty details, qualification, joining report, experience certificate are not available. Compliance is not signed and stamped with the competent authority. Faculty having B Pharma qualification does not have 3 years of experience. Laboratory details like infrastructure, QR code, geo photographs are not available.
These are 3 separate colleges.
All 8 colleges, my lords. These are all 8 colleges, 8 rejection letters I am reading, my lords. And another page, my lords, 510. Again, copy paste stereotype objections, my lords. Even 512 also. All these reject letters, my lords, they are one and the same stereotype, but which are not the objections which were raised by them earlier round, my lords.
But how can you disbelieve them?
Disbelievable.
Just because it is stereotype, how can you disbelieve them?
Why? Because they themselves have furnished me the decision letters, my lord, for compliance, and I have already complied. And they were not at all the objections which were raised by them earlier, my lords. ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ ರಿಜೆಕ್ಟ್ ಮಾಡಿರೋ ತರ ಕಾಣ್ತಾ ಇದೆ.
We can't interfere in all these matters.
If the decision letters are seen, my lords, they are different. And my lordship may kindly see page number.
Sorry, madam. Yes.
1 minute, my lords. 1 minute. Inspection report at.
Inspection report at?
Report at page number 2. In the inspection, they say we have successfully completed and they can continue the page number 298. Today we have inspected the Rajkumar Kamble Memorial College, Kalaburagi, and verified availability of facilities as mentioned by the institution. In SIP, there were 6 faculty count, out of which 1 was on leave and 5 were present. We found 2 classrooms and 5 laboratories available. We completed inspection successfully as per the guidelines for inspections. No deficiencies here also.
This is only for completion of the inspection. What is the date of this inspection?
This is
10/24.
what they say, my lord. This is where they'll furnish the deficiency also in the same report, my lords. In the report, they say, my lordship can, if the complete inspection reports are seen, my lords, they say everything is available and they have supplied all the documents required, my lords. There, my lord, they have not mentioned any deficiency when the physical inspection was conducted by them on that day, my lords. Even it could be seen in page number 290 also, my lords. I hereby declare that inspection is completed, checked, verified, upload documents as per available information in the PCI mobile application. And my lordship could kindly turn to page number 283, my lords. Complete inspection, verification of all the documents, infrastructure, it is as per the norms. 2 faculties have left and new faculties have been appointed and were physically present. In conclusion, the institution has complied PCI norms with respect to infrastructure instrument, faculty library, etc. Inspection completed. And again, they have mentioned in the decision letter saying that, my lord, these are all not available. Whereas in the inspection, physical inspection conducted, they have mentioned this as, my lords.
Yes.
And lordship could kindly turn to page number 275, my lords. I declare that the college have 275. I declare that the colleges have adequate facilities, but salary pay slips not available. Fire safety equipment is there, but fire safety certificate is not available. So such deficiency is not available with other colleges which I have read, my lords. And despite of it, my lord, they supply me another decision letter saying that, and my lordship could kindly come to 264 page number.
No, but that is okay, but what is there to show that
Please, my lords.
these decisions which are passed,
Yes,
how do you say that those are all not correct?
because it is their own, the PCI which respond number 1, my lords, the inspecting authorities are also from 264, my
Let's
lords.
find out is. Same on. List down on 6th February. Yes. Seal number? Yes, Nitesh Padiyal,
I appear for the petitioner.
you ready?
Yes.
R.V. Nadagowda, Ratna Shivayogi Mutt. Oh,
My lord, the petitioner was appointed initially in the year 1992, my lord. Thereafter, my lord, in the year 1997, they have issued with the charge sheet, my lord. And again, they have conducted the inquiry. Thereafter, my lord, the petitioner, while working, my lord, he has not issued the ticket of out of 80 passenger, my lord, 24 passenger, the petitioner has not issued the tickets, my lord, in spite of their allegation is, my lord. Thereafter, my lord, they have conducted the inquiry, and the inquiry, the officer found the employer guilty, my lord, and they have dismissed from service. After the dismissal of the petitioner, my lord, the petitioner was approached the labor court. The labor court held the department inquiry fair and proper, my lord. Again, my claim petition was rejected, my lord. Thereafter, my lord, the labor court is not considered, my lord, a section 11A of the Industrial Tribunal Act, my lord, wherein the discretion power is to given the labor court, my lord. The same was not considered by the labor court, my lord. And again, my lord, the labor court recorded the evidence, my lord. I have committed the past 50 cases, my lord. Wherein, my lord, this honorable court has held that, my lord, there is a may pass on judgment on the data.
First facts, judgment
Yes,
go.
yes. The labor court has rejected my claim petition on the ground that, my lord, I have committed a past 15 cases, my lord. These are the facts of the case, my lord.
Yes.
Again, I approached this honorable court, my lord, on the ground that, my lord, I have the labor court erred the, my lord, considering this like section 11A of the Industrial Tribunal Act, my lord. The only, kindly, section 11A of the Industrial Tribunal, my lord. The petitioner not committed any heinous crime, my lord. They have punished me with a capital punishment, which was not permissible under the law, my lord.
Capital punishment.
My lord, in the service and jurisdiction law, the capital punishment is the dismissal. They have issued me with the capital punishment, my lord.
No, but you are the one who has to collect the money from the public
Yes, my lord.
and give it to the corporation. ನೀವೇ ಒಳಗಾಕೊಂಡ್ರಿ.
My lord, true, my lord, but the thing is, my lord.
Corporation runs on the conductors.
Yes.
The entire corporation runs on the conductors.
Yes.
It runs on faith and
The punishment which was imposed me, my lord, is disproportionate, my lord.
how,
My lord,
How many
other than,
passengers-
my lord, other than they, if they desire, my lord, other than that dismissal from the service, they can impose any other punishment like that, censure or
many
withholding
cases?
increment.
past cases ಎಷ್ಟಿದೆ madam?
Yes,
For 50,
50,
50 past cases.
yes.
yes, ma'am.
What have you produced? Have you produced memos issued?
They have not,
50 past cases ಏನ್ proof ಕೊಟ್ಟಿದ್ದೀರಾ?
Charges, ma'am.
ಇದೆಯಾ?
not with, they have given,
I'll
Huh?
collect the records, maybe I'll collect.
ಅಲ್ಲ ಮೇಡಮ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರಾ ಲೇಬರ್ ಕೋರ್ಟ್ ಮುಂದೆ? Have you produced anything to show that they were past cases?
yes, my lord, they have penalty receipt they have filed before the labor court.
Huh?
Ink page 25, my lord,
Huh.
exhibits wherein they have filed it, my lord.
Penalty receipt.
Penalty receipt.
Give me 1 day time, collect the originals, my lord, they were the exam.
Madam, 2011
Yes,
petition.
yes, ma'am. ಅದು ಇವತ್ತು amendment of cost rate ಅಂತ ಬಂದಿತ್ತು. I have an
Right to-
impression that it may be as ಅದಕ್ಕೆ ಬರ್ಬೋದು ಅಂತ.
Then
ಅದು ಸರ್ವಿಸ್ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ, it is amendment of cost rate ಅಂದಿದ್ರು ಅದಕ್ಕೆ.
then counsel for the respondent seeks time to secure documents list on.
Yes, ma'am.
Ramchandrake.
My lord, the grievance of the petitioner is that he is working in the Krishi Vignana Kendra Kalaburagi in payable section as a senior assistant. The respondent number 7 working in the cash section, my lord. So the respondent number 6 is working in Begudi, my lord, Krishi Vignana Kendra. So the grievance of the petitioner is that from outside, the respondent number 6 is working as a superintendent, he is not a senior assistant. As per seniority list, the petitioner is entitled to the said post, my lord, in the place of respondent.
Entitled ಅಂದ್ರೆ ಹೆಂಗೆ?
But he is already working in the Kalaburagi Krishi.
3 people above you ಅಲ್ಲ? There are
But
3.
they are working in Raichur, my lord. In Kalaburagi, he is working as a senior assistant in a payable section. As per my client instruction, my lord, for cell phone I have received. However, he is working in the Kalaburagi Krishi Vignana Kendra as a senior assistant. From outside, the SK Biradar is working in Begudi, my lord, as a superintendent, not senior assistant. Your grievance ಇಷ್ಟೇ. So ಹೊರಗೆ as a ಅಧೀಕ್ಷಕರು ಅಂತೇಳಿ ಕೆಲಸ ಮಾಡೋರ್ನ ಇಲ್ಲಿಗೆ ತಂದು ಸಹಾಯಕ.
ನನಗೆ ಅರ್ಥ ಆಯ್ತ್ರಿ, ನಿಮ್ ಬೆಳಿಗ್ಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. ಇವಾಗ ಇವರು ಬಿರಾದರು ಅಧೀಕ್ಷಕರು ಸಾಮಾನ್ಯ ಅಂತ ಇದ್ದಾರೆ.
Yes.
ಎಲ್ಲಿಗೆ ಬಂದಿದ್ದಾರೆ? Has he come to ವಾಡ್ಗಿ?
As per Annexure F, my lord.
ರದ್ದೆ ವಾಡ್ಗಿ.
Annexure F, my lord, the ಜಗದೀಶ್ ರೆಡ್ಡಿ ಅವರ ಪ್ಲೇಸಿಗೆ SK ಬಿರಾದಾರ್ ಅವರು ಅಧೀಕ್ಷಕರು ಆಗಿದ್ದು ಈ ಅಧೀಕ್ಷಕರು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬೀಗುಡಿಯಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅವರು.
ಹೌದು.
ಅವ್ರಿಗೆ ಯಾಕೆ ಇಲ್ಲಿ ಕರೆಸ್ಬೇಕು? ಆಲ್ರೆಡಿ
ನಿಮಗೆ ಕೊಡ್ಬೇಕಾಯ್ತು ಅಂತ.
ಎಸ್. ಈಗ ಅವ್ರದ್ದು ಟೋಟಲ್ ಚೇಂಜೇ ಇದೆ. The respondent number 6 name appeared in the column of superintendent is totally different.
ಕರೆಕ್ಟ್ ಅಪ್ಪ, ನೀವ್ ಹೇಳಿದ ಅರ್ಥ ಆಯ್ತು.
Yes, my lord.
Superintendent is sought to be placed in the post of senior assistant.
Yes.
Superintendent ಹೈಯರ್ ಪೋಸ್ಟ್ ಅಂತಂದು ಕೆಳಗಿನ ಪೋಸ್ಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಇನ್ಚಾರ್ಜ್.
Yes.
ಅದನ್ನ ನೀವ್ ಹೇಳ್ತಿರೋದು.
Yes, ಅವ್ರಿಗೆ ತರೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. However, I am working in the Gulbarga University as a senior assistant ಅಂತ ನಮ್ದು ಗ್ರೀವೆನ್ಸ್ ಅಷ್ಟೇ, ಅದು ಬಿಟ್ಟು ಬೇರೆ ಇಲ್ಲ.
ಇವ್ರು ಯಾರು? ಬಸವರಾಜು, ಮಲ್ಲೇಶ್ ಬಿ ಅಸ್ಕಿಹಾಳ.
They are working in Raichur, my lord, Krishi Vignana Kendra, Raichur.
So in Kalaburagi Krishi Vignana Kendra, I am working as a senior assistant. Let me order to take charge in the place of respondent number 7. That is the grievance of petitioner, my lord.
Yes, government, yaru,
University is contesting.
AGS directed to accept notice for respondent number 1.
Please.
Yaar US yaru,
Mantesh Patil.
Mantesh Patil for respondent number 2, 3 and 4.
Yes.
5 yaru,
Private respondents.
5.
Five
Associate Director of Agricultural Sciences and Research Center.
Yes, I will take.
Mantesh Patil for 2, 3, 4, 5. Issue emergent notice to 6. Notice to respond number 7 is dispensed. Jagdish Reddy ಬೇಕಾಗಿಲ್ವಲ್ಲ?
Yes, yes.
Yes, list on date ಕೊಡಿ. Arun Kumar Amargundappa.
Mission is with regard to furnishing of legible copy. 2 to 3 lines, my lord, in annexure A is not legible. I am anyhow, my lord, I am not relying for immediate purpose.
ಯಾವುದು?
Annexure A, my lord. And issue is also 2 to 3 lines in, my lord, of some
ಟೈಪ್
page.
ಮಾಡಿಸ್ಕೊಡಿ ಆಮೇಲೆ.
Please, ma'am, I'll find.
The learned counsel for the petitioner undertakes to comply. Office objection at serial number 27.
My lord, the grievance of petitioners herein is, my lord, declining permission to perform urus. My lord, may I directly invite lordship's attention to annexure G, page 41, is an advertisement of Waqf institution, wherein, my lord, offering sandal.
ಅಂದ್ರೆ ಇದು ಉರ್ದು ನಂಗೆ ಬರಲ್ಲಪ್ಪ.
ಇಲ್ಲ ಕನ್ನಡ ಇದೆ ಕೆಳಗಡೆ. Offering of urus, my lord, is scheduled to be held on 25/1 and urus on 26. My lord, may I directly invite lordship's attention to previous arrangement made by district work officer, annexure H, my lord. Similar occasion, page 42. Similar circumstances were in existence previous year also. There, my lord, because of non-appointment of Mutawalli, also, my lord, managing committee of Waqf, an arrangement was made in between, my lord, petitioner, second petitioner hearing, to also, my lord, the ex-Mutawalli, family member of ex-Mutawalli.
The facts of this case.
Facts of the case, my lord, this Waqf called the Dargah is a notified Waqf institution situated in Manvi, my lord. There, my lord, because of some mismanagement, Mutawallis, my lord, were held to be removed, and a scheme was notified appointing administrator. Thereafter, my lord, a managing committee in terms of annexure A. My lord, may I request annexure A, last para, page 6, secretary, page 17. On account of some mismanagement, Mutawalli came to be removed. And thereafter administrator was appointed, page 17. And the annexure B is page 18. This administrator has called in question, my lord, the appointment of managing, my lord, affairs of Dargah by the committee management. And this court, my lord, dismissed the writ petition filed at the hands of, my lord, administrator. And thereafter, if following the order at annexure A, now, my lord, a resolution is passed and the first petitioner is proposed to be the president of managing committee. Said, my lord, a proposal was forwarded to district work officer, and he did not take any action in the matter in forwarding the same to the board. Therefore, my lord, I filed writ petition before this court, and it is other day, my lord, it has come up and lordship has ordered notice. In the meantime, the annexure F may kindly be perused for a moment. Page 32. One, my lord, Syed Semiuddin Khadri, he, my lord, he submitted representations before the board, claiming that, my lord, he requires to be appointed as Mutawalli. And those representations went unconsidered. Therefore, he filed, my lord, writ petition, annexure F, that is. Says, my lord, he takes deviation from, my lord, previous arrangement. Where, my lord, it is,
Read.
please. Page 43. ಹಿಂಬರ ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಯಚೂರು ಜಿಲ್ಲೆಯ ಸೋಯನ್ಸೋ ನಗರದ ವಕ್ಫ್ ಸಂಸ್ಥೆಯು ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಗೆಜೆಟ್ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ 30 ಅಧಿಸೂಚಿತ ವಕ್ಫ್ ಆಸ್ತಿಯಾಗಿರುತ್ತೆ. ಸದರಿ ವಕ್ಫ್ ಸಂಸ್ಥೆಯು ಉರುಸ್ ಆಚರಣೆಯು ದಿನಾಂಕ 25/1/2025 27/1/2025 ನಡೆಯುತ್ತದೆ. ಮುಂದುವರೆದು ಸದರಿ ವಕ್ಫ್ ಸಂಸ್ಥೆಯು ಮುತವಲ್ಲಿ ನೇಮಕಾತಿ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1 ಅನ್ವಯ ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು ಆದೇಶದ ಕುರಿತು ಸೂಚನೆಯನ್ನು ಮಾನ್ಯ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕ್ಫ್ ಮಂಡಳಿ ಬೆಂಗಳೂರು ನೀಡಲಾಗಿರುತ್ತದೆ. ಆದ ಕಾರಣ ಪ್ರಸ್ತುತ ಉರುಸ್ ಆಚರಣೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ಉಲ್ಲೇಖ 2 ಮತ್ತು 3 ಅನ್ವಯ ಅರ್ಜಿಯನ್ನು ಈ ಕಚೇರಿಗೆ ಸ್ವೀಕರಿಸಲಾಗಿರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ಉಲ್ಲೇಖ 1 ಆದೇಶದನ್ವಯ ವಕ್ಫ್ ಮಂಡಳಿಯಿಂದ ನಿರ್ದೇಶನ ಬರುವವರೆಗೂ ಈ ಕಚೇರಿಯಿಂದ ಉರುಸ್ ಆಚರಣೆಯನ್ನು ಕೈಗೊಳ್ಳಲು ತಮಗೆ ಅನುಮತಿ ನೀಡಲು ರಹವಿರುವುದಿಲ್ಲ. He refers, my lord, order of this honorable court at reference under reference number 1, where, my lord, simple mandamus is issued.
But
My lord,
who is the Mutawalli?
my lord, in fact, my lord, the writ petitioner in WP number is also not Mutawalli, my lord. Claims are pending, my lord. All that I am requesting, my lord, let the previous arrangement shall be continued.
What previous arrangement?
Previous arrangement is at, my lord, annexure H. Very Waqf officer last year, my lord. May I read, my lord, annexure H. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಾಯಚೂರು ಜಿಲ್ಲೆಯ ಸೋಯನ್ಸೋ ವಕ್ಫ್ ಸಂಸ್ಥೆಯು ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಗೆಜೆಟ್ ಅಧಿಸೂಚನೆ ಸಂಸ್ಥೆ ಸೋಯನ್ಸೋ ದಿನಾಂಕ ಸೋಯನ್ಸೋ ಅಧಿಸೂಚಿತ ವಕ್ಫ್ ಆಸ್ತಿ ಆಗಿರುತ್ತದೆ. ಸದರಿ ವಕ್ಫ್ ಆಸ್ತಿಯು ಉರುಸ್ ಆಚರಣೆಗೆ ದಿನಾಂಕ 5/2/2024 7/2/2024 ನಡೆಯುತ್ತದೆ. ಸದರಿ ಉರುಸ್ ಆಚರಣೆಯನ್ನು ಕಳೆದ ವರ್ಷಗಳಿಂದ ನಡೆಯುತ್ತಿರುವ ರೀತಿಯಲ್ಲಿ ಶಾಂತಿ ಸೌಹಾರ್ದತೆಯಿಂದ ಶ್ರೀ ಸೈಯದ್ ಸೋಯನ್ಸೋ ರವರು ಜಂಟಿಯಾಗಿ ಉರುಸ್ ಆಚರಣೆ ವ್ಯವಸ್ಥೆಯನ್ನು ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗಲು ಈ ಮೂಲಕ ತಿಳಿಸಿದೆ.
Yes. Who are these two people?
These two people is, my lord, petitioner number 2, 1 year in, and the next person is, my lord, Syed Idris Qadri is, my lord, who is writ petitioner in, my lord, WP annexure F.
He is not the writ petitioner.
Yes.
Syed
Allah,
Idris.
he is belonging to, my lord, his family only.
You said he is a writ petitioner. No,
Sorry,
you said
sorry.
belongs to the family.
Sorry, I correct myself.
ಆಯ್ತು, let somebody carry on the affairs of.
Yes, my lord, that's all.
ಆಯ್ತು,
Even-
ಇದೇನೋ ಮಾಡ್ತಿದ್ರಲ್ಲ, ಇವ್ರು ಯಾರು ಇದ್ದಾರಲ್ಲ ಇವರಿಬ್ರು.
ಇವರಿಬ್ರು ಮಾಡಿದ್ರೆ ಸರ್.
ಸೈಯದ್ ಮಕ್ಬೂಲ್ ಪಾಷಾ, ಚಿತ್ಸಿ, ಯಾರಿದು?
This is, my lord, petitioner number 1, Syed.
ಚಿತ್ಸಿ ಅಂದ್ರೆ ಯಾರ್ರಿ?
Syed, my lord.
ಸೈಯದ್
It is petitioner number 1, my.
ಸೈಯದ್ ಮಕ್ಬೂಲ್ ಪಾಷಾ,
Yes.
ಚಿತ್ಸಿ ಅಂತಿದೆ, ಚಿತ್ಸಿ.
ಅಲ್ಲ, ಸಿ ಅವರು ಹಂಗೆ ಅದು ಬಂದಿದೆ ಸ್ವಾಮಿ. ಈ ಸೇಮ್ ಪರ್ಸನ್, petitioner number 1. In fact, my lord, this sandal is offered, offering of sandal starts from the house of petitioner number 2.
Where is this ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು ಕರ್ನಾಟಕ ವಕ್ಫ್ ಮಂಡಳಿ ಬೆಂಗಳೂರು ನೀಡಲಾಗಿರುತ್ತದೆ, ಎಲ್ಲಿದೆ? ಪ್ಲೀಸ್ ಕಮ್ ಟು annexure J.
Yes, ma'am.
ಮುಂದುವರೆದು
Yes, ma'am.
ಸದರಿ ವಕ್ಫ್ ಸಂಸ್ಥೆಯ ಮುತ್ತವಲ್ಲಿ ನೇಮಕಾತಿ ಸಂಬಂಧಿಸಿದಂತೆ
ಉಲ್ಲೇಖ 1 ಅನ್ವಯ ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು, my lord, this is writ petition directions, my lord, issued to.
ಅನ್ವಯ ಅಂದ್ರೆ ಏನ್ರಿ? ಉಲ್ಲೇಖ 1 ಅನ್ವಯ
Yes, ma'am.
ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು ಆದೇಶದ ಕುರಿತು ಸೂಚನೆಯನ್ನು ಮಾನ್ಯ
Yes.
ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಗಳು
Yes.
ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕ್ಫ್ ಮಂಡಳಿ ಬೆಂಗಳೂರು ನೀಡಲಾಗಿರುತ್ತದೆ. ಎಲ್ಲಿದೆ ಅದು?
That is again reference number 1 only, my lord.
ರೆಫರೆನ್ಸ್ 1 ಅನ್ವಯ ಅಂದ್ರೆ
ಹೌದು.
ಅದರ ಪ್ರಕಾರ ಸೂಚನೆಗಳನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ. ವೇರ್ ಇಸ್ ದಟ್ ಸೂಚನೆ?
ಮುಂದುವರೆದು ಸದರಿ ವಕ್ಫ್ ಸಂಸ್ಥೆಯು ಮುತವಲ್ಲಿ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ
ಹ್ಮ್.
ಉಲ್ಲೇಖ 1ರ ಅನ್ವಯ ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು
ಹಾ.
till today no orders are passed on the representation.
They say it's already ನೀಡಲಾಗಿರುತ್ತದೆ.
No, I have instructions. my lord. This is dated 21 only, my lord.
ಬೇಕಾದ್ರೆ I can list it tomorrow, find out what is this ನೀಡಲಾಗಿರುತ್ತದೆ.
My understanding is, my lord, it is
According to
directions. For a moment, my lord, directions at Annexure F may kindly be looked into.
The learned counsel for the petitioner is directed to produce,
ಅಲ್ಲ ಅದಿಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಏನಿದೆಯೋ ಅದು ಬರೀತಿದ್ದೀನಿ. Produce the directions issued by the Chief Executive Officer, Karnataka Waqf Board, Bengaluru, pursuant to the order passed by this court in WP number 203588 of 2024, which is referred in Annexure J.
My lord, or else notice may be directed to panel. Yes, Mali, but please.
Naresh V. Kulkarni is directed to accept notice for the respondents 1 and 2. AG is directed to accept notice for 3 and 4. ಅದಾದ್ಮೇಲೆ ಇದನ್ನ ಬರೀರಿ. ಲಿಸ್ಟ್ ಯಾವತ್ತು? ನಾಳೆ.
25th is, my lord.
ನಾಳೆ.
ನಾಳೆನೇ ಬೇಕು.
ನಾಳೆ ಕೊಡ್ತೀರಾ?
Please. ಅಲ್ಲ ನಾನಲ್ಲ ಅವರು let them ascertain, my lord. I have instructions, my lord. No orders are passed.
You have instructions, but the order says something else.
ಅಲ್ಲ ಅವ್ರು ಬರ್ದಿದ್ದಾರೆ ಅದು ಹಂಗಿಲ್ಲ.
ಬರ್ದಿದ್ದಾರೆ ಇಲ್ದೆ ಬರೆಯಕ್ಕಾಗತ್ತೇನ್ರಿ? ಇಲ್ದೆ ಬರೆಯಕ್ಕಾಗತ್ತೆ.
ನನಗೆ ಸಿಗ್ತದೆ ನಾ ಕೊಡ್ತೀನಿ. I have no hesitation. But at the same time, my lord, let the other side may also be verified. ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಬರ್ದಿದೆ.
Then, madam, the learned counsel for the petitioner and the learned counsel for the respondents 1 and 2 are directed to so and so, so and so. Yes, list on, list tomorrow.
Yes. In the preliminary hearing. Preliminary hearing.
ಬರ್ಲಿ. Yes,
ಅಲ್ಲ
next. Preliminary hearing ಗೆ ಬರೋದ್ರಿ ಇನ್ನೇನು?
ಪ್ಲೀಸ್.
ಏನಂಬ? ನಿತೇಶ್ ಪಡಿಯಾಲ್. Yes, madam.
The respondent is a trainee driver, was a trainee driver, my lord. His
Respondent
name
is
was
a
trainee driver.
trainee driver.
Yes, my lord. His name was deleted in the selection list. And on the ground that on his negligence, the accident was caused. He has dashed to the lorry when it was stationed the left side of the road. Due to that accident, my lord, 5 persons were died and 10 persons were injured.
What was the defense taken by you in the MVC case? MVC case ಅಲ್ಲಿ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು ನಮ್ದೇ ತಪ್ಪು ಅಂತ?
Record, that is not available in the file.
MVC case ಅಲ್ಲಿ ಒಂಥರ ಹೇಳಿ ಇಲ್ಲೊಂಥರ ಹೇಳಿದ್ರೆ ಹೆಂಗೆ?
Idರಲ್ಲಿ, if it is available, but I would have definitely faced it. It is not available in MVC proceedings, is not available in my file. ಅದ್ರ ಬಗ್ಗೆ ಯಾವುದು document.
The learned counsel for the petitioner is directed to place on record the judgment and award passed in the MVC case filed against the petitioners relating to the incident in which the respondent was involved.
Yes.
This list on ಯಾವತ್ತು?
Next week, any date.
Sanjay M. Joshi. Yes.
Petitioner are rendering effective services.
Petitioners? Yes.
Senior level.
ಆಯ್ತು ಯಾರಾದ್ರೂ ಮಾಡ್ರಪ್ಪ.
Lordship. For all the 3 retired employees of KBJNL, my lord, for the alleged incident which was taken place 17 years back, they have been punished only on that count. Alleged delay after retirement.
What is the allegation?
Allegation that because of delayed payment of compensation to the beneficiary, the KBJNL was made to pay interest at the rate of higher rate of interest for
Yes.
delay. And there was arbitration proceedings also, my lord, wherein we were not held responsible.
Yes, Mr.
My lord, all these three persons are employees of the state government. They are not the employees of
They're not the
KBJNL.
employees of KBJNL.
No, no, they are
KBJNL.
employees of the, my lord, they are employees of state government. Paragraph number 1,
KCSR is.
paragraph number 1 of the petition,
Paragraph?
number 1 of the petition.
Hmm.
The, sorry, 3 and 4. No. It is respectfully submitted that the petitions have been employed originally by the Department of State of Accounts at different period, and they have served at various places on deputation and otherwise. So it is very clear that they are employees of the state government,
They are the government of, state government
employees,
civil
and
servants,
they are there to go to
KCSR is
the
applicable.
KCT.
So therefore, how can you initiate inquiry after 14 years? Or
17 years.
17 years.
That the KCT will have to take.
Huh?
The delayed concern, my lord, even the,
Already, what does Rule 214 say?
yes.
What does
Rap sheet
Second,
was
three.
issued by the KBJNL only.
Civil service, cases. Yes, 214, ಏನ್ ಹೇಳುತ್ತೆ ಓದ್ರಿ?
Withholding or withdrawing the pension for misconduct or the negligence. The government servers reserved to be themselves the right of either withholding or the withdrawing the pension or part of thereof, either permanently or for the specified period. If in any departmental or judicial proceedings, the pensioner is found guilty of the grave misconduct or negligence during the period of his service, including the service under the foreign employer and the service rendered upon re-employment after the death. Recovery of pecuniary loss from the pension. The government service to themselves the right of ordering recovery from the pension, the whole or the part of any pecuniary loss caused to the government or to foreign employer under the whom government servant has worked on deputation or otherwise. So the yes, along with the interest at 8% per annum from the date of the occurrence of the pecuniary loss to the government. If in any department or judicial proceedings, the pensioner is found guilty of the grave negligence during the period of his service, including the service rendered upon the re-employment after retirement. Provided further that where a part of pension is withheld or withdrawn, the amount of pension shall not be reduced below the amount of minimum pension prescribed under these rules. The departmental proceedings referred to in sub-rule 1, if instituted while the government servant was in service, whether before his retirement or during his re-employment, shall after the final retirement of the government servant be deemed to be proceedings under these rules and shall be continued and concluded by the authority by which they were commenced in the same manner as if the government servant had continued in the service. Provided that where the departmental proceedings are instituted by an authority other than the government, that the authority shall submit a report regarding its finding to the government. Please. The departmental proceedings, if not instituted while the government servant was in service, whether before his retirement or during his re-employment, shall not be instituted save with the sanction of the government, shall not be in respect of any event which took place more than 4 years before such institution, and shall be conducted by such authority and in such place as the government may be directed and in accordance with the procedure applicable to the departmental proceedings in which an order of dismissal from service could not be made to the next during his service.
Yes. So where's the sanction of the government? Government sanction illide.
This case, in the year 2010, Manad, the
article of charges, the allegations are made. And 2014/5/2010, the show cause notice was issued. References, I am referring the references. Where is, in the where is, annex the- react-
where is the charge sheet?
Yes, sir.
118, my lord. Page.
Oh,
And the inquiry report submitted on 3/11/2012.
That is issued by Krishna Bhagya Jalajika.
And thereafter, second show cause notice was also issued.
second show cause notice is after the disciplinary, the inquiry
Yes, ma'am,
officer's
yes, ma'am,
report.
2012 only.
Where is the articles of charge, mister?
Yes.
Annexure D1, my lord, 118.
ನೋಡಿ ಬನ್ನಿ ಇಲ್ಲಿ ಪೇಜ್ 121 ಬನ್ನಿ.
Please. Yes, ma'am. 120. 14/5/2010.
When did you retire?
I retired, my lord,
Petitioner number 1 ಯಾವಾಗ ರಿಟೈರ್?
one name.
When 13, 2011 and 2016.
Petitioner number,
Para number 12 of the petition, read petition.
para 12.
Yes.
Thirteen, 11 and 16.
13, 2011, 2016.
Only period number.
13, 11 and 2016, my lord.
When was the
Incident,
charge sheet? When was the charge sheet?
14/5/2010.
14/5/2010. That is when you were in service.
Yes.
yes, my lord. The action that has been taken against me is in respect of alleged irregularity, which is also not proved in the findings, my lord. And there wasn't any allegation. Arbitration proceedings were also held.
That's okay.
There also, I was not found guilty. We were not found guilty of any charges, any
Not on that.
direction and duty.
First, we'll go one
Please,
step by it.
please, oblige,
Annexure 120 is the articles of charge.
please.
What was the finding on this article? What was the inquiry report's finding?
Inquiry report is that
Except DGO formula, the 1, 2, 3 charges are proved in page number 153.
137 to 154, my lord.
153, para 12 is the finding of the inquiry officer.
130?
153.
152,
50, 54 and 52 and 50.
para 12 of the findings of the inquiry officer. Yes.
1, 2 ಮತ್ತು 3ನೇ ಆಪಾದಿತರ ಮೇಲೆ ಆರೋಪ ರುಜುವಾತಾಗಿರುತ್ತದೆ.
ರುಜುವಾತಾಗಿದೆ. Now
4ನೇ
the petition. 4 is ಆಪಾದಿತ ಮೇಲೆ ಆರೋಪ ರುಜುವಾತಾಗಿದೆ.
ಮೂಲಿಗೆ
1, 2, 3 are the petitioner.
ಇದಾದ್ಮೇಲೆ ಏನಾಯ್ತು? ಸೆಕೆಂಡ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ವಾಸ್ ಇಶ್ಯೂ.
Yes, madam, was issued.
ಅದ್ರ ಮೇಲೆ ಏನಾಯ್ತು? ಡಿಸಿಪ್ಲಿನ್ ಅಥಾರಿಟಿ ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು?
Recovery of the.
That is at
last
annexure
cost
A, my lord.
and also 10% withholding of in pensionary for a period of
Yes.
2 years.
Yes, please.
I have given a reply, my lord. That is also findings was in the year 2016, my lord. We have given reply to as against the findings in the year 2017.
Yes.
And your lordship may kindly peruse para 12 alli. All of us, that is 13, 11 and 2016. After the lapse of more than 4 years, there has been issuing of punishment order. And as against,
ಆರ್ಡರ್ ಅಲ್ಲ. 214 ಅಲ್ಲಿ ಪನಿಷ್ಮೆಂಟ್ ಆರ್ಡರ್
Alla, even otherwise, my humble submission, my lord, the charge sheet was issued in the year 2010.
Yes.
As against that, we have given the reply, denying the charges leveled against me. There is no discussion whatsoever insofar as my reply against the findings is concerned.
Yes.
Reply to the findings is also required to be taken into consideration by the disciplinary authority.
Yes.
Otherwise, that will be empty formality, my lord.
Let us see the disciplinary authority's order.
Yes, ma'am.
ಓದಿ.
From bottom, the second para, my lord.
ಓದ್ಲಿ ತಡ್ರಿ ಅವ್ರು.
ಬಂದಿದೆ. Ink page 16, my lord. Fifth para. Fourth para. ಸರ್ಕಾರದ ಎರಡನೇ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸಿಗೆ ಕ್ರಮ ಸಂಖ್ಯೆ 6 ಮತ್ತು 7ರಲ್ಲಿ ಓದಲಾದ ಪತ್ರದಲ್ಲಿ ಕ್ರಮವಾಗಿ ಮೂಲ್ಗೆ ಪ್ರಧಾನ ಮುಖ್ಯ ಲೆಕ್ಕಾಧಿಕಾರಿ ತೋಟಗೇರೆ ಲೆಕ್ಕಾಧೀಕ್ಷಕರವರು ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿ ಆರೋಪಗಳಿಂದ ಮುಕ್ತವನ್ನಾಗಿ ಮಾಡುವಂತೆ ಕೋರಿರ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಮಿಲೋಡ್. ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರ ವಿಚಾರಣೆ ವರದಿಯೊಂದಿಗೆ ಅಪಾದಿತರು ನೌಕರರು ಎರಡನೇ ಕಾರಣ ಕೇಳುವ ನೋಟಿಸಿಗೆ ಸಲ್ಲಿಸಿರುವ ಲಿಖಿತ ಹೇಳಿಕೆಗಳನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿದೆ. ಅಪಾದಿತರು ತಮ್ಮ ಹೇಳಿಕೆಯಲ್ಲಿ ಪ್ರಸ್ತಾವನೆ ಸ್ವೀಕೃತವಾದ ತಕ್ಷಣ ನೋಟೆಡ್ ಎಂದು ರುಜು ಮಾಡಿ ವಿಭಾಗದ ಕಚೇರಿಗೆ ಅತಿ ಜರೂರು ಎಂದು ನಿಸ್ತಂತು ಸಂದೇಶವನ್ನು ಕಳಿಸಿದ್ದಾಗಿ ತಿಳಿಸಿರ್ತಾರೆ. ಆದರೆ ಅಪಾದಿತ ಅಧಿಕಾರಿಗಳು ಪ್ರಸ್ತಾವನೆ ಪರಿಶೀಲಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ಪರಿಶೀಲನಾ ಕಾರ್ಯವು ಪೂರಕ ದಾಖಲೆಗಳಿಲ್ಲದೆ ಅಪೂರ್ಣವಾಗಿತ್ತು ಎಂದು ವಿಳಂಬವನ್ನು ತಡೆಗಟ್ಟಲು ಪತ್ರ ವ್ಯವಹಾರ ಮಾಡದೆ ಕೇವಲ ಜರೂರು ಎಂದು ವಿಭಾಗ ಕಚೇರಿಗೆ ನಿಸ್ತಂತು ಸಂದೇಶವನ್ನು ಕಳಿಸಿದ್ದು, ನಿಸ್ತಂತು ಸಂದೇಶ ಕಳಿಸಿದೊಡನೆ ಅವರ ಕೆಲಸ ಮುಗಿಯುವುದಿಲ್ಲ. ತುರ್ತಾದ ವಿಷಯವಾದ್ದರಿಂದ ನಿಸ್ತಂತು ಸಂದೇಶ ಕಳಿಸಿದರೂ ನಂತರ ಏಕೆ ಸೂಕ್ತ ಕ್ರಮ ಕೈಗೊಂಡಿಲ್ಲ ಎಂದು ಅಪಾದಿತರುಗಳು ಪರಿಶೀಲಿಸಿರುವುದಿಲ್ಲವೆಂದು ವಿಚಾರಣಾಧಿಕಾರಿ ಅಭಿಪ್ರಾಯ ಪಡುತ್ತಾ ಆರೋಪಿತರ ಪೈಕಿ 3 ಅಧಿಕಾರಿ ನೌಕರರಿಂದ ಕರ್ತವ್ಯ ಲೋಪ ಆಗಿರುವುದು ಸಾಬೀತಾಗಿರುವುದು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಮುಂದುವರೆದು ಶ್ರೀ ವೈಕೆ ಪತ್ತಾರ್ ಪ್ರಥಮ ದರ್ಜೆ ಲೆಕ್ಕ ಸಹಾಯಕ ಅವರಿಗೆ ಬೇರೆ ಕರ್ತವ್ಯ ಹಂಚಿಕೆ ಮಾಡಿದ್ದರಿಂದ ಆರ್ಥಿಕ ಹೊಣೆಗಾರಿಕೆ ಪ್ರಸ್ತಾವನೆ ತಾನು ಸ್ವೀಕರಿಸುವುದಿಲ್ಲವೆಂದು ಹೇಳಿದ್ದು, ಇದು ಕರ್ತವ್ಯ ಹಂಚಿಕೆ ಆದೇಶ 95ರ ಪ್ರಕಾರ ನಿಜವಾಗಿರುವುದರಿಂದ ಅವರ ವಿರುದ್ಧ ಅಪೋಹ ಸಾಬೀತಾಗಿರುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆರೋಪಗಳು ವಿಚಾರಣೆ ಸಾಬೀತಾಗಿರುವುದರಿಂದ ನಿವೃತ್ತ ಅಪಾದಿತ ಅಧಿಕಾರಿಗಳಾದ ಮೂಲ್ಗೆ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿ. ವಾಟ್ ಐ ಆಮ್ ಟ್ರೈಂಗ್ ಟು ಪರ್ಸ್ಯೂಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಈಸ್, he refers to the findings of inquiry officer. He is required to take into consideration the reply which I have given as against the findings. There is no consideration insofar as my reply against the findings is concerned.
Yes.
That is nothing but it is empty formality, my lord. The findings copy is required to be furnished as per Ramzan Khan judgment, my lord. They are required to take into consideration the reply given by the delinquent. And there is no consideration, absolutely there is no consideration whatsoever.
Yes.
It is for that reason, my lord, the order is lacking the application of mind by the disciplinary authority.
Yes, Mr.
In the para middle, last but one second para, my lord, it is the, it includes the reply given to the second Procast notice also. It the, what they have taken the contention, that is also appears, and also after careful perusal of the inquiry report. So there is no irregularity and application of
Where is your reply to the second? ಅಲ್ಲ ಇದು ಅರ್ಜೆಂಟ್ ಅಂತ ಮುಂದಕ್ಕೆ ಗೊತ್ತಾಗ್ತಾರಪ್ಪ. He endorses on the letter that it's very urgent.
Yes.
ಬರ್ದಾಕ ನೆಕ್ಸ್ಟ್ ಸೆಕ್ಷನ್ಗೆ ಹೋಗಿ ಅವ್ರು ಮಾಡಬೇಕು. ಇವ್ರು ಹೋಗಿ ಅದನ್ನ ಫಾಲೋ ಮಾಡೋದು ಇಲ್ಲಿಂದ ಬಂತು. ಅತಿ ಜರೂರು ಅಂತ ಬರೆದು ಕಳಿಸ್ತಾರೆ. ಅತಿ ಜರೂರು ಅಂತ ಬರೆದ್ಮೇಲೆ ರಿಸೀವ್ ಮಾಡೋರು ತಾನೇ ನೋಡ್ಬೇಕಾಗಿರೋದು. ಇವ್ ಫಾಲೋ ಮಾಡಕ್ಕಾಗತ್ತ? ಹೋಗ್ಬಿಟ್ಟು ಅತಿ ಜರೂರು ಅಂತ ಬರ್ದಿದ್ದೀನಿ ಏನ್ ಮಾಡಿದಿರಿ ಅಂತ ಕೇಳಕ್ಕಾಗತ್ತೆ?
Before that, my lord, they have to ascertain the relevant documents attached to the proposal.
Once it goes out of his hand, why should you follow it up?
No, before recommendation, my lord, he has to ascertain and rectify all the documents.
Telegraphic message they have sent, my lord, that shows that they were, the matter is that nistantu.
Reply ಎಲ್ಲಿದೆ?
One.
Not rich.
ಇಲ್ಲ ಇದೆ, ಒಂದು ನಿಮಿಷ.
ನಂಬರ್ ಪ್ಯಾರಾನಾಗ ಏನೇನು ಡೀಟೇಲ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ಅದಲ್ಲ
ರಿಪ್ಲೈ ಅವರು One day. No, madam, they have not produced, but there is reference to that in annexure A, my lord, in ink page 15.
Hello, but what have you contended in your reply?
One.
Is there anything that is worthy of being considered? ನಾನೇನೋ ತಪ್ಪು ಮಾಡಿಲ್ಲ, ನಾನು ಬಿಟ್ಬಿಡಿ ಅಂತ ನೀವು ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ರಿ. Is that sufficient?
But in this para, my lord, in ink page 16, the disciplinary authority refers to the reply given by the
ನೋಡಿ ಹೇಳಿ sir. And senior counsel for the petitioner seeks time to verify the claim made by the petitioners in the reply to the second show cause notice issued by the disciplinary authority. List after the same is done. Yavat?
next week.
List after the same, mention ಮಾಡಿ ನಿಮ್ ಕೈಗೆ ಸಿಕ್ಕದ್ಮೇಲೆ.
ಆಯ್ತು.
Yes, next.
29. Entry models there.
Entry model granted rejection. To the next. Yes.
Sir, I am only on alleged past history, my lord.
Alleged?
Past history.
Ah.
The disciplinary authority is having the powers to take into consideration the past history. There is no barment. But as per the decision of this honorable court, my lord, division bench judgment, what their lordship say, my lord, that if they are relying the past history, it has to be reflected in the charge sheet upon which there is issuing of punishment. Without there being material placed, or I should be given an opportunity to explain against that. Punishing on the ground of, by taking into consideration the alleged past history, will not be in accordance with the rules of natural justice as well as, may I pass on? 1990. Only of that count.
Yes, Deepak.
Your lordship may ink page 35 LM. Para 7. May I read?
Just on.
35, ink page 35.
Hmm.
7. It is also submitted here that the workman had not committed any act of misconduct. He had not remained unauthorizedly absent from so-and-so and had never admitted that he had remained unauthorizedly absent. But in fact, due to ill health, he went on leave with due permission, but a false report had been made against the workman. Hence, the workman denies the allegations of the show cause notice in toto. That the disciplinary authority had prejudiced against the workman, which is evident from the fact that he had taken into consideration the alleged past history, which is neither the part of charge sheet nor the same was discussed in the inquiry, or no any opportunity was given to the workman to explain about the same by providing all the relevant documents.
Lords, the issue number 1 is in affirmative. Lord, the para 10 of the labor code order, may I permit it to read? Yes. The workman had not placed any material. Page 18, the award passed by the labor code. Yes. Para 10. The workman has not placed any material before the court to believe that he had submitted a leave application and went on sending leave application for extension of it. It is pertinent to note that in this case, the workman has not produced any iota of evidence to believe that he was suffering from tuberculosis and took treatment for 1 year and for 4 months. In case of absenteeism, the burden is upon the workman to prove that he was not negligent in attending the duties. As already observed, the workman neither produced any documents to believe that he was suffering, he was submitted leave application, no doctor certificate or other treatment papers to show that he was suffering from tuberculosis. In fact, he is suffering from the said disease. The workman could have produced the necessary treatment papers either before the inquiry officer or before this court. Thus, the workman has failed to prove he was not negligent in attending the duties.
Lord, before the inquiry, neither in inquiry nor before the labor court, he has produced a single document to show that, my lord, he was suffering. And it is 1 year, 4 months, my lord. The absenteeism is from 26/2/2006 to, my lord, 16/4/2005 to 25/2/2006, my lord. Almost 10 months, my lord. And thereafter was further, my lord. He has not produced a single document before the labor court as well, my lord, because the issue, if the issue number 1 is in affirmative, my lord, the workman has to show that, my lord, there is some reasons to believe by the
But
labor.
whether the labor court has relied upon past conduct,
My lord, only may I take to the reasonings given by the labor court with regard to the, this is the main reason, my lord, the para 10. Thereafter, my lord, para page 24 on, para 16. The workman during the course of the examination admitted the service of M16 show cause notice so and so, show cause notice M17 dated. In M16 it is stated that the workman had involved in 2 absenteeism cases, 9 pilferage, the revenue of the corporation cases, all of them are closed by imposing minor punishment with intention to improve his conduct. In M17 it is stated that the workman has involved in 4 absenteeism cases. The workman has not given reply to both the show cause notice denying his involvement in past bad cases of absenteeism. The workman during the evidence also has not denied his involvement in past bad cases. The learned counsel for the respondent relied upon the case of the Union of India versus so and so. In, my lord, next para. In instant case, the workman has not denied the involvement in past absenteeism cases. This shows the workman is a habitual absentee. Further, the workman has not given any explanation for his repeated absenteeism. Therefore, there is no grounds to interfere in the other order of the dismissal passed by the disciplinary authority for proving grave misconduct against the workman. This is not fit case to exercise the discretion vested in this court under section 11 of the ID Act, hence the past following. Lord, first thing, my lord, he has not produced a single document either before the inquiry officer, not before the labor court. And my lord, he has not denied the past history as well. Now, the labor court has rightly dismissed the claim petition made by the.
yes.
My lord, my only submission is that, my lord, the burden will be upon the employer to prove the allegations made against me. And my lord, in case of absenteeism, there will not be any intention on the part of the workman to cause any wrongful loss to the corporation and wrongful gain to himself.
Yes.
And under the absenteeism case, my lord, certainly there will not be. And their lordship in this judgment, my lord, in Ramu versus their lordship, they are pleased to hold, my lord, that even if the inquiry is held to be legal and if it is not defective under any circumstances, the only presumption which could be drawn that he is, ಅದರಲ್ಲಿ word use ಮಾಡಿದ್ದಾರೆ sir, he may not be.
ಏನು ಓದಿ ಏನು ಹೇಳಿದ್ರು?
ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ sir, the retribution of dismissal from service perhaps would require a graver offense than what has been proved against the petitioner in this case. The petitioner has no other ostensible source of livelihood, nor is it the intention of the disciplinary authority to deprive him of the source of livelihood once for all in a climate of inevitable socio-economic conditions which permeates society to today. It cannot be more aptly said that justice tempered with the mercy is equity. It cannot be said that the petitioner is guilty of a heinous offense or a gross tort or even moral turpitude as to warrant the maximum penalty of dismissal from service. The petitioner was produced before the court by learned counsel so and so.
How old are you now?
Now, my lord, while passing of the award itself, he was 37, my lord, in 2010. Now, my lord, I think he is in
54, 55.
Yes.
55.
Any other punishment, my lord, that may meet the answer. Any other alternative punishment? 11A is meant for exercising the powers, my lord, and the labor code did not discuss as to why he is declining to exercise powers under section 11A.
Yes.
And your lordship may kindly take into that maybe pardon for repeating, he will not have any intention of causing loss to the.
Causing loss, if you
my lord,
abstain from work, then. they
My,
have
my
to-
only humble submission, this is the case wherein it may not warrant a dismissal. Any other punishment, my lord.
Yes.
Disciplinary authority, which is.
But if you are continuing, you are
No,
habitual.
there is no continuation. They have not produced any material before.
Produce,
they-
confront ಮಾಡಿದ್ರಲ್ಲ ನಿಮ್ಗೆ.
Allala, sir. The labor code says, my lord, that I have not produced any material.
Correct, but you admit exhibit M16, M17,
One.
you admit that. 4 ಕೇಸು 4 ಸತಿ absent ಆಗಿದ್ರಿ.
9 cases of pilferage also.
9 cases of pilferage. You don't dispute that.
I have submitted, my lord, that I have not committed any misconduct ಅಂತ ಹೇಳಿದ್ದೀನಿ. I leave to you. Any other alternative punishment. In case of absenteeism, my lord, otherwise I would not have pressed.
Only submission is that, my lord, at the passing of the award, he was 37. Now he is 55, my lord. Since from 37 to 55, he has served now the 55 years employee, my lord, for having 4 years services. Sir. Already, my lord, the fresh employment is available for the corporation now for this.
ಆಯ್ತು, ಏನೋ ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನೋ ಒಂದು ಮಾಡಿ. Come up with some term, make some offer.
I have to take instruction.
If with any other punishment, my lord, with, I
Punishment
leave it to you.
Now you are 55 years, you can't
How?
go and work as a conductor.
Please. Any other punishment, my lord, at least he will be in a position.
They will offer some payment.
Kodala, sir, KSRTC, they will never
He
come.
says he'll get, ಏನ್ ಮಾಡ್ತೀರಿ?
Again,
I don't have any instruction
Hey,
regarding.
please take
I will.
instructions.
No, they,
Otherwise,
they
how
have
it
their
is-
own problems, my lord. It will be.
ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the respondent seeks time to secure instructions whether the respondent could offer a lump sum payment against, to the petitioner. Just list on yavat.
Friday, no, Wednesday, next one.
Now, I am likely to pass an order reducing 2 increments with cumulative effect and restore or reinstate into service with back wages, 50% back wages.
I will take instruction, otherwise I will let.
Oblige.
When ready.
Respondent, I seek for a week's accommodation.
Why?
There is some report by the Tahsildar, I'll have to look.
Huh?
Already on 25/4/2024, report has been submitted by Tahsildar.
ಆಯ್ತು ಹೇಳಿ, you ready?
Yes, Lord.
Argue ಮಾಡಿ.
It's 1 week, Lord, I'll,
ಏನಿದೆಯಪ್ಪ,
ಅಲ್ಲ, ಒಂದು instruction ತಗೊಂಡು-
2019 ಇಂದ ಯಾಕೆ ಇದು?
next Friday, next notes.
That's okay, please argue.
Matter is in respect of appointment of Anganwadi helper, my lords.
ಅಂಗನವಾಡಿ
Anganwadi helper, my lords.
helper.
Yes, my lords. My lords, petitioner as well as the respond number 5 had applied for the post, my lords. Petitioner is ninth pass, my lords. And as per the notification, 9th pass persons has to be submitted, selected, my lords. My only candidature, my application was rejected, my lords, only on the ground that I was not resident of Mudnal Tanda, my lords.
ಯಾವ ತಂಡ?
Mudnal Tanda.
ಬುದ್ನಾಳ್.
Yes, my lords. As per the statement of objection submitted by the respond number 3, my lords, only on that ground, my lords, my application was rejected.
This Anganwadi is situated at Mudnal.
Yes, my lords, Mudnal, LT, L Tanda. And the respond number 5 is 8th pass, my lords. So I, only the rejection ground was only with regard to the residence, my lords. This honorable court, my lords, to clarify the issue, my lords, on 21/2/2024, has directed the respond number 4 to submit the report after inquiry, holding inquiry that, my lords, the petitioner as well as the resident of respond number 5, my lords. The report was submitted holding that, my lords, both are resident of Mudnal Tanda only, my lords. Memo dated, my lords, 25/4/2024, my lords.
Memo dated?
25/4/2024, my lords.
Affidavit.
Memo is there, my lords. Memo is filed along with the report, my lords, annexure R1.
ಏನಂತ ಹೇಳುತ್ತೆ ಓದಿ.
Milords. In second para, Milords.
ಹ್ಮ್.
ಅದರಂತೆ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಿ ವರದಿ ಸಲ್ಲಿಸಲು ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಮುದ್ದೇಬಿಹಾಳ್ ಇವರಿಗೆ ಸೂಚಿಸಲಾಗಿ ಉಲ್ಲೇಖ 2 ಅರನ್ವಯ ಮುದ್ನಾಳ್ ಗ್ರಾಮ ಅಥವಾ ಮುದ್ನಾಳ್ ತಾಂಡ ಇವು ಎರಡು ಒಂದೇ ಅಂತ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಮುದ್ದೇಬಿಹಾಳ್ ಇವರು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. If this is taken into note of, my lords, then, my lords, the petitioner will be
Yes, Mr.
more qualified.
Insofar as the education qualification is concerned, not she, even she has completed class 10, 9 ಅಂತ 8 ಅಂತಾರೆ. class 8, class 8 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಹಾ. But not insofar as the residential certificate is concerned, that my lords clearly states she is resident of Mudnal rather than Mudnal Tanda. ಹ್ಮ್. And ಏನೋ? The education qualification, considering both my lords are similarly educated and Who is better entitled? Who is eligible, more eligible, petitioner or the there is respondent? no criteria for such selection, my lords. ಅಲ್ಲ, who is, 9th pass ಆದವ್ರು ಮಾತ್ರ ಕೊಡ್ತೀವಿ ಅಥವಾ ಆಯ್ತು, ಯಾರು ಜಾಸ್ತಿ that, ಆಗ್ಬೋದು? that minimum criteria is they should be 7th passed. ಹಾ. And there is no, my lords, criteria as such stating that only 9th pass would be given more priority rather Yeah, than what is the eligibility? 7th pass? 7th pass ಅಂತ ಇದೆ. The minimum criteria is 7th pass, they should be Is it? 7th pass. ಅಲ್ಲ, that is in the notification. ಇಲ್ಲ, 7th pass ಅಂತ ಇದೆ. Annexure F.
Page number 11 of the statement of objection.
ವಿದ್ಯಾರ್ಹತೆಗೆ ಸಂಬಂಧಿಸಿದ 4ರಿಂದ 9ನೇ ತರಗತಿ ತೇರ್ಗಡೆ ಹೊಂದಿದ ಅಂಕಪಟ್ಟಿ ಹಾಗೂ ಶಾಲೆ ಬಿಟ್ಟ LC ಬಗ್ಗೆ ಪ್ರಮಾಣ ಪತ್ರ ಹಾಜರುಪಡಿಸುವುದು. 9ನೇ ತರಗತಿ 9ನೇ ತರಗತಿ ಮುದ್ನಾಳ್ ತಾಂಡ 8ನೇ ತರಗತಿ.
ಅಲ್ಲ ಇಲ್ಲ ಇದು
ನನಗೆ ಕೊಟ್ಟಿದ್ದು ಸರ್.
annexure F no.
Where is the recruitment notification?
Page number 11 of the statement of objections, my lords.
What does it say? ವಿದ್ಯಾರ್ಹತೆ.
Ninth in the,
Huh?
last 4 lines of the, page number 11 of the statement of objections.
ಹಾ. ಕನಿಷ್ಠ
ಕನಿಷ್ಠ 9ನೇ ತರಗತಿ.
9 ಅನ್ನೋದೇ blank.
4ರಿಂದ 9ನೇ ತರಗತಿ.
4ರಿಂದ 9 ಅಂತ. ಕನಿಷ್ಠ 4ನೇ ತರಗತಿ ತೇರ್ಗಡೆ, ಗರಿಷ್ಠ 9ನೇ ತರಗತಿ ತೇರ್ಗಡೆ.
Yes,
ಇದರಲ್ಲಿ ಹೆಚ್ಚಿನ ವಿದ್ಯಾರ್ಹತೆ ಉಳ್ಳವರನ್ನು ಆಯ್ಕೆ ಮಾಡಬೇಕು.
please.
9ನೇ ತರಗತಿಯಿಂದ ಹೆಚ್ಚಿನ ವಿದ್ಯಾರ್ಥಿಯನ್ನು ಆಯ್ಕೆಗೆ ಪರಿಗಣಿಸುವಂತಿಲ್ಲ. 9ನೇ ತರಗತಿ ಮಾಡಿದ್ರೆ ಅವ್ರು ಕೊಡ್ಬೇಕು. ನೀವು 8ನೇ ತರಗತಿ ಮಾಡಿದ್ರಿ, ಏನಾದ್ರು ಬೇರೆ ಅಕಾಮಿಡೇಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೇನ್ರಿ ಇವ್ರನ್ನ? Can you accommodate petitioner elsewhere?
I have to ascertain because my lord, it is 2019 appointment. my lord.
This lady is already working.
Yeah,
Respondent number
respondent number 5 is working.
ಮತ್ತೆ how to dislodge her after so many years?
I had challenged the petition I had filed in the 2019 itself, my lords. Inquiry was held to that effect thereafter.
Correct ಅಪ್ಪ, but ಏನ್ ಮಾಡೋದು? Is there any interim order subject to the result ಅಂತ ಇದೆಯಾ?
Lords, I will have to ascertain that.
Now she will have to be thrown out.
Yes.
ಮತ್ತೆ ಕೆಲಸ ತೆಗಿಬೇಕಾಗುತ್ತೆ. ಇನ್ನೊಂದು ಜಾಗ ಸಿಗುತ್ತೇನ್ರಿ ಪಿಟಿಷನರ್ಗೆ?
I will ascertain, my
ಬರ್ಕೊಳ್ಳಿ. The report of the Tahsildar regarding the residence of the petitioner is perused. It shows that the petitioner is residing within the limits of Mudnal, and Mudnal village and Tanda are one and the same. Between the petitioner and the respondent number 5, the petitioner who has completed 9th standard has a better chance to be recruited. However, the respondent number 5, the respondent number 5 has completed her 8th grade. And hence, between them, it is a petitioner who has got a better chance. Since the respondent number 5 is already working as helper at Mudnar, Tanda from the last 5 years, it is appropriate to direct the respondents 1, 2, and 3 to verify whether the petitioner could be accommodated in any nearby Anganwadi as a helper. Hence, learned AG is directed to secure instructions in this regard. List on Yavat. 29.
Obligement.
My lord, Tahsildar should be present. It may be dispensed.
Yeah. Since the report is submitted by the Tahsildar, the presence of the Tahsildar before the court is dispensed.
Please, obligement.
Bandidara. Next, Nitesh Padiyal. Here for the petitioner, my lord. The petitioner is working as gang woman under respondent number 4, my lord. Prashant Kumar.
Next
Since
week it
then,
may be
since
taken.
1983, since
Emergency next Thursday. Next Wednesday.
Thackeray 2019 petition. mandamus.
Emergency ಏನು ಕೆಲಸದ್ದು.
Huh?
Next week.
This
of
only
station ಇದೆ.
for some mandamus. Mandamus. Since 1983, she is
Toxic
working under
oxide, my
respondent
lord.
number 4, my lords. She approached labor court, my lord, labor court order for reinstatement. Since then, she is working, my lord.
Toxic council ಮಾಡ his
Prashant Kumar ilva.
29th.
Learned counsel for the respondent number 2 to 4 seeks time as a last chance list on.
Please.
Sachin Mahajan.
The respondent, my lords. The lordship heard this matter. The order dated 13/1/2025.
my lord.
I don't remember the facts, please.
Order dated 13/1/2025, my lords. Your lordship may kindly.
Lord, financial concurrence was not required, my lord, for
No, then,
HK. And that is the case where, my lord, they mixed up, my lord, HK and non-HK. And, my lord, when the selection process was complete and, my lord, it had gone for approval.
then it is made clear that if the respondent number 3 fails to finalize the promotion of the petitioner, by the next date, the petition shall be taken up for disposal. Yeah.
Now,
Please,
they-
notes. Now,
They have
the-
issued an order of promotion along with 14 other persons, my lord, that is under, my lord, career advancement scheme of 2016, which is, my lord, applicable
Pass.
to all other employees.
May I pass
And
it
that
for
is
this?
given with effect from 2023, my lord.
That is, you
He
place him
requested-
above the others.
He requested, my lords, and he relieved from assistant professor post and he joined, my lords, even a request letter.
Already joined.
Joined, my lords. May I pass it?
No, my lord. I may have to take
ಕಾಪಿ
instruction.
ಕೊಡ್ಬೇಕಲ್ಲ ಅವ್ರಿಗೆ ಮುಂಚೆನೆ.
ಅದು ಕೊಟ್ಟಿರ್ತಾರೆ. ಇದೆಲ್ಲ.
17 January 2025.
ಏನ್ ಮಾಡ್ತೀರಿ? Would you like to take instructions?
I'll take instructions.
The learned counsel for the respondent. ಯಾರು respondent?
That's the
Learned counsel for the respondent number 3. In compliance with the order dated 13/1/2025. Submits that the respondent number 3 has promoted the petitioner under the Career Advancement Scheme 2016 to the post of Associate Professor.
professor notes.
And that the petitioner has reported to duty as an Associate Professor. Full stop. The learned counsel for the petitioner seeks time to secure instructions. List on,
Promotion given effect from July 2023.
not there.
Please.
Look.
K. Ramchandra. Yes, Mr. Ramchandra.
We have challenged Annexure H.
Next, sir.
impugned
termination order issued by the respondent number 6, my lord. That's also without having any jurisdiction, my lord. Please. Annexure H. Yes, please. And we are seeking directions to consider my representation as per Annexure K, my lord. Only on the basis of a false complaint lodged by the respondent number 7.
Read Annexure H.
Please. Very correct. ಶ್ರೀಮತಿ ಅರ್ಚನಾ ಪುರೋಹಿತ್ MKB ವೈ ಏಜೆಂಟರು ವಿಜಯಪುರ ಇವರ ಮೇಲೆ ಠೇವಣಿದಾರರಾದ ಶ್ರೀ ಗಿರೀಶ್ ಪಿ ಅಂಬೇಕರ್ ಇವರು ಏಜೆಂಟರು ತಮ್ಮ ಆಡಿ ಖಾತೆ ಸಂಖ್ಯೆ ಸೊನ್ಸೋಗೆ ಸರಿಯಾಗಿ ಸೇವೆಯನ್ನು ಒದಗಿಸದೆ ಅಸಭ್ಯವಾಗಿ ವರ್ತಿಸಿದ್ದು ಅವರ ಮೇಲೆ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸುವಂತೆ ಕೋರಿ ಮಾನ್ಯ ವಿಭಾಗೀಯ ನಿರ್ದೇಶಕರು ಸೊನ್ಸೋ ಇವರಲ್ಲಿ ಸಲ್ಲಿಸಿದ ದೂರಿನ ಪ್ರತಿಯನ್ನು ಲಗತ್ತಿಸುತ್ತಾ ಸದರಿ ವಿಷಯವಾಗಿ ಸಮಗ್ರ ವಿಚಾರಣೆ ನಡೆಸಿ ವರದಿ ನೀಡುವಂತೆ ಉಲ್ಲೇಖ 1ರ ಪ್ರಕಾರ ಮಾನ್ಯ ನಿರ್ದೇಶಕರು ಪಿಂಚಣಿ ಸಣ್ಣ ಉಳಿತಾಯ ಮತ್ತು ಆಸ್ತಿ ಋಣ ನಿರ್ವಹಣೆ ನಿರ್ದೇಶನಾಲಯ ಬೆಂಗಳೂರು ಇವರಿಂದ ನಿರ್ದೇಶಿತನಾಗಿದ್ದೇನೆ. ಸದರಿ ನಿರ್ದೇಶನದಂತೆ ದೂರುದಾರರು ಮತ್ತು ಏಜೆಂಟರ ಹೇಳಿಕೆ ಮತ್ತು ಪ್ರತಿ ಹೇಳಿಕೆಗಳನ್ನು ಪಡೆದು ಸಮಗ್ರವಾಗಿ ಪರಿಶೀಲಿಸಿ ಉಲ್ಲೇಖ ಪತ್ರ 2 ಮತ್ತು 3ರ ಪ್ರಕಾರ ಹಾಗೂ ಮೌಖಿಕವಾಗಿ ಸಾಕಷ್ಟು ಬಾರಿ ಏಜೆಂಟರಾದ ಶ್ರೀಮತಿ ಅರ್ಚನಾ ಪುರೋಹಿತ್ MPKY ಏಜೆಂಟರು ವಿಜಯಪುರ ಇವರಿಗೆ ಠೇವಣಿದಾರರಾದ ಶ್ರೀ ಗಿರೀಶ್ ಪಿ ಅಂಬೇಕರ್ ಇವರು ಆಡಿ ಖಾತೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸರಿಯಾದ ಸೇವೆಯನ್ನು ಒದಗಿಸಿ ಈ ಕಚೇರಿಗೆ ವರದಿ ಒಪ್ಪಿಸುವಂತೆ ಮತ್ತು ತಪ್ಪಿದ್ದಲ್ಲಿ ತಮ್ಮ ಮೇಲೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದಲ್ಲದೆ ಮುಂದಿನ ಆಗು ಹೋಗುಗಳಿಗೆ ತಮ್ಮನ್ನೇ ನೇರವಾಗಿ ಹೊಣೆಗಾರನಾಗಿಸಲಾಗುವುದೆಂದು ಸ್ಪಷ್ಟವಾಗಿ ಸೂಚಿಸಲಾಗಿತ್ತು. ಏಜೆಂಟರು ಸದರಿ ಸೂಚನೆಗಳನ್ನು ಆಡಿ ಖಾತೆಯು ಸ್ಥಗಿತವಾಗುವವರೆಗೂ ಅಂದರೆ ಸುಮಾರು 6 ತಿಂಗಳವರೆಗೂ ಪಾಲಿಸದೆ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳ ಆದೇಶಕ್ಕೆ ಅಗೌರವ ದೂರಿದ್ದನ್ನು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ತಮ್ಮ ಮೇಲೆ ಏಕೆ ಶಿಸ್ತು ಕ್ರಮ ಜರುಗಿಸಬಾರದೆಂಬುದಕ್ಕೆ 7 ದಿನದಲ್ಲಿ ಉತ್ತರಿಸುವಂತೆ ಕೋರಲಾಗಿತ್ತು. ಉಲ್ಲೇಖ ಪತ್ರ 5ರ ಪ್ರಕಾರ ಏಜೆಂಟರು ತಮ್ಮ ಸಮಜಾಯಿಷಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಶ್ರೀ ಗಿರೀಶ್ ಪಿ ಅಂಬೇಕರ್ ಇವರ ಖಾತೆಯನ್ನು ಮುಂದುವರಿಸಲು ಆಗುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸಿದ್ದು ತಮ್ಮ ಮೇಲೆ ಶಿಸ್ತು ಕ್ರಮ ಏಕೆ ತೆಗೆದುಕೊಳ್ಳಬಾರದೆಂಬುದರ ಬಗ್ಗೆ ಯಾವುದೇ ಸಮಜಾಯಿಷಿ ನೀಡಿರುವುದಿಲ್ಲ. ಸದರಿಯವರ ಹೇಳಿಕೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಗಿನಂತೆ ಆದೇಶಿಸಿದೆ. ಗಿರೀಶ್ ಪಿ ಅಂಬೇಕರ್ ಠೇವಣಿದಾರರು ಇವರು ಏಜೆಂಟರಾದ ಶ್ರೀಮತಿ ಅರ್ಚನಾ ಪುರೋಹಿತ್ MPKY ಏಜೆಂಟರು ವಿಜಯಪುರ ಇವರ ಮೇಲೆ ಸರಿಯಾದ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸದೆ ಅಸಭ್ಯವಾಗಿ ವರ್ತಿಸಿ ಆರೋಪದ ಕುರಿತು ಸಮಗ್ರವಾಗಿ ವಿಚಾರಣೆ ನಡೆಸಿ ದೂರುದಾರರ ಆಡಿ ಖಾತೆಗೆ ಏಜೆನ್ಸಿ ಸೇವೆಗಳನ್ನು ನೀಡಿ ಕಚೇರಿಗೆ ವರದಿ ಒಪ್ಪಿಸುವಂತೆ ಸೂಚಿಸಿ ಸಾಕಷ್ಟು ಸಮಯಾವಕಾಶವನ್ನು ನೀಡಿದ್ದರೂ ಸಹ ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರಗಳ ಆದೇಶವನ್ನು ಪಾಲಿಸದೆ ಹಗುರವಾಗಿ ಗಮನಿಸಿ ಆದೇಶಗಳಿಗೆ ಅಗೌರವ ತೋರಿದ್ದನ್ನು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ಉಲ್ಲೇಖ 6ರಲ್ಲಿ ನನಗೆ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಶ್ರೀಮತಿ ಅರ್ಚನಾ ಪುರೋಹಿತ್ ಮತ್ತು MPKBY ಏಜೆನ್ಸಿ ಸಂಖ್ಯೆ ಸೊನ್ಸನ್ನು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ರದ್ದುಗೊಳಿಸಿದೆ. Annexure H is over.
Yes, ಆಮೇಲೆ
The grievance of the petitioner is that the respondent number 6 has no jurisdiction, my lord. Actually, the competent authority is respondent number 1 and 5, my lord. She has been appointed in the year 19.
ಸಹಾಯಕ ನಿರ್ದೇಶಕರು.
She has been appointed as an agent of MPKBY agent in the year 1994, my lord.
By whom?
Deputy Commissioner
ಎಲ್ಲಿದೆ ಅದು?
Vijaypur, my lord. We have not produced the appointment.
Who is the removing authority?
195, my lord. Competent authority is to 1.
What is there to show that?
Appointment order we have not.
What is there to show that the respondent number 1 and 3 are the competent authority? ಎಲ್ಲಿದೆ?
But as per agreement, my lord, agreement also we have not produced here.
ಮತ್ತೆ ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ? How are you maintaining, how can you maintain the writ petition?
next date of hearing, I'll produce that. I'll produce it, I permit you, but you pay cost. Unnecessarily, we're listing the matters. Nobody seems to be bothered, mister, I don't know. ನೀವು ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ರೆ ಅದನ್ನೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. You're saying that the respondent 1 and 3 are the competent authorities.
Yes, yes.
What is there to show? Produce ಮಾಡಿಲ್ಲ. ಏನು, what kind of,
We have not produced yet.
ಏನು ಹೆಂಗ್ ಇದು, how can you, I mean, ಇದೆಲ್ಲ ನಿಮ್ಗೆ ರಿಟ್ ರೆಡಿ ಮಾಡೋ ಒಳ್ಳೆಯದಿಲ್ವಾ? Does it not occur to you? ಇಲ್ಲಿ ಬಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದು ಅದ್ ಮಾಡಿಲ್ಲ, ಇದ್ ಮಾಡಿಲ್ಲ, ಅದ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು, ಇದ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
There is an agreement between the deputy commissioner with the petitioner, so I'll produce that next date of hearing. In the year 1994, she has been appointed as the agent of the Mahila Pradhana.
ನೋಡಿಪ್ಪ, ನೀವೇ ಯೋಚನೆ ಮಾಡಿ, ಏನ್ ನಿಮ್ಮಲ್ಲಿ ಏನು
Please, my lord. So I'll
ಶಾರ್ಟ್
produce.
ಕಮಿಂಗ್ಸ್ ಇದೆ ಅಂತ ನೀವೇ ಯೋಚನೆ ಮಾಡಿ.
Please.
The more I tell, I think I'll become a villain.
No, not like that.
So therefore you please decide, ನಿಮ್ಮಲ್ಲಿ ಏನು ಶಾರ್ಟ್ ಕಮಿಂಗ್ಸ್
Please.
ಅಂತ ನೀವು ಡಿಸೈಡ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Sorry for what happened. So I'll produce that next day.
Counsel for the petitioner seeks time to place on record documents to show that the respondents 1 and 3 are the competent authorities to terminate the agency of the petitioner.
195,
1 and 5 are the competent authorities to terminate the agency of the petitioners.
please.
List on ಯಾವತ್ ಬೇಕು ತಗೊಳ್ಳಿ.
And that,
ಇನ್ನು ಕೇಸ್ಗಳು ಡಿಸ್ಪೋಸ್ ಆಗದೆ ಇನ್ನೇನಾಗುತ್ತೆ? ಹಿಂಗೆ ಪೆಂಡಿಂಗ್ ಉಳಿಯುತ್ತೆ. ಹಿಂಗೆ ಪೆಂಡಿಂಗ್ ಉಳಿಯೋದು ಲಾಯರ್ಗಳಿಂದ. ಸಿದ್ರಾಮ್, ಮಂಜುಳಾ, ನಿತೇಶ್ ಪಡಿಯಾಲ್.
Lordship, the petitioner here in my lord, he was holder of diploma in sugar technology, my lord. My lord, in this particular, in this region and within the jurisdiction of university, Gulbarga University, my lord, there wasn't any subject, it is sugar technology subject wasn't there. It is admitted fact, my lord. And he gained the employment on the basis of diploma in sugarcane. He completed it in the year 1974 in March.
Diploma in sugar cane or sugar technology?
Sugar technology,
You said sugar cane.
sugarcane technology, sugar technology.
Ah.
And there was introduction of this subject in the respondent college, my lord, at Alan. Since there is a sugar factory in Alan, my lord, it is for that reason there was introduction of that subject. And my lord, I did not play any fraud. I have submitted that I have completed diploma in sugar cane technology. And on the basis of that, my lord, I was appointed in the year 1983 itself. That is as per Annexure A.
Yes.
And thereafter, my lord, my appointment was again confirmed in the year 1985 as per Annexure B. Your lordship may kindly Annexure C, my lord, the Registrar of University, typed copy is ink page 23, my lord, of Annexure C. With reference to your representation, he writes a letter to the principal. With reference to your representation and personal discussion with Vice Chancellor, I am directed to state that the pending decision of the Academic Council of Gulbarga University, the present arrangement of handling undergraduate class in sugar technology, that is B.S. Pattankar, lecturer, will continue. He may continue to teach sugar technology subject to undergraduate students of Alan Degree College for the time being. And my lord, thereafter, your lordship may kindly Annexure E, my lord, ink page 26.
Yes.
Second parallelly. The director of technical education, my lord, that is collegiate education, he writes a letter to Commissioner for Higher Education, that is dated 23 8/2019, my lord.
Yes.
Second para, your lordship, ಮೇಲ್ಕಂಡ ಕಾಲೇಜಿನಲ್ಲಿ 85-86 ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದು ಅಗತ್ಯ ವಿದ್ಯಾರ್ಥಿ ಹೊಂದಿದ್ದ ಎಲ್ಲಾ ಬೋಧಕ ಮತ್ತು ಬೋಧಕೇತರ ವರ್ಗದವರ ನೇಮಕಾತಿಗಳು ಅನುಮೋದಿಸಲಾಗಿದ್ದು ಈ ನಿರ್ದೇಶನಾಲಯ ದಿನಾಂಕ 9/3/90 ಪತ್ರಾರ್ಜಿ ಖಂಡಿಕೆಯ 1ನೇ ಉಪಖಂಡಿಕೆಯಲ್ಲಿ ತಿಳಿಸಿರುವ ಕಾರಣಗಳಿಂದ ಪಟ್ಟಣಕರವರ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದಿಸಿರುವುದಿಲ್ಲ. ದಿನಾಂಕ 8/8/90 ಈ ನಿರ್ದೇಶನಾಲಯದ ಪತ್ರದಲ್ಲಿ ವಿವರಿಸಿರುವ ಮತ್ತು ಪ್ರಸ್ತುತ ಪತ್ರದಲ್ಲಿ ವಿವರಿಸಿರುವ ಕಾರಣಗಳಿಂದಾಗಿ ಪಟ್ಟಣಕರವರ ನೇಮಕಾತಿಯನ್ನು ವಿಶೇಷ ಸಂದರ್ಭವೆಂದು ಪರಿಗಣಿಸಿ ಸರ್ಕಾರದ ಅನುಮೋದನೆಯನ್ನು ಕಳುಹಿಸುವಂತೆ ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಕೋರಿರುತ್ತೇನೆ. ದಿಸ್ ಈಸ್ ದ ಡೈರೆಕ್ಟರ್ ಆಫ್.
ಇದಕ್ಕೆ ಅನುಮೋದಿಸಿರುವುದಿಲ್ಲ ಅಂತ ಏನಕ್ಕದು?
ಅಪ್ರೂವಲ್ ಮೇಲಾಡ್.
ಅಲ್ಲ, 9/3/1990 ಪತ್ರದ 1ನೇ ಖಂಡಿಕೆಯ 4ನೇ ಉಪಖಂಡಿಕೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಕಾರಣಗಳಿಂದ.
ಅದೇ ಸರ್.
ಎಲ್ಲಿದೆ ಕಾರಣ ಅದು?
ಕಾರಣ I don't have that in my possession, my lord. He recommends, and my lord, your lordship may also kindly peruse Annexure F, my lord. Ink page 29. Second para, my lord. Sir, when he joined his this college, there was no PG courses in sugar technology, but only PG diplomas were available. Further, there was no stipulated guidelines of qualification requirements from the university, especially in the new subject like sugar technology, which has been introduced first time in this university. He is the only staff members in the university working at UG level, as no other college introduced this course. Last paragraph, my lord. Lastly, the Kalaburagi University wide letter dated 22/1/2009 has given equivalency to the PG diploma course in sugar technology as a postgraduate qualification, and hence his appointment may please be approved in the grant in aid. And my lord, my humble submission, there is little delay on his part, my lord. He is the victim of the compelling circumstances, my lord. He has a son, and they, after marriage, they disowned him, my lord, the son, and he underwent bypass surgery for his heart disease, my lord. And his wife also underwent cancer, my lord. She is undergoing and she is taking treatment for her cancer, my lord. That is also I have produced before your lordship. My humble submission before your lordship is, he has rendered unblemished service, and even in spite of that, my lord, they are not covering him, and pension is not granted. And that apart, my lord, your lordship may also kindly take it.
ಅಪ್ರೂವ್ ಆಗಿಲ್ಲ, ಇದು ಸ್ಯಾಲರಿ ಗ್ರಾಂಟಿಗೆ ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಲ್ಲ?
Adhe sir, my humble submission, my lord, there has been recommendation, and it is a unique case, my lord. And your lordship may kindly peruse the statement of objections filed by the government. At one stage, they say, my lord, there is delay. Bandes. Ink page, statement of objections, my lord. Bandes. Insofar as he working is concerned, my lord, there is no dispute. Para 26, my lord, internal page 10 of statement of objections.
ಎಲ್ಲಿದೆ ಸ್ಟೇಟ್ಮೆಂಟ್?
Here, my lord, in page 26, it is submitted that the Kalaburagi University in its communication dated so-and-so has stated to the principal of 5th respondent institution that the petitioner may continue to teach sugar technology to undergraduate course for the time being, and 2 decades later, the same university has addressed one more letter to the principal of the respondent 5 institution on so-and-so, wherein they have stated that the PG diploma course in sugar technology is equivalent to postgraduate, and hence he is eligible to teach the same. As per university, he might have been eligible to teach, but as per the government norms, orders, he was not eligible to teach since he does not possess the post-graduation in sugar technology, that is MSc in sugar technology. 27th para, my lord, it is relevant. It is submitted that the petitioner categorically admits that there was correspondence between the college authorities and the government department regarding approval of his appointment with government grants. Once he knew this fact, he should have waited for some reasonable time and thereafter should have approached this honorable court seeking a direction to take a decision with regard to approval of his appointment, which he has utterly failed to do so. They are admitting he should not have approached. They say at one stage, they say, my lord, that belatedly have approached. And at another stage, they say, my lord, that he should have waited. My humble submission, my lord, at the time of appointment, I did not play any fraud or I have not made any misrepresentation. Under similar circumstances, my lord, they have relied one decision, my lord, which is not applicable to the case in hand. In decision which they have submitted is last like either, my lord, there is no pagination for that. Your lordship. Last operative portion, may I? Para 9, my lord.
Of what? 9 of?
Judgment which they have referred me. In the statement of objections, they have annexed one judgment of this honorable court, division bench judgment, my lord. The lordship got it. Otherly, my lord, para 9, we have perused the papers. Apparently, it is no doubt true that the notification which is issued by the university dated so-and-so gives an impression that post-PG in biotechnology is equivalent to MPhil. But the university itself has clarified the same pursuant to its communication dated 28/1/2008, indicating that the said equivalence is only for the purpose of pursuing higher studies and not for securing job. Indeed, it is the equivalent qualification means a qualification notified by the government to be equivalent so-and-so. Lastly, my lord, para 12, the notification on which reliance is placed by Mr. Naik, a learned senior counsel, to submit that the biotechnology is equivalent to MPhil cannot be accepted in as much as pursuant to the subsequent notification, the same is clarified, indicating that it is only for the purpose of pursuing higher studies and not for securing a job. Hence, we are of the view that the orders passed by the tribunal does not warrant interference. My humble submission before your lordship is, I am neither seeking job nor getting employment on the basis of that it is equivalent, my lord. What they have said, the university itself has admitted that, my lord, that it is equivalent, and there was no such degree surrounding this area, my lord. It is for that reason they appointed and they clarified that I am eligible for that exemption. And, my lord, under similar circumstances, this honorable court were pleased to hold, my lord. May I pass on?
Please hold.
Para 10, my lord. A perusal, para 10, my lord. A perusal of the statement produced by the respondent shows that the service rendered by the petitioners varies from 10 months to 17 years. That being so, it is perhaps too late for the respondents to argue that those who have given the best part of their lives to the institution can still be treated as improperly appointed even after such long service rendered by them, only because their initial appointment was defective by reason of their not possessing the prescribed qualification. The respondents have not placed on record the copies of appointment orders issued in favor of the petitioners, nor is it their case that any one of them is on probation or has been appointed subject to his or her producing evidence regarding the requisite qualification. It is also not their case that the appointments made were on contractual basis or for a limited period. It is therefore safe to assume that the appointments made by the respondents were regular and meant to continue till those appointed retired on superannuation. The version of the respondents that the appointments in question were made on humanitarian grounds does not make any material difference for whatever may have been the reasons underlying the appointments. The fact remains that those appointments have continued working, those appointed have continued working as employees of the respondents and have been discharging the functions attached to the post against which they were appointed. Having taken the petitioners in their employment and having utilized their services in connection with the institution run and managed by the society, it is not open to either society or the institution to oppose the grant of pay scales legitimately admissible to those employees. It is indeed unfortunate that despite statutory provision to that effect, the respondents have somehow continued the non-teaching staff on payment of consolidated salary for years together. The fact that the petitioners are not given any increments or so and so, they reiterate there, my lord. My humble submission, my lord, there is nothing on record or suggest, my lord, that I have played any misrepresentation, I have made any misrepresentation or played fraud against the management, my lord.
Which is the provision which says that PG is the required qualification? The petitioner, you hold PG diploma.
How, sir? No,
The PG
diploma, my lord. Diploma still.
The PG diploma.
Hello, sir.
You
Diploma in sugar technology, my lord. That is as per their own letter, my lord.
Don't even have a PG diploma.
No, my lord. PG diploma is there, my lord.
Ah.
Diploma is not equivalent to PG anta ಇದೆ.
But please come to your certificate that you relied upon. Certificate issued by the university. Page annexure D.
D, my lord.
Ah.
D, one. Yes, my lord.
What the-
PG diploma. With reference to the above cited subject as per the certificate issued by the Government Polytechnic Kolhapur, PG diploma course in sugar technology is equivalent to post qualification, and hence the appointment of B.S. Patankar, lecturer in sugar technology, may be considered for the said post and is eligible to teach course in sugar technology at our college.
What is PG diploma?
After the BSc graduation, my lord,
Ah.
PG, that is, if he does MD, MS, the 2 years course will be there, my lord, for graduate holders. My lord.
What is your qualification? Where is your qualification?
I am diploma holder, my lord. I am diploma holder. That is not in dispute.
No, what is it? Is there any difference between PG diploma and diploma? Huh?
There is no difference, my lord. The only difference, the respondent are alleging that I am not the holder of MSc in
That's okay. Now there's some letter issued by the university
house.
which says PG diploma is equivalent to postgraduate qualification. So what, madam? PG diploma, thank you. What is the meaning of PG diploma? Post-graduation. Post-graduation.
After BSc has made, I am lacking the proper instruction, my lord. He is undergoing the treatment and his wife is also on bed.
You are not
Yes.
under any disability.
True, my lord. Post-graduation.
Post-graduation, but you don't have a post-graduation.
I do have, my lord.
You said diploma.
MSc illa, sir. MSc illa.
You said diploma.
Diploma is there.
Where is post-graduate diploma illiದೆ ನಿಮ್ಮದು? MSc ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ.
MSc ಮಾಡಿಲ್ಲ, sir. MSc ಮಾಡಿ.
ಬರೀ diploma ನಿಮ್ದು.
Diploma.
So therefore, diploma is different from postgraduate diploma. You said just now that both are same.
ಅಲ್ಲ, ಅವ್ರ ಲೆಟರ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು ಸರ್.
ನಿಮ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಏನ್ ಹೇಳಿ ಸರ್?
ಒಂದ್ ನಿಮಿಷ.
ಡಿಪ್ಲೊಮಾ ಅಂದ್ಮೇಲೆ 2 ವರ್ಷ ಕೋರ್ಸ್ ಇರ್ತದೆ.
ಡಿಪ್ಲೊಮಾ ಆದ ನಂತರ ಮೇಲೆ ಒಂದ್ ನಿಮಿಷ.
Diploma 2 years course will be there. You don't have a PG diploma, you only have a diploma.
My lord, my humble submission, there wasn't their university the endorsement and their recommendation itself says, my lord, that it is an exceptional case. And earlier, my lord, your lordship may kindly take judicial notice of certain facts, my lord, that when homeopathic, Ayurvedic, Unani, etc., they were introduced, my lord, there were only diploma holders. They even were teaching PG students, my lord. Persons who are holders of diploma course, my lord, they were teaching. And my lord, I have been entrusted with the work of teaching throughout my career, my lord.
Right, too. For teaching, there will not be a problem, but for you to claim grant in aid, this is a problem.
ಅದರಲ್ಲಿ ಅದೇ ಹೇಳ್ತಾರಲ್ಲ ಸರ್, ಅವರೇ ಡೈರೆಕ್ಟರ್ ಆಸ್ ಎ ಇಂಕ್ ಪೇಜ್ 26, my lord, annexure E. They themselves say, my lord.
Yes.
ಪಟ್ಟಣಕರ್ ಅವರ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದಿಸಿದ್ದರಿಂದ ದಿನಾಂಕ 9/3/90 ಈ ನಿರ್ದೇಶನದ ಪತ್ರದಲ್ಲಿ ವಿವರಿಸಿದ ಮತ್ತು ಪ್ರಸ್ತುತ ಪತ್ರದಲ್ಲಿ ವಿವರಿಸಿರುವ ಕಾರಣಗಳಿಂದಾಗಿ ಪಟ್ಟಣಕರ್ ಅವರ ನೇಮಕಾತಿಯನ್ನು ವಿಶೇಷ ಸಂದರ್ಭವೆಂದು ಪರಿಗಣಿಸಿ ಸರ್ಕಾರದ ಅನುಮೋದನೆಯನ್ನು ಕಳಿಸುವಂತೆ ಈ ಮೂಲಕ ತಮ್ಮನ್ನು ಕೋರಿರುತ್ತೇನೆ.
ಆಯ್ತು. 90 ಇಸ್ವಿಯಿಂದ ಏನ್ ಮಾಡ್ತಿದ್ರಿ?
ಅಲ್ಲ ಸರ್, I have been making several representations, my lord. Your lordship may kindly peruse Annexure F 2011.
When did you retire?
14, my lord, 41 years.
When did you attain the age of superannuation?
ಆಮೇಲೆ ಮತ್ತೆ they continued me for 2 more years, my lord.
When
That
did
is in the year 2014, my lord, I
Did
retired.
you attain the age of superannuation?
2014.
When did you file the writ petition?
Endri?
21/5/2012. After 7 years.
12. 2 years I was continued for extra.
Retirement ಯಾವಾಗ ಆಗಿದ್ದು?
Retirement 2012, my lord.
ಮತ್ತೆ ನೀವು
I beg your pardon. I was continued. I was given extension for 2 more years.
grant need ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
ಇಲ್ಲ.
So therefore, what were you doing from 2012 till 2021?
ಅಲ್ಲ ಅದೇ ಹೇಳ್ತೀನಿ. I have been making representation. Your lordship may kindly have a glance on the
2012 ಆದ್ಮೇಲೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ 2012 ಆದ್ಮೇಲೆ I underwent the 2011, 12, 14, 12 ವರೆಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ, 11 ವರೆಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಮೇಲೋಡ್. Representations I was giving. And my lord, I was ailing from heart disease, my lord. And I underwent that bypass surgery. I have produced that for your lordship's consideration, my lord.
Yes. Yes, who is the answering respondent?
Government, my lord.
In this case, my lord, the initial appointment in the year 1983, my lord. So now the superannuation date is in the year 2012, my lord. So the appointment of the petitioner is not approved by the competent authority, that is the government. So under such circumstances, my lord, the institution, whether the institution has obtained the approval from filling up the post and granting it to the said
The
post.
appointment itself is not approved.
No, my lord.
Approve ಆಗಿಲ್ಲ.
No, my lord. In the kindly peruse in page number, in their recommendation letter, Annexure G, in page number 24, Annexure G. So kindly turn to in page number 27. It is the letter of the very petitioner. The
Director.
in page number 27.
27.
Please.
27
27 ಅಲ್ಲಿ ಟೇಬಲರ್ ಕಾಲಮ್ ಆದ ತಕ್ಷಣ ಕೆಳಗೆ ಸ್ಟಾಪ್ ಅಪ್ರೂವ್ಡ್.
ಇಲ್ಲಪ್ಪ
But
ಇದೆ.
my lord, in page number 27, internal page number 5. Of
27
Annexure
of
G.
what?
Annexure G, my lord. Annexure G, internal page number 5. G.
ಯಾವ್ದ್ರಿ Annexure G?
G is the representation made by the.
Annexure G is a representation dated 14/2/2011.
Please, my lord.
ನಾನ್ ಮಾಡಿದ್ದು.
Wherein it is mentioned, my lord.
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
Internal page number 5.
5 ಅಲ್ಲ?
Yes, my lord.
ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
After tabular column, my lord, stop approved.
ಹಾ.
So 1 chemistry, 3 approved, physics 1, mathematics 2, botany 1, zoology 2, sugar teacher nil. The very post is not approved by the government.
ಏನ್ ಮಾಡೋದು ಹೇಳಿ?
I leave it to your lordship. Because my lord, my humble submission, my lord, he has been continued throughout.
No, that is
And,
okay.
and he had taught several students, they have come out with graduate certificates, my lord. They have gained the employment. I am the person who have rendered the service and unblemished service of more than 30 years, my lord.
Approval ಗೆ you might be right in being appointed. You might be right in appointed as a lecturer. But for you to claim approval, what does the government rules say?
ಅದೇ ಅವರೇ ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, they recommend, my lord, Annexure E
Special
ಅಲ್ಲಿ.
case ಅಂತ ಮಾಡಿದ್ರು, ಆಗ್ಲಿಲ್ಲ ಅದು.
It is ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ, my lord. Even
ಆಗಿಲ್ಲ. ಸ್ಪೆಷಲ್ ಕೇಸ್ ಅಂತ ಟ್ರೀಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಹೇಳಿದ್ರು, ಹೌದು ಸರ್.
ಏನೋ ಆಗ್ಲಿಲ್ಲ.
ಅಂದ್ರೆ ಇದರಲ್ಲೂ ಹೇಳ್ತಾರಲ್ಲ ಸರ್, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಕೂಡ what they say is he should have waited.
Yes.
He has immediately approached the honorable court.
You should have waited and come to the court immediately ಅಂತ ಅವ್ರು ಹೇಳೋದು.
ಅಲ್ಲಲ್ಲ ಸರ್, ಇಲ್ಲಿ
ಹಂಗೆ
ಇಲ್ಲ ಇಲ್ಲ
ಹೇಳೋದು.
ಇಲ್ಲ ತಾವ್ ನೋಡಿ ಸರ್, ತಾವ್ ದಯವಿಟ್ಟು
ಓದಿ
in page, internal page 27, paragraph.
ಓದಿ.
It is submitted that the petitioner categorically admits that there were correspondence between the college authorities and government department regarding approval of the appointment with government grants. Once he knew this fact, he should have waited for some reasonable time and thereafter should have approached
approached this court.
and waited for some reasonable time and thereafter should have approached this honorable court seeking for a direction.
90ನೇ ಇಸ್ವಿನಲ್ಲಿ ಲೆಟರ್ ಹೋಯ್ತು.
ಆಯ್ತು ಸರ್.
90ನೇ ಇಸ್ವಿಲಿ ಅವ್ರು ಏನೂ ತಗೊಂಡಿಲ್ಲ. ಸ್ವಲ್ಪ ದಿನ ಕಾಯ್ಬೇಕಾಗಿತ್ತು. ಆಮೇಲೆ ಕೋರ್ಟ್ ಓಡ್ ಬರ್ಬೇಕಾಗಿತ್ತು.
ಕೋರ್ಟಿಗೆ ಬರುವಾಗ insofar as, and now my humble submission, my lord, insofar as my claim is concerned, they are not denying it. What they are saying, he should have approached much earlier.
ಬರ್ಕೊಳ್ರಿ.
Much earlier.
The petitioner,
And without making it as a precedent, my lord, your lordship, my lord, I have rendered unblemished service and
sought for
under
writ in the
peculiar
nature
circumstances of the
mandamus.
case.
I sought for writ in the nature of mandamus to approve his appointment with a retrospective effect. That is from the date of his initial appointment and cover him under the government grant with all consequential benefits, including back wages, leave surrender encashment benefit, gratuity, pension, etc. Expira. The petitioner contends that he is a BSc graduate with a postgraduate in diploma in sugar analysis. He completed the said course in the year 1974. Full stop. He contends that the respondent number 5 had started a new course in sugar technology and a post of lecturer was notified. The petitioner applied against the said post and was appointed as lecturer in sugar technology by the order of appointment dated 15/11/1983. Full stop. The petitioner claims that from then on, he has been working sincerely, honestly, and to the fullest satisfaction of the respondent number 4 and 5, till he retired in the year 2012.
Sir.
12 or 14?
12 minutes.
The year
12 minutes.
2012.
He was continued for 2 more years.
Full stop. He contends that the respondent number 5 was covered under the government grant in the year 1985. Full stop. The respondent number 5 was under the control and supervision of the respondent number 3 university. And hence, there was a need for obtaining approval of the appointment of the petitioner and also to admit him for salary grant. Full stop. The respondent number 4 therefore made a representation to the respondent number 3 for appointing the appointment of the petitioner. Full stop. The respondent number 3 addressed a letter dated 11/8/89 to the respondent number 5 that pending decision by the academic council of the university, the arrangement of the university, the petitioner may continue as a lecturer in sugar technology at the respondent number 5. Full stop. The petitioner claims that from then on correspondences ensued between the respondents for the approval of his appointment. Full stop. The respondent number 5 is stated to have made several requests with the respondent number 1, 2, and 3 for the approval of the appointment of the petitioner and to admit him for salary grant. Full stop. Accordingly, the respondent number 3, by an order dated 22/1/2009, informed the respondent number 5 that PG diploma in sugar analysis in sugar technology is equivalent to the post of post-graduation, and hence the appointment of the petitioner as lecturer in sugar technology may be considered. Full stop. The petitioner contends that the Director of Higher Education had addressed a letter to the Commissioner and Principal Secretary to the Government of Karnataka that there are no master degree, postgraduate degree holders in sugar analysis, and therefore the qualification possessed by the petitioner could be treated as equivalent to PG course, and his appointment be approved as a special, and his appointment may be approved as a special category, as a special case. Full stop. Despite the recommendation made, the respondents purportedly did not implement their own recommendation, which compelled the petitioner to file representations dated 14/2/2001 before the respondent number 2 and 31/5/2012, respondent number 2. Full stop. In the meanwhile, the petitioner retired on 31/5/2012. The petitioner submits that even after his retirement, he was continued for a period of 2 years. However, he suffered a heart-related ailment and had to undergo bypass surgery on 16/11/2016. Full stop. He contends that since there was no response from the government, he once again submitted a letter dated 10/5/2017 to the respondent number 1, reiterating his earlier request and sought for pension and other service-related benefits. Full stop. He claimed that during October 2019, his wife was diagnosed with cancer, and thus his condition was precarious. Stop. The petitioner is therefore before this court seeking for a direction to the respondents to approve his appointment with retrospective effect and grant all consequential benefits. The learned senior counsel representing the petitioner submitted that the petitioner was the only candidate available to be appointed as lecturer in sugar technology at the respondent number 5. He submits that the respondent number, he submits that the Directorate of Collegiate Education had addressed a communication dated 23/8/1990 to the Commissioner and Secretary of the Department of Education that the petitioner is that the case of the petitioner could be treated as a special the appointment of the petitioner could be treated as a special case and could be sent for approval. Full stop. He contends that from the year 1990, the respondents did nothing. But on the other hand, the petitioner was, petitioner services were used for used as an examiner in the board of examiners on 27/11/2003. Full stop. He contends that except the petitioner, the contents that there are not many PG diploma holders in sugars technology, and therefore the respondents must have treated the case of the petitioner as a special case and must have approved the appointment of the petitioner. Per contra, the learned AGA has filed a statement of objections contending inter-alia that the post of lecturer has to be filled up by a candidate who possesses a postgraduate qualification in the concerned subject. He contends that the petitioner did not possess a postgraduate qualification in sugar technology, but only possessed a diploma in sugar technology. And therefore, he was not and therefore his appointment was not to be approved by the respondents. He contends that though the Directorate of Collegiate Education had recommended to treat the case of the petitioner as a special case, the petitioner slept over his rights from the year 1990 and did not compel the official respondents to treat his case as a special case for approval. It is also contended that the petitioner has come to this court after nearly 9 years from the date of his retirement, seeking for approval of his appointment from a retrospective date. Therefore, it is contended, for a full stop, further it is contended that the equivalence certificate issued by the university would not be sufficient for approving the appointment, but may be sufficient for appointing, but may be sufficient for teaching at the respondent number 5. In support of his contention, he is relied upon the judgment of a division bench of this court in WP number 9549 of 2009. Full stop. I consider the submissions of the learned counsel for the petitioner and the learned senior counsel for the petitioner and the learned AGA. The learned counsel for respondent number 4 and 5 supported the contentions of the learned AGA. Next paragraph. It is not in dispute that the petitioner possessed a diploma in sugar technology and was appointed as a lecturer in sugar technology by the respondent number 5, vide order dated 15/11/1983. Full stop. His services were governed by the service manual of the respondent number 4. Full stop. This appointment was on temporary basis, and the same came to be regularized by order dated 9/11/1985. However, his service conditions continued to be governed by the HKES Service Manual 1978. Full stop. The respondent number 3, in reply to a communication addressed by the respondent number 5, permitted the petitioner to teach sugar technology subject to undergraduate students of the respondent number 5, pending decision of the Academic Council of Gulbarga University. Full stop. It appears that from a communication dated 22/1/2009, comma, that is after nearly 20 years from the letter dated 11/8/1989, the respondent number 3 affirmed that the PG diploma course in sugar technology is equivalent to postgraduate qualification, and hence the appointment of the petitioner may be considered for the post. Full stop. However, in the meanwhile, a communication was addressed by the Directorate of Collegiate Education to the Commissioner of Education and Secretary, Department of Education, requesting it to treat the case of the petitioner as a special case for approval of his appointment. From the year 1990 till the year 2012, nothing much transpired. The petitioner, comma,
ಒಂದು ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದ್ದಾನೆ.
submitted a representation in the year 2011 to consider his case sympathetically, and the same status continued till the date of his retirement. Full stop. It is not in dispute that for the purposes of appointment of a lecturer in an aided institution, comma, a candidate must possess a post-graduation in the concerned discipline. Full stop. The petitioner admittedly did not possess the said qualification, but possessed a diploma which was not admittedly a sufficient qualification to be qualification for the post of a lecturer. Full stop. The petitioner, who has slept over his rights from the year 1990, and has approached this court in the year 2021, comma, cannot compel the respondents to approve his appointment, that too with retrospective effect from the date of his initial appointment. No doubt, this court has also all the sympathy for the petitioner, since there are not many experts in sugar technology, and ideally, the respondents must have treated the case of the petitioner as a special case and must have taken steps by imposing conditions upon him to obtain a post-graduation within a particular time. Full stop. Since that is not done, and since the petitioner is not, and since the petitioner does not possess the qualification, comma, this court cannot issue any mandamus to overcome a mandatory provision in law and direct the approval of the appointment of the petitioner. Full stop. In that way of the matter, this petition lacks merit and is dismissed.
Oblige. Date of approaching the honorable court.
ಬರ್ಬೇಕಾಗಿತ್ತು ನೀವು ಅವಾಗ ಏನೋ ಮಾಡಿದ್ರೆ ಏನೋ ಮಾಡ್ಬೋದಾಗಿತ್ತು. 31 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದ್ರಿ ಏನ್ ಮಾಡೋದು?
ಮಕ್ಕಳು they threw him and his wife out of.
ಏನ್ ಮಾಡ್ತೀರಿ?
At least from the date of pensionary benefits ಆದ್ರೂ ಸಿಗ್ತಿದೆ ಸರ್.
ಪೆನ್ಷನ್ ಬೇರೆ ಅಪ್ರೂವ್ ಆಗ್ಬೇಕು, ಅದು ಸ್ಯಾಲರಿ ಗ್ರಾಂಟ್ ಅದಾಗ್ಬೇಕು, ಅದೆಲ್ಲ ಕಷ್ಟ. ಸಾರಿ.
Oblige.
Raghuram Kadambi. Is it the same case?
My lord, no, my lord, this is a different matter. I'm led by senior counsel. My lord. Sorry, just a second.
Sorry, I'm appearing, my lord, in this matter. And my lordship had another matter before your lordship that was a different point. Now, my lord, what has transpired here? Of course, they have not filed a reply yet.
Lord, one kind submission. Lord, last occasion, my lord, I in fact made a submission that, my lord, I am about to file, my lord, on the instructions of my lords. Lord, a week's time, lord, I have received a parallel remarks. Any date, my lord, I will. Please. Any date, 28, 29, any date.
29th Agboda, if the court permits.
29th.
So grateful. Interim order may please be extended.
Interim order is extended to the next date.
Very good.
Please. Cancellation of registration of trade union. Prashant BK. Prashant BK. There is no representation for the petitioner. Hence, petition list on.
Next to appear for petitioner. My lord, petitioner was serving in the early department and he was retired from service. And during his tenure of service, my lord, a tentative pension was already fixed. And he was prosecuted under the Prevention of Corruption Act. And thereby he was convicted for the period of 1 year. And thereafter, my lord, that 1 year conviction order was challenged in the SLP. In the SLP, my lord, it was for rendering punishment, my lord, he was exempted.
Exonerated.
Exonerated. Now, after that, my lord, the respondent authority, they have.
SLP allow ita?
Please go.
SLP was allowed.
Yes, my lord. Allowed. And thereafter, my lord, the respondent authorities, they issued a notice as per Annex F, my lord.
SLP was dismissed.
Page 83.
He said allowed. Allowed, my lord, for example.
Annexure R1 with
Yes.
statement of objections.
He says SLP was allowed.
Exempted, my lord, that copy also.
Only exemption because it
Yes,
was
yes.
the time of admission.
Criminal
exemption was
petition number
granted.
so and so with
It was allowed to
exemption from
surrender.
surrendering.
ಹೌದ್ರಿ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ SLP ಕೇಸ್ ಹಾಕುವಾಗ ಸರೆಂಡರ್ ಆಗ್ಬೇಕಲ್ಲಿ ಸರೆಂಡರ್ ಆಗಿ ಸರೆಂಡರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಗ್ಬೇಕು. You're not exempted.
Exemption from surrendering is allowed and petitioner has been sentenced to undergo imprisonment for 1 year. Thereafter,
He was not exempted.
please.
Petition is dismissed, which means to say conviction is upheld.
Only in respect of surrenderance is not exempt.
Surrender. Yes. No. When there's an order of conviction.
Yes.
If you file a special leave petition to the Supreme Court,
Yes.
you should file a surrender certificate. You should surrender.
Please.
Yes,
I
yes.
hope
my
you
lord.
understand.
Yes,
That is
yes,
the
yes.
procedure in the Supreme Court.
Yes.
You should surrender, only then SLP criminal will be taken.
Yes.
Exemption ಹಾಕಿದ್ದಾರೆ from
For
surrendering.
surrendering, it was exempted. Yes.
That application is allowed.
Yes. Now, my grievance, my lord, after they issue a notice, I have submitted a reply, my lord, and that reply was not taken into account by the respondent number 6 who has passed the order. In the reply, my lord, I put forth the entire tenure of service rendered by the petitioner. My lord, he has rendered service about 37 years and odd months, my lord. And the
Ready ಇದೀರಾ ಇಲ್ವಾ? You ready?
yes,
Are you ready to address arguments?
cold ಇದು ಆಗಿದೆ.
ಹುಷಾರಿಲ್ವಾ? And counsel for the petitioner seeks time. It's list on. Publish, please. Matter pertains to regulation minutes.
Hmm.
This is also squarely covered by Nagendra judgment which I have produced in the morning.
Pardon?
Nagendra judgment minutes.
Ah.
In the morning I have produced. The respondent is veterinary university minutes. Here minutes, the only,
ಏನು ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕರೀಣ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ?
but idರಲ್ಲಿ
In the morning, we said all cases will be taken up together.
one submission I would like to make minutes. Lordship may kindly turn to the impugned order. Veterinary, I mean,
What is the impugned order?
ಆಗಿರ್ತಾರೆ. Minutes.
Annexure F.
Annexure G and G1, already they have considered minutes. On parity also I am entitled, and also the judgment of this honorable court. And one more thing is that, my lord, Annexure F, the endorsement which is given to me, my lords, at page number 48. May I read it, minutes?
Yes, please.
WP number so and so, the Honorable Court of Karnataka. Writ petition number 20190 of 2021 High Court of Karnataka at Kalaburagi, file dated 20th-9/2021. With reference to the above cited, subject cited above, this office is making following communication to the below addresses. Wide one stated Shri Sunil Kumar Shinde, son of Mohan Rao Shinde, age 41 years, petitioner, worked as non-teaching staff on contract basis. 179 days contract and continued under contract terms in constituent institutions of the Karnataka Veterinary Animal and Fishery Sciences University, approached Honorable Karnataka High Court at Kalaburagi, seeking direction to the university for consideration of regularizing his services. This office, on receipt of representation made by the petitioner in the light of the judgment passed in WP number 201903 of 2021, considered the representation and the Honorable Court disposing the case on 10/1/22 made the following order. Heard the learned counsel of the petitioner and the respondents. Having regard to the factual aspects of the case, the respondent university being in authority under Article 12 of the Constitution of India, it is a bounden duty of the respondent university to consider the representation dated 12/8/21. In that view of the matter, without expressing any opinion on the merits of the case, the writ petition is disposed of, directing the respondent university to consider the representation at Annexure D within 3 months from the date of the receipt of the certified copy of this order. This office, on receipt of the representation made by the petitioner in the light of the judgment passed, would like to submit that the government of Karnataka passed a legislation, wide reference 4, cited strictly prohibiting the absorption of the services of the employees of establishments in public sector into public services. The said act is squarely applicable to the KVA FSU, it being a state-funded university constituted by an act of Karnataka legislature. The university also took consideration of the date of filing of the writ petition in order to consider the determination of the claim available to the petitioner as on the date of the list. However, specific clause in the Karnataka State Civil Service prohibition of absorption of civil services of the employees of establishments in public sector into Public Service Act 2020, published in Gazette on 19/10/2020, specifically bars for such consideration. The section 311 and clause 2 of the Act 2020 reads as follows. No suit or other proceedings shall be instituted, maintained, or continued any court, tribunal, or any other authority against the government or any person or authority whatsoever for such absorption into public service. And no court shall enforce any decree or order directing such absorption into public service. Therefore, the provisions of the Act clearly indicate barring regulation and absorption of any employee working or worked or contract basis of KVSF. In the light of the legislation passed in Karnataka legislature, the Karnataka State Civil Services Prohibition of Absorption of Services Employees of Establishment in Public Sector into Public Service Act 2020, the request for regulation and absorption into the university service is completely prohibited. In this, when I had approached this honorable court, my lord, they had asked to consider the regulation, and they do not deny that I am working there, my lord. What they say is that, my lord, it doesn't fall within the purview of section 12 because they are public sector, and public sector, they are governed by 2020 Act, therefore it can't be. So this is highly illegal, my lord. This should not have been passed.
And also in the light of the judgment given in the morning, that is, I'll pass it on.
We'll take it up with other petitions, madam.
Because there, my lord, they have not given endorsement, not even considered. This is second round of litigation and
It's all
where
about
this is-
regularization.
And my lordship, I kindly see annexure G, G1, they have already regularized other employees also.
Right, but we'll take it up with other petitions. ಅದ್ಯಾವತ್ತಿದೆ ಅದು?
ಇಲ್ಲಿ. ಅದು date fix
This
ಆಗಿದೆ.
petition, list this petition on 5-2 along with WP numbers ನೋಡಿ ಇದ್ಯಾವುದು? ಬೆಳಿಗ್ಗೆ ಕೊಡಿ.
48. ಅದು 4, serial number 4. My kind request is that, my lords, similar petitions are pending, my lord. Many petitions are there.
ಅಲ್ಲ ಅದಕ್ಕೆ ಒಟ್ಟಿಗೆ
Take up
ಒಂದ್ಸತಿ
and dispose it off. Since so many years, they are knocking the third time they are coming.
I will dispose it off. I don't want
I understand.
conflicting judgments. I should not dismiss the petition. Somebody else should not allow it. So let there be uniformity is what I am trying to tell you.
Yes, my lords.
You give all the numbers, we'll take it up in one shot.
Today all were listed and today all were listed and coordinate bench judgment also I had given.
Correct, but
There
ನೀವು
is
ನೋಡಿ
no
ಇದೊಂದು 48 ಹೇಳಲೇ ಇಲ್ಲ ನೀವು ಬೆಳಿಗ್ಗೆ.
ಅಂದ್ರೆ ಇದು ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರಲ್ಲ.
ಇದು ರೆಗ್ಯುಲೈಸೇಷನ್
ಇದೆ ಬಟ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್
ಈ
ಕೊಟ್ಟು
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಮನೆ ಹಾಳಾಗೋಗ್ಲಿ ಮೇಡಮ್. ರೆಪ್ರೆಸೆಂಟೇಷನ್ ರೆಗ್ಯುಲೈಸೇಷನ್ ತಾನೇ ಇಶ್ಯೂ.
ಇದರಲ್ಲಿ
Forget the endorsement. Regularization is the issue. So it's all same.
it also could be
You should have said it in the morning that 48 is also the same.
could not relate.
Yes. Ravindra Reddy.
Your lordship,
Please,
on
Padilla.
last date of hearing, it was heard for short, my lord. Your lordship, please to direct us how the university will be falling under definition of industry and whether the employee, that is respondents, falling under the definition of workman. For that, my lord, to show that education institution is an industry,
Let him argue.
please.
This matter, my lord,
Huh?
I cite some judgments, ಸ್ವಲ್ಪ judgments are.
Next time
ಎಲ್ಲ
also,
Next
ಒಂದು ಬೆಳಿಗ್ಗೆಯಿಂದ ಒಂದು ಮಾಡಿಲ್ಲಪ್ಪ ಕೇಸ್ ಕೊಟ್ಟು.
ಅಲ್ಲ, ಸಾಯಂಕಾಲ ಆಯ್ತು ಅಂತ ಅಷ್ಟೇ.
last
No,
time
why-
also, my friend has taken time.
Huh?
Last time also. your
I'll
lordship-
file memo, my lord.
I don't want to say anything more.
Sorry.
Number 73, my lords. Serial number 73, my lords.
From serial number 35 B group ಶುರು ಆಯ್ತು. 35 to 49.
49, any date.
ಅಲ್ಲ 15 ಕೇಸಲ್ಲಿ ಒಂದೇ ಒಂದು ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕಾಗಿದೆ. 15 ಕೇಸಲ್ಲಿ ಐ ಕುಡ್ ಓನ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಓನ್ಲಿ ಒನ್ ಕೇಸ್. ಪ್ರತಿಯೊಂದಲ್ಲೂ
From my side, my lord, I have,
ಸರಿ ಬಟ್ ಏನ್
how, sir?
ಅಲ್ಲ,
15 ಕೇಸಲ್ಲಿ ಒಂದು ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರು ಬೆಳಿಗ್ಗೆ. ಫ್ರಮ್ 2:30 to 4:50 we have spent wastefully. ಒಂದು ಕೆಲಸನೂ ಆಗಿಲ್ಲ.
Nandano, ಅದೇ till 2 AM in the night and 25 matters, I had only one case.
ಕರೆಕ್ಟ್, ಬಟ್ ರೆಲೆವೆಂಟ್ ಪಾಯಿಂಟ್ಸ್ ಯಾರು ರೆಡಿಯಾಗಿ ಬರ್ತಿಲ್ವಲ್ಲ, ಏನ್ ಮಾಡೋದು? ಅಟ್ಲೀಸ್ಟ್ ನೀವನ್ನ ಓದ್ಕೊಂಬನ್ನಿ. ಐ ಆಲ್ಸೋ ಡೂ ಮೈ ಹೋಮ್ ವರ್ಕ್. Don't paint the impression that
No, my lord, I am the last person.
just like
No,
that.
no,
We also do some homework.
absolutely, we cannot have any kind of grievance.
Ah.
Even remotely also we cannot. What only I am trying to persuade your lordship, if one matter is heard, my lord, there will be disposal of 13 to 14. My friend is,
Sir, I am ready, but you are not ready. ಏನ್ ಮಾಡ್ತೀವಿ? Lawyers are not ready, what can
How?
we? List on ಯಾವತ್ತು?
one date may kindly be on, my lord, finally.
Whatever date you want, please come ready.
Serial number 73, my lords.
Let my friend, my lord, he is seeking,
ಆಯ್ತು, ಯಾವತ್ ಬೇಕು ಹೇಳಿ, ಯಾವತ್ ಬೇಕೋ ತಗೊಂಡು.
any day I am ready.
29.
29.
Finally, ಅಂತ ಹೇಳಿದ್ರೆ I will be in a position to mention, my lord.
Serial number 50, Amir Amraja.
Serial number 73, my lords.
ಒಂದು ಸ್ಯಾಟ್ ಡೇಟ್ ಕೊಡ್ರಿ ಸರ್.
Saturday.
ಡೇಟ್ ಕೊಡ್ರಿ.
Saturday ಅಂತ ಕೊಡ್ರಿ. 29th.
ಪ್ಲೀಸ್.
25th ಏನ್ ಮಾಡ್ತಿದೆ? 29th Saturday ವರ್ಕಿಂಗ್ ಇದೆಯಾ? 25th,
ಸರ್ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಸರ್.
ಶಾರ್ಟ್
ಶಾರ್ಟ್ ಡೇಟ್ ಸರ್.
ಆಯ್ತು 25th ಶನಿವಾರ.
ಪ್ಲೀಸ್
Sir, ನಮ್ದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ರವೀಂದ್ರ ರೆಡ್ಡಿ ಅವರು ಅದನ್ನು ಇಫ್ ಇಟ್ ಇಸ್
ಅವ್ರೇನೋ ಕೇಳ್ತಾ ಅವ್ರು ಯಾವತ್ತು ಬೇಕು ಕೇಳಿ. ನೆವರ್
I will inform.
29th
29th ಅಂದ್ರೆ sir, and when Saturday is working day, it may kindly be taken on that day.
Saturday is working, first is also working. So you people, whoever wants to decide, whoever wants to get their cases. Ready na? Ready? ಹೇಳ್ರಿ.
49, 25th ತಗೊಂಡ್ರೆ I will much of.
ನೋಡಿ ಅವ್ರನ್ನ ಕೇಳಿ. ಅವ್ರಿಗೆ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ ಬೇಕಾದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡ್ತೀನಿ. ಎಸ್ ಅಮೀರ್ ಹಮ್ಜಾ. Yes, what is that you are sought for? Annexure H.
No, sir.
ನಿಮ್ದು ಯಾವ ಪಂಚಾಯತಿ?
Sir?
ನಿಮ್ದು ಯಾವ ಪಂಚಾಯತಿ? ಯಾವ್ದು?
ಅಂಗನವಾಡಿ ವರ್ಕರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್.
ಯಾವ ಊರು? ಯಾವ ಊರು? ನವಬುರ್ಜ್.
ನವಬುರ್ಜ್ ಸರ್.
ಎಲ್ಲಿದೆ ಇದು?
ಗುರುಮಿಟ್ಕಲ್ ತಾಲೂಕು.
ಎಲ್ಲಿದೆ ಇದು?
ಗುರುಮಿಟ್ಕಲ್ ತಾಲೂಕು.
ಪೇಜ್ ನಂಬರ್.
Notification annexure A, page number 10, my lord.
ಹಾ. Yes, please.
Page number 17, my lord, annexure B. The notification issued by the CDPO for
Yes.
call form of the vacant post.
ನವಬುರ್ಜ್.
Navaburj, serial number 2, my lord.
ಹಾ.
My applicant was applied for, petitioner was applied for the same post. Page number 18, annexure C, my lord.
Annexure C.
C, my lord. Then after, as per annexure D, she was provisionally selected for the same post, my lord. Page number 27.
27, yes. 27 is ವಾಸಸ್ಥಳ ದೃಢೀಕರಣ ಪತ್ರ.
Annexure D, my lord.
ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆ ಪಟ್ಟಿ.
Yes,
ಜಮಲಮ್ಮ ತಂದೆ ಶಂಕರಪ್ಪ.
my lord.
ಹಾ.
Then after, as per annexure E, annexure H, my lord, without assigning any specific reasons, fresh notification was performed.
Please read annexure E ಓದಿ. Please read annexure E.
Yes, my lord.
ಓದಿ.
ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 5/2/2022ರಂದು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಯಡಿಯೂರವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಮತ್ತು ಸಹಾಯಕಿಯರ ಆಯ್ಕೆ ಸಮಿತಿಯಲ್ಲಿ ಗುರುಮಿಟ್ಕಲ್ ಶಿಶು ಅಭಿವೃದ್ಧಿ ಯೋಜನೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಖಾಲಿ ಇರುವ ನವಬುರ್ಜ್ ಮಿನಿ ಅಂಗನವಾಡಿ ಕೇಂದ್ರ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಸಲ್ಲಿಕೆಯಾದ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಶ್ರೀಮತಿ ಜಮಲಮ್ಮ ಇವರನ್ನು ತಾತ್ಕಾಲಿಕವಾಗಿ ನವಬುರ್ಜ್ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಗುರುತಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ತಾತ್ಕಾಲಿಕ ಆಯ್ಕೆಗೆ ಉಲ್ಲೇಖಿತ ಎರಡರಂತೆ ಶ್ರೀಮತಿ ನಾಗರತ್ನ ಗಂಡ ದಿವಂಗತ ನವೀನ್ ಕುಮಾರ್ ಮುಖಂ ಎಲೇರಿ ಇವರು, ಶ್ರೀಮತಿ ಜಮಲಮ್ಮ ಗಂಡ ಸಣ್ಣ ಹನುಮಂತ ಡ್ಯಾಮ್ನವರು ಇವರು ಸುಮಾರು 1 ವರ್ಷ ಹಿಂದೆ ಶ್ರೀ ಸಣ್ಣ ಹನುಮಂತ ಡ್ಯಾಮ್ನವ್ರ ಎಲೇರಿ ಗ್ರಾಮದ ಈತನನ್ನು ವಿವಾಹವಾಗಿದ್ದು ಮತ್ತು ಸರ್ಕಾರಿ ಪ್ರಾಥಮಿಕ ಶಾಲೆಯಲ್ಲಿ ಅತಿಥಿ ಶಿಕ್ಷಕಿಯಾಗಿದ್ದು ಇವರು ನವಬುರ್ಜ್ ನಿವಾಸಿಯಾಗಿರುವ ಬಗ್ಗೆ ತಪ್ಪು ಮಾಹಿತಿ ನೀಡುತ್ತಾರೆಂದು ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ ನವಬುರ್ಜ್ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ತಾತ್ಕಾಲಿಕ ಆಗಿರುವ ಜಮಲಮ್ಮ ಇವರ ವಾಸಸ್ಥಳದ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ವರದಿ ನೀಡಲು ಈ ಮೂಲಕ ಕೋರಲಾಗಿದೆ.
ಏನಾಯ್ತು ವರದಿ?
As per annexure F, my lord.
ಓದಿ.
ಪ್ಯಾರಾ ನಂಬರ್ 3. ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಕೊಂಕಲ್ ಇವರು ಈ ಕುರಿತು ಸ್ಥಾನಿಕ ವಿಚಾರಣೆ ಮಾಡಿ ಶ್ರೀಮತಿ ಜಮಲಮ್ಮ ಗಂಡ ಸಣ್ಣ ಹನುಮಂತ ಇವರು ನವಬುರ್ಜ್ ಗ್ರಾಮದ
ನಿವಾಸಿಯಾಗಿದ್ದು ವಾಸಸ್ಥಳ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ದಿನಾಂಕ ಈ ಪ್ರಮಾಣ ಪತ್ರ ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ವಾಸಸ್ಥಳ ನಕಲು ಪ್ರಮಾಣ ಪತ್ರ ಲಗತ್ತಿಸಿದೆ. ನಂತರ 3/1/2022 ಯಲೇರಿ ಗ್ರಾಮದ ಶ್ರೀ ಹನುಮಂತ ಇವರೊಂದಿಗೆ ವಿವಾಹವಾಗಿರುತ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸರ್.
ಬೇರೆ ಊರು ಇದೆಯಲ್ಲ
ಸರ್
ಯು ಹ್ಯಾವ್ ಬೀನ್ ಮ್ಯಾರಿಡ್ ಟು ಯಲೇರಿ.
ಯಲೇರಿ ಸರ್,
ಯಲೇರಿ ಎಲ್ಲಿರೋದು?
ಸೇಮ್ ತಾಲೂಕು ಸರ್,
ಸರ್
ಬಟ್ ಅಂದ್ರೆ ಬೇರೆ ಊರು ಆಗುತ್ತೆ ಸರ್.
ತಾಲೂಕ ಸೇಮೆ,
ಸರ್
ಊರು ಬೇರೆ.
ಊರು ಬೇರೆ ಆಗುತ್ತೆ.
ಎಷ್ಟು ದೂರ ಇದೆ? ಎಷ್ಟು ದೂರ ಇದೆ ಈ ಊರಿಗೆ?
ದೂರ ಎಷ್ಟಿದೆ ಸರ್ ಗೊತ್ತಿಲ್ಲ ಸರ್, ಕೇಳ್ತೀನಿ ಬೇಕು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಪ್ಲೀಸ್.
ಏನ್ ಸರ್, ನವಬುರ್ಜಾಗೂ ಮತ್ತೆ ಎಲೆರಿಗೂ ಎಷ್ಟು ದೂರ ಇದೆ? ನವಬುರ್ಜ ಮತ್ತು ಎಲೇರಿ,
ನವಬುರ್ಜ್
ಗುರುಮಿತ್ಕಲ್.
ನವಬುರ್ಜ್ ಬುರ್ಜ್ 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 ಬುರ್ಜ್
You're not residing in Navburja. ಇವಾಗ ನೀವು
ಇವಾಗ ರಿಸೈಡಿಂಗ್ ಮಾಡ್ತಾ ಇರೋದು ಅಲ್ಲಿ.
ಇವಾಗ
ಮ್ಯಾರೇಜ್ ಮಾತ್ರ ಅಲ್ಲಿ ಆಗಿದೆ ಸರ್, ಎಲ್ಲರಿವರಿಗೆ ಆಗಿದೆ. ಬಟ್ ಈಗ ಅಲ್ಲೇ
ಲಂಡನ್ ಬಿಟ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಬಂದು ಕೆಲಸ ಮಾಡ್ತೀರಾ? ನೀವು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದೀರಾ ನೋಡಿ ಇವಾಗ. ನೆಕ್ಸ್ಟ್ ಜಿ ಬನ್ನಿ ಪ್ಲೀಸ್, ಕಮ್ ಟು ಅನೆಕ್ಷರ್ ಜಿ. ನನ್ನ ಮದುವೆ ಯಲೇರಿ ಗ್ರಾಮದ ಹನುಮಂತ ತಂದೆ ಸಿದ್ದಪ್ಪರವರದೇ ಆಗಿದ್ದರೂ ಕೂಡ ನವಬುರ್ಜಾ ಗ್ರಾಮದಲ್ಲಿಯೇ ವಾಸವಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತೇನೆಂದು ಈ ಮೂಲಕ ನಾನು ಹೇಳ್ತಿದ್ದೀನಿ.
ಹೌದು ಸರ್, ಅಲ್ಲೇ ಇರ್ತೀನಿ ಅಂತಂದು ಇದು ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲೇ ಇರ್ತೀನಲ್ಲ, ನೀವಿರೋದು ಯಲೇರಿನಲ್ಲಿ. ಯು ಆರ್ ನಾಟ್ ಎ ರೆಸಿಡೆಂಟ್ ಆಫ್ ನವಬುರ್ಜಾ. ನೀವು ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ನವಬುರ್ಜದಲ್ಲಿ ವಾಸ ಇರ್ಬೇಕು ನೀವು.
ಹೌದು ಸರ್, ಅಲ್ಲೇ ವಾಸ ಇರ್ತೀನಿ.
ಈ ವಾಸ ಇವಾಗ ಇರ್ತೀರಿ ಅಲ್ಲ ಸರ್, ಗಂಡ ಅಲ್ಲಿದ್ದಾನೆ.
ಆಫ್ಟರ್ ಮ್ಯಾರೇಜ್ ಇಲ್ಲೇ ಕಂಟಿನ್ಯೂ ಆಗ್ತೀನಿ ಅಂತಂದು ಅವ್ರು ಬರೆದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಅದ್ರ ಸಲುವಾಗಿ
ಯು ಆರ್ ನಾಟ್ ಎಂಟೈಟಲ್ ಟು. ವಾಟ್ ಆರ್ ದ ಕಂಡೀಷನ್ಸ್?
ಅಲ್ಲಿಯವರೇ ಇರ್ಬೇಕು ಅಂತ,
ಆ ಊರಿನವ್ರು ಇರ್ಬೇಕು ಅಂತ.
ಆ ಊರಿನವ್ರು.
ಎಷ್ಟು ದೂರ ಇದೆಯಮ್ಮ ಮೇಡಮ್? ಎಷ್ಟು? ನವಬುರ್ಜಾ ಅಂಡ್ ಯಲೇರಿ 3.
ಸೇಮ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಇದೆ ಸರ್ ಯಲೇರಿ.
ಮತ್ತೆ ಇವ್ರು ಯಾರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರು, ಅವ್ರನ್ನೂ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನೀವು? ಯಾರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅವ್ರನ್ನೂ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ
ಸರ್? ಅಂದ್ರೆ ನಾವು ನೋಟಿಫಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೇವಲ್ಲ ಸರ್, ಅದ್ರ ಸಲುವಾಗಿ ಮಾಡಿದ್ದಿಲ್ಲ ಸರ್.
ಏನು ಸರ್ ನೀವೇನು? ನಾಗರತ್ನ ಗಂಡ ನವೀನ್ ಕುಮಾರ್ ಯಲೇರಿ. ಎಷ್ಟು ದೂರ? 3.1 kilometers. ಈ ನಾಗರತ್ನದೇನ್ರಿ? ಶಿ ಈಸ್ ಆಲ್ಸೋ ಯಲೇರಿ ಊರ್ನವರಲ್ಲ.
That notification was withdrawn. Fresh notification was issued on 3/8/2020, which is under challenge, annexure H. So that process
ಅದು
is.
ಪ್ರಾವಿಷನಲ್ ಸೆಲೆಕ್ಷನ್ ಲಿಸ್ಟ್ನೇ ಸ್ಟಾಪ್ ಮಾಡಿಸಿ.
Get a fresh residency certificate.
Yes, ma'am.
Fresh
Let them make
certificate
an application
apply
for
ಮಾಡ್ಕೊಳ್ಳಿ.
ಸರಿ ಸರಿ.
ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged a notification dated 3/8/2022 issued by the respondent number 4 inviting fresh applications to the post of Anganwadi worker at Navaburja village. The petitioner has also sought for writ in the nature of mandamus, directing the respondent number 4 to issue order of appointment to her. Next para. The petitioner contends that the respondent number 4 invited applications to the post of Anganwadi worker at Navaburja. Full stop. The petitioner was selected provisionally selected provisionally as the Anganwadi worker.
Yes.
Thereafter, a resident of Yeleri village submitted a complaint stating that the petitioner was given in marriage to a person named Hanumanta Dyamanora of Yeleri village, and that she was working as a guest teacher at a government primary school for more than a year. Full stop. Following the said complaint, the respondent number 5 addressed a communication dated 21/2/2022 to the Tahsildar, conduct an inspection about the residential status of the petitioner. Full stop. Following this, the Tahsildar submitted a reply dated 24/22 stating that the petitioner is not a resident of Navaburja, but is a resident of Yeleri after her marriage with Mr. Hanumanta Dyamanora. So the petitioner thereafter submitted a representation dated 4/6/2022 stating that even though she was given in marriage to a person who was residing at Yeleri village, she was ready to perform duties as an Anganwadi worker at Navaburja. Full stop. The respondent number 4 has thereafter issued the impugned notification dated 3/8/2022 inviting fresh applications for the post of Anganwadi worker at Navaburja. Being agreed with the said notification, the petitioner is before this court. Next para. The learned counsel for the petitioner submits that though the petitioner submits that the petitioner was a resident of Navaburja and was given in marriage to a person at Yeleri village. Also, it contends that Yeleri and Navaburja are adjacent villages, and therefore the petitioner can serve as an Anganwadi worker at Navaburja.
One submission, madam.
Full stop.
Page number 15, 3 kilometer ಒಳಗಿದ್ರೆ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಂತ ಇದೆ.
Full stop. 3 kilometer?
ಅಂತರದಲ್ಲಿ ಇದ್ರೆ. Page number 15, ಅಂಗನವಾಡಿ ರೋಮನ್ 6:7 ಅಂಗನವಾಡಿ ಸಹಾಯಕರನ್ನು ಕಾರ್ಯಕರ್ತೆಯರನ್ನಾಗಿ ಆಯ್ಕೆ ಮಾಡುವ ಬಗ್ಗೆ ಅಂಗನವಾಡಿ ಕೇಂದ್ರದಿಂದ 3 ಕಿಲೋಮೀಟರ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ವಾಸಿಸುತ್ತಿದ್ದರೆ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದಲ್ಲಿ ಆ ಅಂಗನವಾಡಿ ಕಾರ್ಯಕರ್ತೆ ಹುದ್ದೆಗೆ ಬೇರೆ ಅಭ್ಯರ್ಥಿಗಳಿಂದ ಅರ್ಜಿ ಆಹ್ವಾನಿಸುವ ಪ್ರಮೇಯ ಇರುವುದಿಲ್ಲ.
ಆಯ್ತು. At Navaburja. He also invited the attention of the court to clause sister.
Roman 7, my lord.
Clause 7 of the recruitment notification and contends that any applicant who is residing within 3 kilometers from the Anganwadi is entitled to submit an application. He therefore contends that the petitioner is entitled to be considered for the post of Anganwadi worker. Full stop. Per contra, the learned counsel for the learned AGA submits that the petitioner had failed to disclose she is not a resident of Nauburja, but was a resident of Yelleri village. It also contends that the petitioner was earlier employed as a guest teacher at government primary school, which also was not disclosed. Full stop. He contends that in qualification,
SSLC.
SLC. SSLC, no?
SSLC, ma'am.
Full stop. He therefore contends that the impugn notification issued is just and proper and it's not called for interference. Next para, I consider submissions of the learned counsel for the petitioner and the learned counsel for the respondent, learned AGA appearing for the respondents. Next para. The recruitment notification dated
earlier 9/12/2021.
just
9/12/2021.
9/12/2021. 23/9.
Subsequent 3/8/22.
20.
3/8/22.
ಇದರಲ್ಲಿ ಏನು ಕಂಡೀಷನ್ಸ್ ಇದೆ?
It's applicable to the same conditions. It is in recruitment guidelines, my lord.
The guidelines issued by the Department of guidelines issued by the respondent number 1
First.
for appointment to the post of Anganwadi worker shows that any person residing within 3 kilometers from the Anganwadi is entitled to apply to the post of Anganwadi worker. Full stop. The petitioner was appointed as an Anganwadi worker provisionally. Full stop. The respondent number 4 entertained a complaint of a stranger who alleged that the petitioner was not residing at Navaburja but was residing at Yelleri. And invited and held that the petitioner is not entitled to be appointed and invited a fresh notification. Issued a fresh notification, the impugn notification inviting suitable candidates, eligible candidates to the post of Anganwadi worker. The respondent number 4 was blissfully unaware of the guidelines prescribed by the respondent number 1. Full stop. The respondent number 4 must have ascertained the distance of Yelleri and Navaburja, distance between Yelleri and Navaburja, before holding that the petitioner is not entitled to apply to the post of Anganwadi worker at Navaburja. In that view of the matter, the impugn notification issued by the respondent number 4 inviting fresh applications to the post of Anganwadi worker at Navaburja deserves to be interfered with. Consequently, the same is quashed. The respondent number 4 is directed to secure information from the concerned Tahsildar as to the distance between Navaburja village and Yelleri. And if it is within 3 kilometers, as per the guidelines issued by the state government, the respondent number 4 shall issue appropriate appointment orders to the petitioner. Full stop. This shall be complied within 3 months from the date of receipt of a copy of this order. All other cases, some other.
73, my lords.
Serial number 56, my lord. The lordship may fix the date on 14/2, my lord, so that because the earlier counsel has retired from this case.
So take it preferably on a Sunday, Saturday.
14/2, because the chancellor of the university has expired. Some internal changes are there.
14/2, I may not be sitting.
Then your lordship may on 13/2 or 12/2.
12th.
Second week. 12th will be all right.
Whichever day.
Serial number 56.
All entry models will be extended.
Court officer. Court officer. Court officer, 65 serial number.
ಎಲ್ಲ ಸೀರಿಯಲ್ ವೈಸ್ ಕರಿತೀನಿ, ಎಲ್ಲ ಹೇಳ್ಬಿಡಿ.
ಹೇಳ್ಬಿಡಿ ಕರೆದ್ಬಿಡಿ.
ಒಂದ್ ನಿಮಿಷ. Okay, ನಾವು ಸೀರಿಯಲ್ ವೈಸ್ ಕರಿತೀವಿ.
62, 74.
Serial number 51.
Sir, next
Mali
week.
Patil PS.
Sir, next week.
51 next week ಕೊಡ್ರಿ sir, Friday 29th.
29.
Yes sir.
Number 52 Nitesh Padia. 52. ಹೇಳ್ರಿ sir. 29. Number 53. 53 ಎಷ್ಟು? 29. Number 54 ನಿಮ್ದೆ. ಇವತ್ತೆಲ್ಲ ನಿಮ್ದ ಕೋಟ್ ಐತ್ರಿ.
ನಮ್ ಟ್ರೈನ್ ಹೊಂಟದ ಸರ್.
ಒಂಚೂರು ಕೊಡಿ, ತೆಗೆದಿಲ್ಲ.
25 ನಿತೇಶ್ ಪಡಿಯಾ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
ಎಂಟ್ರಿ ಮಾಡ್ರ ಐತ್ರಿ.
Okay.
ಎಂಟ್ರಿ ಮಾಡ್ರ ಅಂತ. Date 29. Number 56 Mahesh Patil.
56, 29.
29 ರೀ.
29.
ಇಲ್ಲೇ ಇದ್ರಲ್ಲ. 56 ಕೇಳಿದ್ರಲ್ರ. 56 ಅವರು ಇದನ್ನ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್
Court officer 65. 65.
ಒಂದ್ ನಿಮಿಷ ನಿಂದ್ರಿ.
56 ಯಾವಾಗ ಕೊಟ್ರಿ?
12 to ಕೇಳ್ತದ್ರಿ.
77. 58.
57 ನಾಗರಾಜ್ ಪಾಟೀಲ್. 58 ಮಹೇಶ್ ಪಾಟೀಲ್. 29. Number 59 ರಾಥೋಡ್ ಸುಭಾಷ್ ಚಂದ್ರ. Number 60 ನಿತೇಶ್ ಪಡಿಯಾ.
ಕಾರಣ ಕೂತ್ಕೊಂಡ್ರೆ ಹಿಂಗ್ ಬರ್ತದೆ ನೋಡ್ರಿ. ಇದು ಮಾಡ್ಬಾರ್ದು.
61 ರಾಥೋಡ್. Number 62 ಉಲಿಯಪ್ಪ.
29. 29.
Number 63 DL Ladkan. 63 DL Ladkan. 64 Mahesh Patil. Sir, 64.
ಯಾವತ್ತಿದೆ?
Number 66 ಹರ್ಷವರ್ಧನ್ ಆರ್ ಮಾಲಿ ಪಾಟೀಲ್.
29, 30, 31 ಯಾವ್ದು?
65 ಸಮಯ. ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಯೂಟ್ಯೂಬರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹಾ
65 ಕೇಳಲಿಲ್ಲ.
65 ಬೆಳಗ್ಗೆನೆ ತಗೊಂಡಿದ್ದಾರೆ. 5:02 ನೋಡಿ.
5:02 ಇದೆಯಾ?
5:02 ಬೆಳಗ್ಗೆನೆ ತಗೊಂಡಿದ್ದಾರೆ.
ಹೌದಾ, ಸರಿ. ಓಕೆ. ಥ್ಯಾಂಕ್ ಯು.
67 ಜಯರಾಜ್ ಬುಕ್ಕ.
5:02 ಹಾಕೊಳ್ಳಿ. ಅದೇ ನಾವು ಇದಕ್ಕೋಗ್ತೀವಲ್ಲ.
3rd ಆದ್ಮೇಲೆ ಕೊಡಿ ಸರ್.
68
3rd ಆದ್ಮೇಲೆ.
3rd ಆದ್ಮೇಲೆ.
ಬೆಳಗ್ಗೆ ಅಮ್ಮ ಸಿಗ್ತೇನೆ. ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ. ಇಷ್ಟೊತ್ತಿಗೆ ನಾನು ಮನೇಲಿ ಇರ್ತಿದ್ದೆ.
71 ಮಾಂತೇಶ್ ಪಾಟೀಲ್. 72 ನಿತೇಶ್ ಪಡಿಯಾಳ್.
ಇದೆ
73 GN ನರಸಮ್ಮನವ್ರ.
ಸರ್, ಡೇಟ್ ಕೊಡ್ರಿ. ನಾವು
ಯಾವಾಗ ಹೇಳ್ರಿ?
28.
ಯಾವಾಗಾರ ಕೊಡಿ ಸರ್.
29
ಓಕೆ.
1
29.
1 74 ಹುಲಿಯಪ್ಪ ಇರೋರು. 75 ಹೇಮಾ ಎಲ್. ಎಂಟ್ರಿ ಮಾಡ್ರ. 52
ಸರ್.
2 weeks.
ಮ್ಯಾಲ ತಗೋರಿ, ಕೈದಾಗ ತಗೋತೀನಿ ಲೆಟರ್ ಹಾಕೋ.
76
ಇದು ಬಿರಾದರ ಸಾವ್ಕಾರ.
ಅವರು ಇಲ್ಲ ಅರ್ಜೆನ.
Good.
ಅವ್ರದ್ದು.
ಹಾ.
77
27 or 28 ಸರ್?
29
ಸರ್ 28 ಕೊಡಿ ಸರ್.
ಇಲ್ರಿ ಬರೋದಲ್ರಿ. ಇಲ್ಲಿ ಬರೋದು ಕ್ಲಾಸಿಫಿಕೇಶನ್ ವೈಸ್ ಬರೋದು.
ಅದೇ ಕರೆಕ್ಟ್ ಸರ್. ಟ್ಯೂಸ್ಡೇ ಐತಿ ಸರ್. ಟ್ಯೂಸ್ಡೇ ಇದ್ರೆ
sir.
28.
28, sir. ಇವತ್ತೂ ಅಂದ್ರೆ ಸರ್ ಇವತ್ತೂ
28. Entry ಮಾಡಿರ್ತೇನೆ. Entry ಮಾಡ್ರೈತೆ ಅಂತ ಮೇಡಮ್. Entry ಮಾಡಿದೆ.
ಮೇಡಮ್ ಎಂಟ್ರಿ
79.
ಮಾಡ್ರಿ ಮೇಡಮ್.
GG Chagashetty.
79. Next week. 29.
Simply 80 Arun Kumar Amar Gundappa. 81 Krupasagar Patil. 29. 80 Arjun. 81 Arjun. 82 Geeta. 86 Arjun Barmagoda.
ಹಾಕೊಳ್ಳಿ ಇರ್ಲಿ ಹಾಕೊಳ್ಳಿ ಅಲ್ಲಿ ಇರ್ಲಿ
Chagashetty.
ಅಲ್ಲ ಅಷ್ಟೇ ಇದು ಹಿಂಗ್ ನಡೀತಿರ್ತದ ಅದು ಕೋರ್ಟು ಈಗ ಅದನ್ನ ಆಫ್ ಮಾಡ್ತೀನಿ ಆಮೇಲೆ ಗಾಡಿ ನಿಲ್ಸ್ಬಿಟ್ಟು
Arjun.
ಆಫ್ ಮಾಡೋದು